All right. Thank you for tuning into the live show. You know what time it is. It is your boy Genesis. The time is currently 5:52 a.m. and today's date is the 1st of March 2025. How is your year going? It is the third month already. Okay, so whatever you're trying to do, get on doing it right now because time flies like a thief in the night. Okay, fast, really fast. You just never know. Call your loved ones, hug your family, kiss your wife, hug your kids. You just never know when it's going to be the last time. You know what I mean? So life is like that. All right. Right now, this morning, we're going to check out a judiciary update. Um, this is an adoption of the 119th Congress Authorization Oversight Plan. And it's a long hearing. Well, it's not a hearing. It's just like a oversight. Um, it is for I think about 6 hours. But anyway, I think it's on. Well, I don't think I know because I'm reading it right here. It's on how to protect our communities from DUI Act, the No Immigration Benefit for Hamas and Terrorist Act, and the No Censors on Our Shores Act, and adoption of the 119th Congress Authorization and Oversight Plan. It's a full committee markup. And yes, this is what we're going to do this morning. It's a little different from what we do, but they had very important issues to talk about. And what more do we do here? We learn and we share ideas and we talk about our opinions. So, with that being said, let's get straight to the show.
I thank the gentleman. Now recognize, pursuant to notice, I call up H.R. 1071, the No Censors on Our Shores Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1071 to provide
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the sponsor of the legislation, the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. When I came to Congress quite a few years ago, I was fortunate enough to serve on the Foreign Affairs Committee, and as a rookie under Chairman Henry Hyde, I learned a lot. One of them was, in fact, politics stops at the water's edge, meaning, of course, within the borders, we could be divided as Republicans and Democrats. But beyond our borders, we have to be united, and we historically have been. But times have changed. In some ways, that part is still true. What I mean by that is when a foreign nation chooses or causes the censorship or the denial of free speech or the First Amendment rights of an American through their policies abroad, America stands united. Hard to believe that, in fact, we as a nation, in the effort to export free speech and the ideas of freedom for more than 200 years, seemingly are slipping backwards. Right now, in Brazil, some of this legislation comes from that specific example, but also in the European Union, in the UK and Australia, in fact, censorship of American citizens' rights on public access media such as X and Meta have in fact been systematically censored. And in fact, the cause of this bill came from when Elon Musk refused to take, if you will, the demands of Brazil, and X was taken offline in an entire country. The fact is, we have seen censorship of what others want to have their free speech begin to happen. That means that America, expressing its own views in America or the views of freedom around the world, can no longer do that unless we stand up. So my bill seeks to simply say, Go ahead. Ignore the First Amendment in your own country. It's your right. Absolutely, you can. And if you want to, shut down X, Meta, Google, any of them you want. But don't expect to come to America under a U.S. visa. Don't expect to be in America and remain if, in fact, you are the perpetrator of that extinguishing of free speech. In short, we're not going beyond the water's edge. We do nothing to people abroad. But when you come on our shores, we stand united for the First Amendment. For that reason, this legislation very simply says that, in fact, denying the ability to remain here or to come here of someone who has participated in stifling free speech will, in fact, be the policy of our nation. For that reason, I want people to understand it's not whose speech was denied, it's that an American speech or an American organization speech was denied. We seek in no way to influence someone's overseas activity other than to say we do export our belief in free access of all. As a matter of fact, I just came back from the Middle East, where one of our greatest exports today is in fact helping Iranian dissidents circumvent the censorship that goes on in Iran so that there can be communication of those who object to that totalitarian regime. Would we cave to that? No. And we should not cave to somebody simply because they say they're a democracy, while in fact being a democracy except when it comes to American free speech. With that, Mr. Chairman, I yield back.
Gentleman yields back. Chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. I like Mr. Issa's bill. In fact, at first blush, it sounded like a great bill to me, protecting the First Amendment rights of our citizens against foreign dictators and autocrats on a rampage against the First Amendment rights of our people. And we know that there are a lot of those dictators and autocrats out there. I thought immediately of the Wall Street Journal reporter Evan Gershkovich, who was charged in Russia on completely bogus espionage charges and was sentenced to prison for 16 years simply because he offended Vladimir Putin with his coverage. And he was held for 1 year, 4 months, and 3 days before he was released in a prisoner exchange after a global protest. So it sounded to me like a good idea to protect Evan Gershkovich and other journalists today in a world filled with autocrats and political censors who always want to stifle people's speech in order to maintain their own grip on power. And like Mr. Issa, I grew up with the idea that partisan conflict stops at the water's edge. And if a foreign government takes one of our citizens, whether it's a journalist or a businessman or a traveler, unlawfully because they don't like what that person is saying or what that person is writing, then we must stand united as a country against them. And I spend a lot of time with the Tom Lantos Human Rights Commission trying to get both Americans and foreigners out of prison for doing nothing other than expressing themselves, reporting the news, or practicing their religion. And I invite colleagues who don't know about the work of the Tom Lantos Human Rights Commission, named after one of our former colleagues, to check it out, because you can really help get people out of prison in a situation like this. The problem is, when I read the fine print of the bill, I realized it wouldn't do anything for Evan Gershkovich, or indeed any other American journalist jailed by a foreign dictator, or any American citizen who was in prison for protesting some kind of government tyranny abroad. So the bill is written very narrowly. It would bar from admission to America foreign government officials who commit acts against a citizen who's within the United States that would violate the First Amendment. The genesis of this bill, I wasn't here when it was marked up last time. I think it may relate to a conflict between Elon Musk and a Supreme Court justice in Brazil. Maybe that's how it got started. But I would say that if we're going to do this, it shouldn't apply to one guy. Well, let's enlarge the principle so that it applies to any American whose First Amendment rights are being threatened or violated by a foreign state, a foreign autocrat. So I will be introducing an amendment to that effect. I would say, against both of us, someone might say, well, there are certain things our First Amendment protects that other countries don't protect. For example, the right under Buckley versus Vallejo and Citizens United, people have a right to spend to the heavens. In our campaign finance system, that might not be the law. In France or Brazil, I don't know if somebody should be banned permanently from our country for enforcing such a law, but that seems like a not as big a deal if we were actually going to use this legislation to protect our people against censors and tyrants abroad. So I'm interested in how Mr. Issa might react to such an amendment, and I thank you for the time, Mr. Chairman. I yield back.
Gentleman yields back without objection. All other opening statements will be included in the record. The chair now recognizes the gentleman from California for the for the purpose of offering an amendment in the nature of a substitute. The clerk will report.
The clerk will report.
Yep.
Amendment in the nature of a substitute to H.R. 1071, offered by Mr. Issa.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes the gentleman from California to explain the amendment.
Well, the amendment is technical in nature, but I want to take this opportunity to say that I appreciate the ranking member's amendment. Although I've just had a first blush at it, I would say that as long as the parliamentarians don't think it exceeds the authority of this committee, I'm certainly more than willing to incorporate. I think the gentleman's not having been here when it was marked up the last time, I just want to clarify that we did not do this for Elon Musk. The fact that X got shut down, Starlink accounts for business there got shut down, and it was done by a judicial a judge basically, was novel. But on a regular basis, we see this in similar ways in Europe, and all of these are democracies and different than the dictatorship of Putin. But I think the gentleman's point is good. That denying access to people who stifle free speech around the world certainly is a consistent pattern, and I personally have no objection to expanding it. I think, in fact, perhaps it's the best way to get beyond looking at one example or a series of examples. But I would say that there's a pattern that we're trying to brush back, and just the introduction of the bill last Congress had a positive effect on how Brazil looked at it. But we have a long way to go with the European Union, as the gentleman probably knows, and I'm a little tongue-in-cheek, but it's a crime to speak ill of the king in England. And we're okay with that, but if you're here and you're on X or some other social media and you speak ill of the king, one would think that they would respect the fact if you do it on British grounds, that's a different story. But when you do it and it simply spreads around the world and they choose to stifle it, I have no problem. If they choose to cut it off, that's fine. But I'm not going to let the officials who do it come to the United States, because a visa, and I think the gentleman would agree, a visa is in fact a privilege, not a right for people around the world. I would yield to the gentleman if he had any comments so we could be expeditious with this.
Yeah, that seems right to me. I suppose the question is the exercise of what we would consider free speech and free press rights in another society, and I would want to assert the universal right of the press to report the news, even in an autocratic society, even if it's against their laws. In other words, I think I want to adopt the spirit of this legislation to say if we've got reporters who are covering news in a foreign country, and then someone says, well, that's defamation of the king or the prince or whatever, that this legislation would cover a situation like that and say, no, you're going to be barred from America if you're imposing that kind of censorship on our reporters or our citizens.
Well, and I think it's important to note that in the markup in the last Congress, there was a question of, would this, for example, ban or bar the Pope from coming to the United States? And so that would be far too broad. It's not, we're not trying to say that debatable arguments that go on around the world are automatically barred. And so that's why it's, it is limited to foreign officials who, while serving as government officials in a foreign government, we tried to, in the amendment in the form of substitute, make sure that we made clear of that. So, but I do agree with the gentleman that, look, we're trying to be narrow in this. Adding your language doesn't seem to offend the narrowness that we are simply targeting the question. And by the way, I think the important thing is the administration has the ability to waive. It's not an outright bar that under no circumstances can, let's say, a head of state who is guilty of it be barred, that capability would still be there. Just as, and one of the best points that was made in the last Congress, delegates coming to the United Nations would not fall under that because their visas, by definition, are different. But I do think that we've come to common ground, and I hope that we, if there's any additional amendments, that we can be equally open to them. And with that, I yield back, Mr. Chairman.
Gentleman yields back. Who seeks recognition? The gentleman from New York is recognized.
Thank you. I have a question for the sponsor, for Mr. Issa. I was just wondering, are we going to have due process for people to whom we're going to deny a visa? In other words, we say they did some prohibited conduct. They say they didn't. Are we going to have some sort of judicial process to decide that?
If the gentleman would yield,
I would.
In my years on foreign affairs, in addition to obviously immigration here, I've learned a kind of an interesting anomaly. The answer is no, sir. There isn't due process for non-U.S. persons seeking to come to the United States. There is administrative process. It's a little bit of a black hole at Foggy Bottom and at the Department of Homeland Security and so on. Because people, and I'm sure the gentleman from New York knows that, you know, we do casework on people who say I wasn't let in and how, or, you know, and just as global entry and all these others. The fact is that because it's not a right but a privilege, people routinely get told yes or no. Most often they get told no because of the, quote, likelihood of returning. In other words, they'll overstay. But they don't get told that even when that's the case. And in my casework over the years as a member of Foreign Affairs, sometimes you have to sit down and go, come on, wink twice if that's the reason. So this is one of those cases in which the refusal would, in fact, give them an opportunity to bring forth some sort of an argument because they would be told that they were being refused on these grounds. So in some ways, it's more transparent than the general visa application. But I appreciate the question.
I thank the gentleman, and I yield back.
Would the gentleman yield? Would the gentleman yield?
Yes.
Thank you. I just wanted to affirm what Mr. Issa said, that in a case where somebody's applying, that is an administrative process to deny. The only concern I would raise is that this bill also has some deportability standards, and that is for somebody who is in the country. And so that part, I completely agree. Having been through the process many times and worried about whether I was going to be denied a visa to come to this country, I know what that administrative process is. But the part around deportability is actually something where we would apply, or the question, the Mr. Nadler's question would apply in terms of due process.
And if the gentleman from New York could further yield, the gentlelady's right that the revocation of a visa leading to deportation is, in fact, a process that has a little bit more access because before someone leaves, they can, in fact, file. And to be honest, they're in the U.S., they can even go to the court and file. So there is some more due process once you cross the water's edge. We put that in simply because it is certainly possible that we'll find people who are here who have these past activities. I think back to, as a Clevelander, a person who turned out to be one of the prison guards in the Holocaust, who literally was found years later, had been here for a very long time. They went through revocation of his citizenship. They went through the whole process and then deported him. It took years.
Yeah.
In this case, we would suspect that it would be rare that somebody would be here under a green card and we'd found out that they were alleged to have stifled free speech. But the gentlelady's right. There would be due process in that case.
And so this wouldn't be just somebody accused. They would have access to the full, because a lot of the bills that we've been debating on the floor, as you well know, take a standard that is already the case, making somebody deportable, for example, for a violent crime that they've been convicted of, and expands it to essentially say that if you're just accused of that crime, then you're deportable.
Well, exactly.
So what standard would apply in this?
Well, the standard, for better or worse, is the revocation of a visa. The visas have a limited time anyway. But I'll give you an example that I see regularly is people who are here who overstay. Most of them, when faced with you've overstayed, get out of here, leave. But the fact is some appeal, and there is a due process. Nothing in this bill changes that. You know, the only difference between being overseas and being here is when you're overseas, you don't have access to any federal court or any, you know, ability to adjudicate any other way. Once you're on U.S. soil, you do have those rights. So, but the gentlelady is absolutely right to be concerned, and we're not changing any of those standards.
Well, and hopefully the gentleman would speak up on some of these bills when we do change the standard, because I think it is essential on U.S. soil that we continue to have the due process that's so important.
And I agree with the gentlelady that people who were at one point lawfully in the country deserve full access to the courts if someone wants to change their status. And I couldn't agree with the gentlelady more.
Thank you. I yield back to the gentleman.
Thank you. I yield back.
Gentleman yields back. We're having some discussion up here with ranking member on the potential amendment. Who seeks recognition on the gentleman from Tennessee is recognized.
Mr. Issa, if you would yield.
I don't have any time.
Yeah, I was just curious.
Yes, of course.
The king. Which king are you referring to?
Well, in this case, the King of England.
Not Elvis Presley.
You know, I happen to think that people disparage the King, Elvis, at their own peril, but there's no law protecting him. But I would certainly never disparage the King from Memphis.
Well, he is our king.
He is your king. Our king. The king.
Who wants to follow that? The gentleman from Washington is recognized.
Thank you, Mr. Chair. I just want to lend my support to this fine bill, and very proud to be a co-sponsor. You know, free speech is under attack across the globe, and this measure sends a clear signal that America's not going to stand for it, and we're certainly not going to stand for it with American citizens. I'd also point out that, you know, Congress, with the Magnitsky Act, you know, has stood up previously for abuses of human rights and sanctioned foreign actors when those have been under attack, and what is a greater human right than the ability to speak freely? So I applaud the prime sponsor, and I'm very pleased to be a co-sponsor, and urge the members here to support this important piece of legislation. Thank you. Yield back.
Gentleman yields back.
Mr. Chairman.
Ranking member is recognized.
I would like to introduce an amendment. I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the
Without
nature of a
objection, the amendment will be considered as read. The gentleman from Maryland is recognized to explain his amendment.
Thank you kindly, Mr. Chairman. The amendment extends the consequences in this bill to any official abroad who participates in the pretextual detention, arrest, prosecution, incarceration, execution, or murder of U.S. citizens who are just exercising their First Amendment rights abroad. The notable example and the genesis for this idea on my part is American journalist Evan Gershkovich, who Vladimir Putin jailed on trumped-up charges of espionage because he didn't like what Gershkovich had printed about him in the Wall Street Journal. Another example is the American-Russian journalist Alsu Krumasheva, who was sentenced to 6.5 years for pretextual charges of spreading fake news about the Russian army. Fortunately, both these journalists were brought home to America in a prisoner exchange in the last administration. Their convictions were nonetheless absurd, completely pretextual, and clear attempts to silence the speech of Americans who dared to write ill of what was taking place in Russia. Many journalists have been jailed under false pretenses in countries like Russia, China, Iran, and North Korea because they dared to criticize authoritarianism there. So, but the theory of this amendment is just that if we're going to stand up for free speech around the world, as we should, it should start with the people who are actually jailing our citizens who are reporters or who are just being incarcerated for speaking up. I take it, I hope it's consistent with the spirit of Mr. Issa's legislation. Some people are now raising constitutional questions about the whole thing. And I guess my first instinct is Mr. Issa's instinct. I'm not sure that it's a First Amendment issue since we're talking about admission to the country, which isn't a constitutional right. But I want to hear my colleagues on that question. Obviously, we don't want to pass legislation that's unconstitutional. But in any event, I do advance my amendment, and I appreciate what Mr. Issa has said, which is he sees this as a narrow addition to his original plan. And with that, I yield back.
Before the gentleman yields back, could you yield? Here's what I think would be best for this, and it's in the tradition that we would agree not to move this to the floor without the inclusion of the basic premise of this amendment. Our parliamentarians, everyone has the same potential concern, which is we want to make sure that it's crafted so that it still keeps the basic premise, which is U.S. persons, whether through social media or others, including the Wall Street Journal and so on, their actions are their First Amendment right. Any abridgment of that right, which would include taking down their speech, it would also include incarcerating them. It would include any actions that either abridges their rights or liberties or would stifle free speech by that action. You know, Putin doesn't lock that guy up because of him. He locks it up because of 100 others that might do the same that won't do it. So I believe we can very easily find, and perhaps by the end of today, the narrow language, which is not much different than this. We do have the concern that we don't want to have somebody say that, you know, some hypothetical scenario. But I think I'm 100% supportive that to incarcerate somebody is abridging their First Amendment rights when it's for what was in the Wall Street Journal. And I think we can easily do that. And again, as long as the narrow response is we deny them the visa or revoke a visa, then I think it stays well within the limitation of the bill. And for the ranking member, we did this narrowly because we just want to brush back bad behavior. I have to tell you, I don't think it'll stop Putin one bit, but it certainly will tell our allies that we are, believe it strongly, and that policy should be taken seriously by everyone who wants to come to the United States, including those who might work as henchmen of people like Putin.
Gotcha. If you don't mind yielding to a question from me, Mr. Issa, or a couple that have been raised with me as I've gone off in this new direction here. One is the question of adjudication of the question of whether someone has violated the First Amendment rights of an American. In other words, who is that someone at the consular office in a foreign country that will say, we're going to deny you a visa because you've engaged in action? Is it the State Department?
And I think it's not complicated because we're not changing a complicated system. Mm-hmm. The complicated system is, yes, there are a number of people in the process, starting with a fairly junior person at the desk sometimes interviewing who feels that they're being lied to. It then goes back to the background checks, which include, for example, allegations of money laundering, allegations of drug dealing, allegations. All of those are pretty opaque. And it's been part of our process for many, many, many decades. Mm-hmm. And when I worked with Henry Hyde, he was both chairman of Judiciary and then chairman of Foreign Affairs. And he preserved that system as the chairman of Foreign Affairs after 9/11 because it was more likely to be fair to foreigners using foreign affairs people as the first line. But I will tell you, if you're denied, you can continue to provide more information. You can ask for why, but it's purely administrative, and we're not changing that. As a matter of fact, I would say that if this legislation were not passed, and if an administration decided to include some of these considerations as activity that they felt made somebody ineligible, technically, they could probably do it sua sponte.
Regardless.
Gentleman's time has expired. If the gentleman wants to continue the dialogue, I'll recognize Mr. Issa, and you can yield if you had a second
I
question.
seek recognition.
Gentleman from California is
I
recognized.
yield to the gentleman.
So here's my other question, and this is an argument against myself here. But the thing that occurred
I
to
would
me,
never argue against it.
I always win those arguments. So I was thinking of examples where First Amendment case law in America really is something of an outlier for the rest of the world, and I started to think about campaign finance. So if one of our citizens says, I want to spend $50 million in the French election, and that person's prevented from doing so because it violates their laws, then is the adjudicating officer there banned from coming to America because that would have violated the First Amendment?
Actually, that's beyond the scope of the bill for a reason. We do not affect conduct overseas while you're overseas. In other words, when you go past the water's edge, if you're sitting in Tehran and you want to speak ill of the Ayatollah, it's not specifically within this bill. This is U.S. protected speech. It is on our waters. So it does cover the Wall Street Journal. It doesn't cover going to a protest in Tehran.
Okay, so then the question was raised, Germany, because of its history, has a particular approach to Nazi speech. They've banned it since World War II. They've banned, openly Nazi political parties, which obviously we don't under our First Amendment. But does that mean that a U.S. citizen who goes to Germany and engages in pro-Nazi speech could not be, arrested or censored there under their laws without the official running afoul of our new legislation?
This would not cover their actions overseas. There are a number of laws that cover actions of Americans even when they're overseas. You might remember maybe early in your tenure the sex tourism bills that became a global. You could be prosecuted here for your global activity in other countries around the world, but that's not within the scope of this bill. And again, I kept it narrow because I wanted to make sure that we brushed back this tendency to, mostly on social media, which includes, by the way, all of our great journalism people, because they all go out on that same pipeline, finding their actions literally disappearing in foreign countries and the like. So that's why we did it, because we thought it was our ability as America, in America to speak and to disseminate that around the world, because that's what we did with Radio Free Europe. That's what we've done for so long. And to have anyone brush it back, seems inappropriate. Look, they have the ability to come and sue us here. So we're not eliminating their ability. We're just saying you can't just decide that you're going to not let, in the case of Brazil, literally not let the revenues from Starlink be collected because you don't like what's on X.
Gotcha. All right, well, that's clarifying for me. But I don't know if you're prepared to say you'd like to accept the amendment.
I'd like to accept the amendment. The only thing I'd ask is that we do it by, as agreed language. In other words, the two parties simply make sure that the final words are limited in the scope that we've discussed. But we're totally supportive.
The gentleman yield.
I'd yield.
Okay.
If it's,
Well,
I think it's
oh, sorry.
Darrell's time. Would the ranking member be willing to withdraw his amendment? We passed the legislation. I think we got agreement amongst both parties for the legislation. And we will pledge, I will pledge, we will not bring this to the floor until we've in some way addressed your amendment, either put it in the bill, work on the language, and you offer it as an amendment on the floor. I think Mr. Issa said it well. We like the spirit of it. We just want to make sure it fits within the narrow scope of what we're trying to do.
And I'd like it to be in the bill when it goes to the floor. I think we can get there.
Okay, well, if the gentleman will yield, I very much appreciate your openness to possibly accepting it and are working on this language. I know there are a few other members who have amendments that we want to hear, and so I'll continue to follow that, and I hope that if the legislation moves forward, we can definitely work on it.
Okay, and we can have people working behind the scenes even today. I want to get it done quickly.
I will withdraw the amendment, Mr. Chairman.
I appreciate it. The memo is withdrawn. Who seeks recognition? Gentlelady from Pennsylvania is recognized.
Mr. Chair, I have an amendment at the desk.
The clerk will report.
Amendment to the amendment in the nature of a
Without
substitute.
objection, the amendment will be considered as read.
Reserve a point of order.
The gentlelady is recognized to explain her amendment.
So the First Amendment protects free speech and a free press. It's among the founding principles of our nation, and the addition of the Bill of Rights, including the First Amendment, was essential to our Constitution's ratification. And of course, the principle that a free press is essential to our civic life and must be free from suppression and coercion, whether by a monarchy or other form of government, that was vindicated by the original Philadelphia lawyer, Andrew Hamilton, in the John Peter Zenger trial. We know that a democracy only truly works when its citizens are properly informed. But while our Republican colleagues have presented us with this unworkable legislation that they claim is about protecting Americans' First Amendment rights, they're ignoring the outright assault on the First Amendment that's currently coming from inside Donald Trump's White House. Mr. Issa mentioned that in some countries it's illegal to speak ill of the king, and it appears that that's rapidly becoming the official policy of the Trump White House. Just yesterday, the administration announced that it was seizing control of the White House press corps, moving decisions about the press pool away from the independent journalist organization that has handled them for decades. So our own domestic autocrat, not a foreign king, is trying to assert and trying to freeze out those who would question or criticize his actions. The administration has weaponized the FCC to go after broadcasters like NBC, PBS, and NPR that produce content or have policies that the administration doesn't like. They've had DC's U.S. attorney, referring to himself falsely as Donald Trump's attorney, send threatening letters to members of Congress for criticizing Donald Trump's allies. Reporters have been evicted from their offices in federal buildings. The White House has kicked the Associated Press out of the Oval Office in Air Force One because the outlet made an editorial decision to continue to refer to the Gulf of Mexico as it has been and continues to be known throughout the world for over 4 centuries. And the president and his allies have brought frivolous lawsuits against news outlets like the Des Moines Register and various networks because the president didn't like their coverage or the results of their polls. It's clear that free speech and a free press are under attack by this administration and its billionaire buddy, Elon Musk. They're using the power of the government and big tech allies to promote their own lies and to punish or silence those who disagree. If my colleagues across the aisle really want to protect the First Amendment, as all patriotic Americans should, they'd be outraged. They'd speak out against what's going on. Because if we're going to champion the First Amendment around the world, we should be standing up for it here at home. But so far, all we're hearing from our Republican colleagues is crickets. So my amendment would address the recent attacks on the First Amendment that I've outlined above. If the majority thinks these actions don't constitute attacks on the First Amendment, then they should go on the record and say so. But I'd hope they would support my amendment to acknowledge these sorts of egregious violations for what they are. I yield back.
Gentlelady yields back. Gentleman from California is recognized.
I appreciate the gentlelady's concern in this area, and I certainly support her 5 minutes of explaining her, the injustice that she feels is going on. I will say it's certainly outside the scope, the intention, and the benefit of this bill. It's certainly not outside the gentlelady offering a similar bill that addresses this specifically, and I would encourage her to do that.
Gentlemen, you yield for a quick question?
Of course.
You said you appreciated my concern. Would you condemn those actions of restricting access to the White House by our news outlets?
I'm glad you asked that question, and I'll answer it this way. I would do different things than our current president. I would handle things differently. I think each of us would be different. But for the gentlelady, look, I fully appreciate that this committee under Chairman Jordan has had a concern about weaponization of government, and I believe that we should always hear and amplify any time it appears as though any administration is using any of its powers to weaponize. I have a long history of feeling like, although it's a privilege to be one of the few that gets to be at the White House, that we should be very careful to not exclude the historical champions of that. And so I would answer you by saying the Associated Press has been a conduit for everyone for a long time. And I would hope this gets resolved quickly, because I don't believe that the Associated Press, based on their past history, should not be at the table. You know, I knew the late Helen Thomas, and I watched her, after a generation of being the leader, be dismissed from her coverage of the White House. She was a personal friend. She yelled at me regularly over my politics, but she was a personal friend. And so, yeah, I do appreciate that on that particular example, we should be very careful to change the mix of people who have access to those precious few slots that exist. And so I don't know that that's as much empathy as you would like, but it really is genuine. And I would say that the gentlelady's got a point, and I would encourage her to hold us as accountable for weaponization in everything you do, the same as we, I think, tried to hold the last administration accountable for the same reason.
Well, I'll ask my staff to reach out, and maybe we can work on the bill.
I look forward to it.
Gentleman yields back. Gentleman from Florida is recognized.
Thank you, Mr. Chairman. I was listening to Chairman Issa talk eloquently, quite frankly, about weaponization and free speech. And, you know, it's funny, I'm literally just reading a tweet from Chairwoman Green from Georgia, who denied my ability today to waive on to an Oversight Committee hearing, which has been standard practice on DOGE, as the first Democrat to join the DOGE caucus, because I believe government should become more efficient and should learn how to spend less money. And not only did she deny it, she then took my letter requesting to come on, tweeting it out, saying she wasn't going to let me attend the hearing today on foreign policy, on foreign spending, and I'm on the Foreign Affairs Committee. And so I was coming to talk about the repercussions of fighting China if we withdraw from the world. And I know the chairman's going to let me continue with my comments because he's a free speech advocate, unlike Chairwoman Green. And I was going to talk about how we can't fund the government anymore by CR, because if we refund it by CR, all the fraud, waste, and abuse that DOGE says they found, we would just refund all that fraud, waste, and abuse if we do it by CR. And the American people voted against the status quo, and so we can't continue government as the status quo. And I voted against the budget yesterday, not because I'm not for decreasing taxes, but because Thomas Massie, who, you know, wears the debt clock, he's the Flava Flav of Congress walking around with a clock, and says, we're gonna add $1 trillion to the deficit in 3 years. $1 trillion to the deficit in 3 years. And I trust Thomas on his numbers. I mean, he's definitely the numbers guy. And so, Mr. Chairman, I appreciate your work on free speech and weaponization. But I would tell you that you should probably talk to some of your members who are in charge of other committees so that we can continue decorum and some norms here that people, when the rules allow you to waive on to a committee, that those waivers are approved. I yield back.
Would the gentleman yield?
I would.
There were two members, two former chairmen of Oversight, and I can say with certainty, neither one of us ever failed to respect that ability to waive on. You know, it's a tumultuous committee, but it's one that always supported that, and I apologize for what you experienced personally, because
well, I didn't go through any trauma, but I appreciate it. I mean, look, I have no doubt that, you know, maybe Chairman Comer ran into her office and was like, "Don't put Moskowitz on." But at the end of the day, I bring it up here because I'm asking you to talk to your colleagues. I don't think any members want a tradition where a committee allows. This committee doesn't allow waivers, right? But where a committee does allow waivers, we should continue that tradition.
we do allow waive within the
Oh,
subcommittee.
we do allow waivers here? Oh, okay.
Yeah, we just don't allow waive from outside the
Okay.
committee. But
Well,
look, I will speak and use all the persuasion I have with the gentlelady to prevent that in the future.
I appreciate that, Mr. Issa. Thank you so much.
Gentleman yields back. Who seeks recognition? Question is on the amendment from the gentlelady from
Pennsylvania.
Pennsylvania. All those in favor? No, she's already spoke on her amendment. I think we're ready for the vote. Oh, okay, right. That's what I thought. The question is on the amendment offered by the gentlelady from Pennsylvania. All those in favor say aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it.
Roll call vote.
Roll call being requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett?
Mr. Kiley.
Mr. Kiley votes no.
Gentleman from Missouri, Mr. Onder.
Mr. Onder votes no.
Gentleman from Kentucky, Mr. Massey.
Mr. Massey votes no.
Anyone who hasn't been recorded? Clerk will report.
Mr. Chairman, there are 12 ayes and 19 noes.
The amendment is not adopted. Who seeks recognition? You guys got any more amendments? We're good.
Any more amendments? No, that's it.
Question occurs on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor of the amendment in the nature of a substitute, say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it.
The question is unfavorably, the ayes have it, amendment in nature substitutes.
The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chairs, the ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 875, the Protect Our Communities from DUI Act, for purpose of markup, and move the committee reported favorably to the House. The clerk will report the bill.
H.R. 875.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Alabama, Mr. Moore, for an opening statement.
Thank you, Mr. Chairman. Every 45 minutes, that is how often someone in the United States dies in a crash involving an alcohol-impaired driver. In 2022 alone, there were 13,524 alcohol-impaired driving fatalities. In 2020, drunk driving crashes led to nearly 400,000 injuries. Those crashes don't discriminate. The victim could be me, could be you, be one of any of our family members. This issue hits close to home for me. There was a newlywed couple from my hometown of Enterprise, Alabama, named Angel and Jeremy C. I knew this couple personally. Angel and Jeremy were riding a motorcycle together when out of nowhere, an illegal alien under the influence of alcohol collided into the newlyweds with his pickup. Their lives were cut dramatically short. Tragedies like this are not uncommon across our country. Take Broomfield, Colorado, for example. In December of 2023, an illegal alien killed a 46-year-old woman and her 16-year-old son when he drove his truck up to 100 miles an hour, ran into the victim's vehicle, causing it to then crash into a tree. Despite having 5 previous DUI-related convictions, a Boulder County judge sentenced this illegal alien to probation and community service and work release. On December 8, 2023, in relation to the 2 of those convictions, just 4 days before the drunk driving crash killed that mother and her son. Or consider the case from Florida, where just last month an illegal alien from Mexico was arrested in Florida for his 3rd DUI after he hit and killed a kindergartner. In Texas in December of 2024, an illegal alien killed a 7-year-old girl after he drove drunk and crashed into a car that was being driven by the girl's mother. Just months earlier, ICE had lifted a detainer, which had previously lodged against this illegal alien, after he was arrested for assaulting a family member in June of 2024. H.R. 875 makes common sense changes to immigration law to make an alien who is convicted of or who is admitted to driving under the influence inadmissible. It also makes an alien convicted of doing so removable. In fact, 59 Democrats voted in favor of this legislation when I brought it to the floor of the House last February. To our Democrat colleagues, today we respond to the mandate of the American people, who just 3 months ago voted for Republicans to restore common sense in this country. If you're a guest in this country and you drive drunk, you should be removed from our country, period. Drunk drivers are involved in 31% of all crash deaths in this country. On average, drunk driving killed roughly 11,000 people in the United States every year from 2012 to 2022. Yet the immigration laws do not make aliens inadmissible or removable if they drive drunk and recklessly break our laws. H.R. 875 changes that and creates safer streets and safer communities for all of us. I urge my colleagues to support and protect our communities from the DUI Act. And with that, Mr. Chairman, I'll yield back.
Gentleman yields back. The ranking member is recognized for an opening statement.
Thank you, Mr. Chairman, and thank you to the gentleman for his legislation. We lose more than 11,000 people every year to drunk drivers on the highway, and it's an issue that's very close to my mind and my heart because I lost a beloved cousin of mine, Wendy, back when we were both in our 20s. She was in the prime of her life. She just graduated from Brandeis College, and she was killed while riding a bicycle on the roadways of Florida. The driver of that car was a U.S. citizen. I suppose it doesn't make any difference. when I was a state senator in Maryland, we took on the power of the liquor lobby to pass legislation to strengthen our DUI and reckless driving laws in our state. And I introduced legislation to compel the use of what's called an ignition interlock device, which is basically a breathalyzer that's put in the car, and to compel the use of the ignition interlock device for anybody who's been convicted of DUI. The liquor lobby and some of the bars opposed it. They said that's a pain. Every time you get in your car, you've got to breathe into the breathalyzer. Yeah, it's a pain, but it doesn't quite compare to the pain of a mother or a father or a son or a daughter or a brother or sister or a friend who loses somebody to a drunk driver. This is not bumper cars. You know, this is the real thing. So we passed that in Maryland, and I was proud of that. And I know my colleagues in Annapolis have continued to work on the issue. I will never forget, I was named Legislator of the Year by Mothers Against Drunk Driving in 2016. So this is important to me. The thing that shocked me was to find that there are big political forces in the states that are opposed to cracking down on DUI driving because they view any such legislation as an interference with the ability to promote alcohol culture and drinking culture. And it was shocking to me that it became a partisan issue in Annapolis, except for colleagues who themselves had lost somebody in their family or lost a friend. Now, I've seen some of the same dynamic here in Congress. For years, we have had legislation introduced by members on both sides to encourage states to enact and enforce laws requiring the installation of the ignition interlock device for people who are convicted of drunk driving. And I'm a proud co-sponsor of that bill, the DUI Act, last Congress. Alas, there were no Republican members of this committee who joined us in that legislation. I know Representative Cohen has worked energetically on combating drunk and dangerous driving on the roads, along with a number of other my Democratic colleagues. The HALT Drunk Driving Act was included in the bipartisan infrastructure bill, which again, unfortunately, fell to partisan conflict, and so it was rejected by all but one of the GOP members of this panel. So against that backdrop, today's legislation seems suspect to me because it doesn't confront the danger of drunk driving with serious public policy changes. That is, it doesn't deal comprehensively with the issue. Obviously, the vast majority of drunk driving fatalities in America are caused by U.S. citizens. So this legislation seems to weaponize the problem to scapegoat immigrants. It's not a serious attempt to reduce drunk driving on the roads, a problem that's overwhelmingly about citizen drivers, because overwhelmingly our roads are filled with citizen drivers. Nor does the bill do anything to repair our broken immigration system or secure the border. So we've got able and committed members on both sides of the aisle, and if we want to make the roads safer for everybody from drunk drivers, let's get together and do it. I will have lunch with whoever wants to do that. Let's plan that out now. Congress can pass bipartisan, comprehensive legislation to address drunk driving. We can also pass bipartisan, comprehensive immigration reform. We reached a tough deal on the Senate side with President Biden last Congress to fortify our border with better technology, more personnel, more asylum judges, increased funding, and then that was tanked, as everybody knows. So I would suggest that's a much better way to go, and I will yield back to you, Mr. Chairman.
Gentleman yields back. The chair now recognizes the gentleman from Alabama to offer an amendment in the nature of a substitute.
Mr. Chairman, I appreciate it. This really is just an amendment in technical nature. I have an amendment at the desk.
Yeah. Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from Alabama to explain the amendment.
It doesn't change anything but the date, Mr. Chairman, so it doesn't change any substance of the bill, and with that, I'll yield back.
Gentleman yields back. The gentleman from Texas, Mr. Nels, is recognized.
Yes, sir. I thank you. I support my colleague, Mr. Moore, on this issue. You know, serving as an old sheriff in Fort Bend County, Texas, we arrested a lot of people for drunk driving, threw a lot of people in jail. Some of them went to prison if they cause serious bodily injury or death to the victims. This bill really just focuses nothing more on individuals that are here that are illegal and that are caught driving under the influence. I can remember Miss Boo, I'll never forget it. Her son was in my office, and I had to explain to him why his mother was killed by an individual that was deported 6 previous times. And one of the previous deportations was as a result of drunk driving. So quite honestly, Mr. Moore, if your bill would have been in effect years ago, maybe Ms. Boo would be here with us today. So this is much needed legislation. If you're going to come over here, I just ask you to respect our damn laws, respect our laws. And if you're here illegally, obviously you don't, and then you want to come over here and harm, possibly kill the American people. You need to serve your time, and as soon as you get released, you need to be sent back to where you came from. With that, I yield back.
Gentleman yields back. The gentleman from California is recognized. I think you were the first. Yeah, gentleman from California is recognized.
Thank you, Mr. Chairman. And first of all, Mr. Moore, I want to thank you for bringing up this legislation. It's good to discuss driving under the influence. In my district, a number of years ago, I got a phone call in the morning. City of Orange, a young lady, American citizen, under the influence, rammed into a number of children in a school crosswalk, 7 a.m., killed a number of them. Under the influence, 7 in the morning. She was partying all night, got in her car in the morning, killed a number of children. So I know we're debating here. I don't think this is an issue of undocumented. Rather, it's an issue of driving under the influence in this country. Mr. Moore, I was just going to say, under crimes of moral turpitude, you're already inadmissible and deportable in the United States. And these crimes include murder, manslaughter, violent crimes, sexual assault, rape, incest, child abuse, embezzlement, theft, robbery, fraud, conspiracy, money laundering, drug offenses, domestic violence, spousal abuse, animal cruelty, animal fights, and DUIs. You're already inadmissible, deportable to the U.S. But I would say to you, and I agree with you, that driving under the influence is an issue we have to deal with, continue to deal with in this country. We have to send a strong message, not only to those who are here not as American citizens, as immigrants, but rather all Americans. We have to send them a message, no more DUIs. And I think Congress needs to lead by example. I'd like to see a bill that, for example, would say, members of Congress who are convicted of a DUI are not eligible to serve in U.S. Congress. Let's lead by example. Mr. Moore. Sorry. You can't do the time, don't do the crime. So, Mr. Moore, I would say to you, I'd love to work with you on public policy to address driving under the influence. Too many people have died horrifically because of foolish individuals drinking, smoking pot, getting behind the wheel, and driving in our public streets. This is not an issue of undocumented, of immigrants. Rather, it's a public issue that we need to continue to address.
Will the gentleman yield?
Of course.
I want to thank the distinguished gentleman from California for his remarks. And I failed to say in my opening statements that indeed, as the gentleman points out, that most DUI offenses are already grounds for removal because they are crimes of moral turpitude. DUIs where the penalty is a year or more and where there's bodily harm, hit and runs, aggravated DUI, and driving with knowledge of an invalid, suspended, or revoked license. So what this legislation would do essentially is just make it mandatory upon even a first DUI offense where nobody is injured. I don't know that that makes our roads safer compared to, for example, a compulsory ignition interlock device rule for people who are actually convicted of drunk driving. That really has worked dramatically in Maryland, in any event, to reduce drunk driving on our roads, because it's a tiny population that actually drives drunk. Most people just don't do it, and they understand how antisocial it is, but it's a tiny population of people who have a drinking problem who keep doing it over and over again. So the ignition interlock device is installed in their car, the breathalyzer on their steering wheel, so the car won't start until they breathe in and they pass the breathalyzer test. So that's a positive way to go, and I believe our colleague Ms. Jayapal has an amendment that would actually allow the nuances of this problem to be dealt with. And I thank the gentleman for yielding, and I yield back to him.
I want to say to the author of this amendment, Mr. Moore, I'd love to work with you on this very specific issue of DUIs under the influence in this great country. No room for it. Thank you very much.
Gentleman yields back. Gentleman from Arizona is recognized.
Mr. Chairman, I have an amendment at the desk.
I'll reserve a point of order, Mr. Chairman.
Okay.
Oh, you don't have the amendment?
The,
Okay, can we go somewhere else then when we do that?
can you hold just a second?
Yeah, I'll hold.
The gentleman from Wisconsin, Mr. Tiffany, is recognized.
On Tuesday, January 30th, 2024, at approximately 3:30 p.m., a Rusk County Sheriff's Officer deputy was dispatched to a motor vehicle accident on Highway 8 in Rusk County, which is in my district in northern Wisconsin. The Ladysmith Emergency Medical Services was dispatched. Fire personnel advised that the operator of the semi was trapped within the cab of the vehicle. The driver, who was the lone occupant of the semi, I was identified as Stephen Nashholm. Stephen Nashholm's condition appeared to be critical. The deputy made contact with a male near the other vehicle involved in the crash. Jorge Sanchez advised the deputy that he did not speak English. The deputy observed Mr. Sanchez swaying while standing in place. His eyes were bloodshot and glossy, and his face and eyelids appeared droopy. The deputy detected a strong odor of intoxicants. The deputy learned that Mr. Sanchez's driver's license status was revoked due to a prior OWI. Mr. Sanchez agreed to a preliminary breath test. The test indicated a breath alcohol content of 0.176. In Wisconsin, 0.08 is over the limit. Mr. Sanchez admitted he is not legally in the United States, and he has not been in the United States for approximately 3 years, which would be, or had been in the U.S. for approximately 3 years, which is 2021. Mr. Chairman, that gentleman, Stephen Nashholm, he died in that accident. He leaves behind his family, including 3 daughters. This is part of the carnage that illegal immigration and the invasion of America over the last 4 years has brought to America. And there's a tiny bit of the population that's dead as a result of it. Mr. Nashholm, as I said, leaves behind 3 daughters. As we've been saying for 4 years, every state's a border state. This happened in rural northern Wisconsin, about as far as you can get from the southern border. I'd also point out a witness that we had here, Mr. Chairman, Erin Rockwall from Pewaukee, Wisconsin. Her family's part of the carnage that came from illegal immigration here in America. Her son died of a fentanyl poisoning. I would take you to Prairie du Chien, Wisconsin, where a Venezuelan gang member brutally beat up a woman and her daughter just last year, after going on a crime spree in Madison, of which Dane County has is a sanctuary county here in the United States of America. So I'm fully in support of Mr. Moore's bill here. I mean, unfortunately, we've had to take a rifle shot approach here in this committee to make the point to some on the other side, and by the way, thank you to the Democrats who have supported these pieces of legislation as they've come forward, but we've had to very specifically identify for the American people the carnage that has been going on here in our country. And this is just another one of those rifle shot bills that we've had to do that make it very clear of the carnage that has happened in the United States of America over the last 4 years. And I am grateful that this committee, I believe, will be bringing, we heard the term comprehensive legislation. I am very hopeful that we will do the same as we did last session when we passed H.R. 2 out of this House of Representatives. I hope we will do something similar to fix this problem that has been foisted on the American people over the last 4 years, which was probably the #1 issue that people were voting on November 5th, because every state was a border state. And I hope we will continue to bring legislation like this, including much wider-ranging legislation to fix the problem on the southern border that the Trump administration has made clear they're going to do it, but let's make sure it lasts for more than 4 years and it becomes statutory. And it becomes statutory by being kicked off in just this committee, the Judiciary Committee, that knows the carnage in America needs to end. I fully support this bill, and I yield back, Mr. Chairman.
Gentleman yields back. I had, I believe, the gentlelady from Washington and...
Mine is an amendment at the desk.
Okay. Yeah, go ahead. The gentlelady's recognized. Clerk will report.
Amendment to the amendment in the nature of a
Objection, the amendment will be considered as read. The gentlelady from Washington is recognized.
Reserve a point of order.
A point of order has been reserved by the gentleman from Arizona.
Thank you, Mr. Chairman. My amendment is straightforward, and I think it would help address the unintended consequences of this bill. I, too, appreciate the efforts that people are making on both sides of the aisle to address the issue of DUIs. But I am concerned about what this bill does and allows for. It would allow, my amendment would allow judges to have discretion to consider mitigating factors before summarily ordering a lawful resident to be deported, because this bill does involve lawful residents. I take DUIs extremely seriously. According to the National Highway Traffic Safety Administration, approximately 37 people die in drunk driving accidents per day in the United States, and I think the ranking member and others on this committee have offered very powerful statements about why it's very important for us to do what we can to prevent driving under the influence. But this bill is, unfortunately, I think, not a solution as written. As the ranking member discussed in his statement, many DUIs are already considered crimes involving moral turpitude, and they are already grounds for removal or inadmissibility. Serious public safety threats are already deportable offenses under current law. I worry that this bill seriously scapegoats legal immigrants who have long-standing community presence and many considerations, and subjects them to very, very harsh sentences without any judicial discretion. To be clear, this bill would make anyone convicted of a single misdemeanor DUI subject to deportation. The issue here is that the bill has not at all considered how DUI statutes differ across the country. In Arizona, the DUI statute allows people to be charged with a DUI if they're intoxicated and have, quote, physical control of their vehicle. I bring this up because in the Ninth Circuit, in reviewing an appeal of a removal case for a non-citizen charged under this law, it was found that the, quote, physical control language meant that under the statute, and I quote, one may be convicted under it for sitting in one's own car in one's own driveway with the key in the ignition and a bottle of beer in one's hand. While the non-citizen in this case had been ordered deported because his conviction under the statute was considered a crime of moral turpitude, the Ninth Circuit overturned that ruling because the actions covered by the statute could not all reasonably be seen as crimes involving moral turpitude. As the court put it, quote, drunken driving is despicable. Having physical control of a car while driving is not. If this bill had been enacted when the case had been decided, the case would never have actually made it to the Ninth Circuit, because no judge would have the discretion to rule whether this so-called crime merited the very harsh sentence of deportation. The bill would actually prevent, in its current form, judges from being able to decide if the punishment fits the crime. And this case is just one example of overbroad DUI statutes. There are many others that we can discuss. I was recently taking a refresher course on driving in order to get a discount on my insurance policy, and I learned that my state is actually one of those same states, Washington, allows for the conviction of a misdemeanor DUI while not actually driving the vehicle. And remember, the case I discussed only made it to court because the prosecutors chose to bring those charges, suggesting that prosecutors will indeed continue to advance these minor DUI cases. Under these statutes, individuals that are charged with DUIs for merely sleeping in their car would be penalized. If you're trying to wait until, because you get into the car and you realize that you should not be driving and you pull over on the side of the road and you sit behind the wheel, you could actually be convicted. So people have potentially made the conscious choice not to drive impaired, but they end up punished. And again, to be clear, we are talking about green card holders, people who are legal permanent residents, legal residents here in the United States who Republicans often say they claim to like. And so we're putting their fates on the line. So my amendment says that immigration judges have the discretion to decide if a DUI conviction actually merits deportation by considering mitigating factors. Things like, was anyone harmed? Has the person sought treatment for substance abuse after their DUI conviction, which is what we want in the case of an illness or an addiction, and the length of time that they were convicted of the DUI. Everyone deserves a second chance. This amendment doesn't even require that. It just allows judges to consider all of the factors of the case and give them discretion to consider offering grace to someone who might deserve it. And I hope that there might be support across the aisle for this amendment. I yield back.
Gentleman yields back. Gentleman from Alabama is recognized.
Thank you, Mr. Chairman. On its website just last year, U.S. Customs and Border Protection clearly stated a single driving under the influence DUI conviction is not grounds to deny entry into the United States. Moreover, the Board of Immigration Appeals has held a simple DUI offense is not a crime involving moral turpitude that would make an alien removable from the United States. Time and time again, the Democrats on this committee are dead set on watering down any bill that has a whiff of immigration enforcement. If you ask the average American whether an alien in this country should be deported if an alien commits a DUI offense, the average citizen would be dumbfounded to think that that isn't already in the law. Yet Democrats today would prefer that immigration judges and immigration officers engage in the complex legal analysis to determine whether a DUI offense is serious enough to warrant an alien being removed from the U.S. or barred from entering the country in the first place. Despite the electoral defeat in November, Democrats continue to reject just common sense. We should not have to wait for an alien to kill someone or after their second or third or fourth DUI before we deport them. And we don't need to empower immigration judges to impose open border enforcement agendas through such vast discretion. Statistics show by the time someone is arrested for a DUI, folks, that person is driven at least a dozen times drunk. The only factor that we should be considered is whether an alien has admitted or been convicted of a DUI offense that simply makes sense. I urge my colleagues to reject this amendment. And with that, Mr. Chairman.
Will the gentleman yield for a quick question?
Yeah.
Is it okay? Yes. Thank you for that powerful statement. You know, when someone's killed by a drunk driver, the family would like to see the drunk driver, the reckless driver, the motorist who does this put away forever. Then it raises the question, when you think about it, not from the standpoint of the victim's family, but from the standpoint of the legislature, well, anybody who's driving drunk theoretically could be causing the exact same kind of trauma and pain and death. So the question I want to ask you is, should anybody leave aside their citizenship or their immigration status, should anybody who is picked up on drunk driving the first time be sentenced to jail for a year or 5 years or 10 years? Because they theoretically could have killed somebody, because the legislation we're looking at would take a permanent resident in the country and say, you're out, we're going to deport you even if nobody's hurt. And it's just an honest question. It's not a rhetorical question.
And I understand, Mr. Raskin, but we're simply trying to clarify here that we have people in this country who are here illegally, or even if they're with a green card, but if they're driving under the influence, there needs to be some teeth in the law. We don't need to just turn them loose.
Right, no, agree, but in other words, should it be a deportable offense the first time if nobody's hurt? I mean, if they're hurt, they should be out, and they're out now. And I guess, and that's the question. I don't know
But
the
we
answer.
apply different standards to people who are here illegally all the time.
No, but people here legally then, because the gentle lady's amendment
yield to
relates.
Mr. Biggs.
I thank the gentleman for yielding to me. So the argument, the nub of the argument from the other side is, if someone brandishes a knife but doesn't stab you, you can stay. The studies are clear. When I hear somebody say, "Oh, you know, it was just the first DUI. It was innocuous. Nothing to it." The studies are clear. I'm going to refer you to multiple studies in just a minute, but I'm going to give you this one study. The average person who gets a single DUI has committed multiple DUIs. The scientific evidence on that is clear. That's clear. And what you're saying is, and by the way, the previous ranker to you said not too long ago, whether someone has 2 or 6 or 20 convictions.
Gentleman,
no
yield.
big deal. I'm going to keep going. Thank you. The gentleman who's asking to yield mentioned if you have a DUI, you shouldn't be qualified to sit in Congress, right?
Or the Senate.
Or the Senate, yeah, right. But the bottom line is, there are people in this Congress today who have a DUI. But ultimately, when we get down to this, the argument you're making is a single DUI, unless there's contact with somebody that harms someone, it doesn't work. That they should not be given this particular punishment.
Gentleman, yield.
And then I'll just tell you the APC case that you're talking about. You're making it sound like an APC is someone who's pulled off the road, is asleep in their vehicle, trying to sleep it off. That is not what an APC law is in Arizona or anywhere else in this country. APC, actual physical control. Actual physical control means you have actual ability to get that car going, moving like that. So it's keys in the ignition. We've had people passed out in the middle of an intersection, car running. Technically, they're not driving. You can't get them on a DUI. You can get them on an actual physical control.
Gentleman's time has expired. Gentleman from Alabama yields back. The gentleman from New York, Mr. Goldman's recognized.
Mr. Goldman.
Thank you, Mr. Chairman. I'll first yield to the gentlelady from California.
I actually disagreed with the Ninth Circuit's decision, and I agree with the gentleman from Arizona on the risk posed by someone in control of a vehicle while inebriated. I don't think I understand the legal decision, but I disagree with the outcome. But here's the question I have. We want to protect everyone from harm, but we also have our faith-driven belief in the possibility of redemption. And so if you have a legal permanent resident who had a DUI conviction 25 years ago, went to AA and has recovered, they would be removable under this bill. So I do think one of the opportunities that the gentlelady's amendment offers is to provide for the possibility of redemption, because I think we all know people in our churches, in our neighborhoods, even in our own family, who have recovered from alcoholism, and there needs to be that possibility, especially for people who are legally here. And I just wanted to make that observation, and I yield back to the gentleman from New York.
Thank you for yielding back. This amendment raises, I think, a narrow but very important flaw in the bill, which is that it applies to lawful permanent residents. Yesterday, we had a subcommittee hearing on the president's executive order on birthright citizenship, which is flawed in many ways, but it does distinguish between lawful permanent residents and those who are here legally but on visas. And to say that someone who has a green card, if they are convicted of a misdemeanor DUI, should be deported is draconian and is inconsistent with other distinctions in bills and executive orders that my colleagues on the other side of the aisle have supported. I think that the gentlelady's amendment addresses that issue very well by allowing even the lawful permanent resident to remain in the statute, which I disagree with, but at least giving a judge discretion if there is a situation like I just described, which seems excessive and I think is not what the bill is truly intended to address. So I would ask my colleague from Alabama if he might consider either supporting this amendment, which I think addresses it, or at least addressing in some other way the fact that lawful permanent residents are included in this bill.
Would the gentleman yield?
I will, yes.
Just to underscore your point, somebody who is a permanent resident of the country, a green card holder, who has a DUI for the first time, could be still deported under the gentlelady's amendment if there's an analysis that finds that that person causes continuing risks and harm. All that the gentlelady's amendment suggests, as I understand it, is that a court should be able to look at those different factors rather than say everybody who gets a DUI the first time is going to be deported. And the reason that I posed the question to the gentleman from Alabama is because I was kind of on the other side of this issue when it came to U.S. citizens, when we were talking about whether people should be jailed the first time in Annapolis. And there, the partisan divide was different. It was, I think, more of the Democrats who were saying, yeah, although not enough of them, but the Republicans were saying absolutely not. Give everybody a break on the first DUI if nobody's harmed, if nobody's hurt by it. And right now, a permanent resident who does hurt somebody is going to be deported, right? So the hit and run, or if there's harm to another person, that person will be deported. So we're talking about that discrete category where it's a first-time offender and nobody's hurt. And I don't know if there's anybody here who would say that person should go to jail for a year or 5 years. I don't know. I'm somebody who would entertain that because I know what it means to lose somebody in your family. And you wouldn't be in a situation like that if there weren't people actually out there drunk driving all the time. And I'm happy to yield back and thank you for your indulgence, Mr. Goldman.
And I yield back to the chairman.
Gentleman yields back. Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. So I am confused by the arguments that are being presented here. We all want mercy, we all want redemption, and we all understand mercy, we all understand redemption. You know what? If you've committed a crime under this particular statutory provision,
Mr. Chair, I'd like to speak in the amendment.
you can go and seek redemption and mercy in your home country. And I wish you Godspeed. But also, the other side has claimed that a DUI is a crime of moral turpitude. They have. We've heard that already, right? And it is a crime of moral turpitude. But they're saying in this instance, this crime of moral turpitude is unique and should not require removal. But I'm just going to remind you that even if you have a green card, if you commit any of the crimes under this statutory provision, you're gone. You are gone. And this should be no exception.
Will the gentleman yield?
And so, maybe if we've got time. So when I get back to the studies that I'm reviewing, and I keep hearing, you know, if it's a first-time DUI, and nobody was hurt, you know, they ought to be okay. When I say they ought to be okay, we're going to let them stay in. But the bottom line is, the studies are clear, and I'll just refer to one right here. It's called Risk of Alcohol-Impaired Driving Recidivism Among First Offenders and Multiple Offenders. The studies are really clear. One time, the first time you're caught, because that's what we're talking about. This isn't the first time you drove drunk. And when we say drunk, we think of someone's falling down. But we're talking about the legal limit, which has been defined in various states, and the most common number is probably 0.08. But if you're at a 0.05, something like 80 to 85% of the population is impaired to drive. We're talking about divided attention. That's what driving is. It requires divided attention. What is the impairment with an 05? Is that your ability to control your divided attention is derogated. That's what we're talking about here. We're talking about somebody who is running the risk. If they haven't caused an accident the first time they're arrested and convicted, and by the way, a lot of states don't fully prosecute. They're providing diversion programs and whatnot. This study itself talks about the multitudes of times that an individual is driving impaired but has only been caught the one time. That's the distinction. That's a huge distinction. And back when I was prosecuting, we saw the same thing with whether it's burglaries or thefts or the one that was less likely to be that way was obviously a homicide. Less likely to be caught, to have committed multiple homicides and then be arrested. But with a DUI, it's happening often.
Will the gentleman yield for a quick question?
Yeah, Mr. Correa asked me to first. Let me just finish this thought here. The thought that I have is I'm baffled by this notion that it's a crime of moral turpitude, but somehow nobody's getting hurt here, so we're going to let this go. And I'm just telling you, there is far more to it than that. I oppose this amendment, and Mr. Correa.
Thank you, Mr. Biggs. I just want to say that your example of somebody pulling a knife on somebody, that's probably a felony. That's not equivalent to what we're talking about today.
Look, let me tell you, it depends on the state, depends on the...
A person who's been here 30 years...
I'm going to reclaim my time back.
Okay.
Reclaim it back. That is incorrect. That's an incorrect statement. That's an incorrect statement of law.
Will the gentleman yield for another question?
From California.
I just wanted to make the point that Democrats are not recognizing the distinction between legal immigrants and U.S. citizens who drive drunk. The difference is we're stuck with the U.S. citizens who endanger our society, and we have to deal with them.
Yeah.
We shouldn't have to deal with drunk drivers coming here from other countries. Whether you're here legally or illegally, you're still a guest of this country. And if you behave in a manner that places others in danger, you need to leave. I yield back.
And I'll yield to the gentleman from the ranking.
Thank you kindly. It sounds like you and I are sort of on the same side of the drunk driving issue because, I was very tough on this. But do you take the position that a U.S. citizen who's picked up the first time on DUI, and I understand they've probably driven drunk many times before, I mobilized all that data for my own arguments, but should that person be put in jail for 5 years or a year? Which I would say is kind of the equivalent of deporting someone who's been a permanent resident for 25 years.
I would say your analogy is inapt. It's apples to oranges. But I would also say that in Arizona, for instance, you get an 05, you're going to jail. You are going first offense. You are going to jail.
Time of the gentleman has expired. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I yield to the gentlelady, Jaya Paul.
Thank you, Mr. Johnson. I wanted to address a number of issues, and I want to thank the gentleman from New York, Mr. Goldman, for his powerful statement. I think it's important to look at the current situation and how this bill changes it. So the current situation is that the following DUI offenses are all considered crimes of moral turpitude. That is, where the maximum possible penalty is a year or more, and where there is serious bodily harm, hit and runs, aggravated DUIs, driving with knowledge of an invalid, suspended, or revoked license. So I wanted to clear up that that is currently the law. What this bill would do is it would expand that and say that somebody who was just with a single DUI where those circumstances don't apply, so none of these terrible things have happened, would be given not even a get out of jail free card, so to speak, but would simply have a judge be able to consider the circumstances. Is this somebody who has lived here for 20 years? Is this somebody who has never had any kind of an offense before? Is this somebody who has an addiction, an illness, because addiction is an illness, and I think we all know that, and we all talk about it in different ways, but somehow when it comes to this issue, we don't want to talk about it that way, and certainly when it comes to immigrants, we don't necessarily want to talk about it in that way. So my amendment doesn't go as far as I would like, because I actually agree with Mr. Goldman's point earlier, but it at least gives the opportunity for redemption, as was so powerfully spoken about. And the issue of second chances. Can a judge, an immigration judge, at least consider whether the punishment fits the crime? Because I think what the ranking member was trying to get at with his example is that we do have some sense in our legal criminal justice system, whether it works or not, that there should be a punishment should fit the crime. So if somebody is killed, that's a different set of requirements in terms of punishment than if somebody is not harmed. And so my amendment just says, can a judge consider those factors and do that only for legal? We're only talking about legal residents. So this is not about undocumented, because undocumented immigrants automatically are deportable for that offense. So we're talking about legal residents here. We're talking about a specific category of people where these considerations would be considered. It doesn't mean that it's going to apply, but we're giving the judge the ability to give a second chance to somebody. So I wanted to clarify all of those things because I think it's really important. It's a very narrowly tailored amendment. And I think for those of us who feel like there has been a slingshot approach on immigration because there hasn't been broader immigration reform, which, as the ranking member of the immigration subcommittee, as somebody who's worked on it for 20 years, as somebody who is an immigrant myself, has actually been through all the visas and gotten citizenship, I think that is really important. I'd love to work with people on the other side who are genuinely committed to trying to reform the immigration system. But to put penalties on legal residents who are here and who have a history of contribution to their churches, to their neighborhood groups, to their communities, and put a punishment on them that is so harsh, that is deportation, that leaves family members behind, that may be U.S. citizens, that puts people in a position where they don't get a second chance when we do have, we certainly have members of Congress who have had DUIs and they've gotten second chances. They get to serve in the United States Congress. I think this is a very narrowly tailored amendment that I hope the other side would support. And I appreciate the consideration and am looking for the folks on the other side of family values to be able to stand up and support this ability.
Will the gentleman yield?
I would. It's my time.
Oh, yeah.
Time belongs.
Oh, sorry.
I'll yield to the gentleman from California.
Thank you, Mr. Johnson. Mr. Moore, if you have a guest that's been here 30 years, yes, he's a guest in this country, a little bit different. That's why judicial discretion is probably something that will help us solve this. But we don't know, and again, if you want to work on something on DUI public policy, love to work with you on that. We've even had a president been convicted of a DUI who can't go to Canada unless he gets special permission. So this is about DUI public policy, sir. Thank you very much. And I yield back to Mr. Johnson.
Mr. Johnson yields back. The chair now recognizes the gentleman from Wisconsin, Mr. Grossman.
He's retiring from the field.
Oh, he's okay.
He's heard enough.
Gentleman from Missouri.
Yeah, thank you, Mr. Chairman. Mr. Chairman, I think it's clear that being present in the United States legally is a privilege, not a right. And even though aliens are routinely arrested for and convicted of DUI, they are rarely found inadmissible or deportable.
In defining whether if an offense is even whether it's an aggravated felony or crime involving moral turpitude is a complicated legal process. And aliens are rarely deported for DUI. In addition, the Board of Immigration in the matter of Lopez Meza held that a simple DUI defense is not a crime involving moral turpitude. So Representative Moore's House Resolution 875 makes it clear that DUI, which claims more than 13,000 American lives a year, is a ground for inadmissibility and deportable offense. The problem with this amendment is that there are way too many soft on crime and soft on illegal immigration judges. So giving those judges discretion to waive the requirements of this proposed law is inadvisable. I strongly support the underlying bill. I yield back.
Gentleman yields back. If it's okay, we'll have a call the amendment vote. I know we have several people want to speak on the legislation itself. So the question occurs on the amendment from the gentlelady from Washington. All those in favor say aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it.
We almost won that.
Roll call being requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Griffin votes no. Ms. Kamlager-Dove votes aye. Mr. Chairman, there are 10 ayes and 17 noes.
The amendment is not adopted. Chair now recognizes the gentleman from Arizona for an amendment.
An amendment at the desk.
Clerk will report.
Amendment to the amendment.
Mr. Chairman, I reserve a point of order.
A point of order reserved by the gentleman from Maryland.
Nature of a substitute to H.R. 8.
Without objection, the amendment will be considered as read. The gentleman from Arizona is recognized to explain his amendment.
Yeah, thank you, Mr. Chairman. Sergeant Brandon Mendoza of Mesa, Arizona, was killed in 2014 by an illegal alien who was driving the wrong way on the freeway while the illegal alien was under the influence of alcohol. He was legally impaired. His blood alcohol content was 3 times the legal limit. He had a violent criminal record that went as far back as 1994. At the time, Sergeant Mendoza was just off duty. He had just completed his shift, and he was on his way home when this fellow, the illegal alien, was driving the wrong way on the freeway and hit Officer Mendoza, who was riding he was a motorcycle cop, and he hit him on his motorcycle. He was a 13-year police veteran and killed by someone who should never have been here and should never have been driving that day. Despite being convicted of multiple crimes over the years, that individual was not deported and remained in the country until that fateful day in 2014. This amendment actually names this bill the following. This act may be cited as the Jeremy and Angel Say and Sergeant Brandon Mendoza Protect Our Communities from DUI's Act of 2025. I want to point out just a couple others. There was an illegal immigrant from Honduras who was under the influence, driving 100 miles per hour, ran a red light and T-boned the car Jimmy Chang was driving in, and Jimmy Chang was 37 years old when he was killed. Between August and September of 2022, ICE arrested 175 individuals, all with multiple DUI convictions of those that they arrested. Juan Navarro Hernandez was arrested in 2019, had 7 DUIs, and had never been removed. 5 additional illegal aliens were arrested recently for DUI, including one who had a felony DUI and one who had left the scene of an accident. Mr. Chairman, this amendment is simple. It's to recognize several people who have fallen at the hands of those who are illegally in the country, who are driving under the influence and had killed them.
Gentleman yields. Who seeks recognition?
I withdraw my point of order.
Point of order is withdrawn. The chair now recognizes the, okay.
Mr. Chairman, but I'll just say simply that, I mean, those are terrible cases. I think that all of them, if they were serious crimes and felony DUIs, are already covered by the law. So, I'm not sure that the title fits exactly the meaning of the legislation, but that's all I want to say about it, and I yield back.
Chair now recognizes the gentleman from California, Mr. Kiley.
Thank you, Mr. Chair. So there's a suggestion from the ranking member that no one on our side supported the ignition interlock requirement, which actually isn't true. I did support that, and I know that a number of my colleagues over here disagree with me on that particular issue. I also wholeheartedly accept the premise that we need to do more about drunk driving to protect the thousands of people who are tragically killed on our roads every year. But I fail to see how that premise leads to the conclusion that we ought to reject this legislation. I don't see how that premise leads to the conclusion that we should take it easy on folks from other countries who drive drunk on our roads. To the contrary, our standards for who we allow in the country are one of the ways in which we determine and convey our values. This value is that if you want to come into the United States, then you cannot recklessly turn your vehicle into a lethal weapon that can end people's lives in an instant and shatter entire families. So this is a common sense measure, I think. It's why it passed the House with bipartisan support before. It's why Canada has essentially the same policy, as someone on the other side alluded to. If you have a DUI, you're not even allowed to go and visit Canada. And by the way, as far as the hypothetical of your own citizens, what the penalty ought to be, they don't all go to jail on their first offense, but they still have a standard that you can't even visit if you have a DUI. So I think this is a common sense measure. I thank my friend from Alabama from bringing it. It will get bipartisan support on the floor, and I hope it gets bipartisan support in this committee today.
Will the gentleman yield?
Sure.
But I'm delighted to hear my friend from California supports the ignition interlock device. You were not on the bill, so that I was just referring to co-sponsors of the bill, and if you were planning to support it, great, and I hope you will join that bill as a co-sponsor. And you're also correct with your logic that to support that does not imply that you don't support this legislation. My position is exactly where the gentlelady from the state of Washington is, which is that when we're talking about first-time offenders who've not hurt anybody and they're a permanent resident of the country, it should go to a judge and they could be deported, but perhaps not. There's a whole constellation of factors we want to look at, which was always the argument that I heard from colleagues on both sides of the aisle, but especially Republicans, about U.S. citizens on their first DUI, that they shouldn't necessarily be sent to prison for that, but work some other kind of arrangement out. So I just hope that the fervor with which people are expressing themselves about DUI by permanent residents will carry over to DUIs by U.S. citizens. Thanks for yielding.
Would the gentleman yield? Right here.
Sure.
Thank you. I just wanted to say that, I've spoken with the bill sponsor. I just appreciate if there's consideration being given to what I'm raising, because I think that this does have unintended consequences for a whole bunch of people across this country who have been contributing in your communities, in our communities. And I think that we do have to continue to think about addiction of all kinds as a disease, as an illness, and be able to ensure that we are making the punishment fit the crime. And I just want to say again that deportation is an extremely harsh punishment. It's merited in certain cases. That's why we have crimes of moral turpitude in the immigration law.
If I could reclaim my time, just to clarify, so then, for both you and the ranking member, you don't object to the admissibility portions of the bill. It's the deportability portions that you object to. Is that correct?
Correct.
Yes.
Yeah.
I agree with that.
I yield back.
And my amendment makes it very clear, by the way, exactly what I'm talking about. It's extremely narrowly crafted. I yield back.
Gentleman yields back. Gentleman from Kansas is recognized.
Well, thank you, Mr. Chairman, and I've appreciated the generally very thoughtful discussion on the broader issue of DUI and the particular issues of inadmissibility and deportability here. I want to thank our colleague from Alabama, Mr. Moore, for bringing this bill. I'm very proud to be a co-sponsor of it. And just as many of my colleagues have shared particular instances from their state, I wanted to offer up why this is a matter of particular importance to me. In the years that I had the opportunity to serve as Attorney General for my state, I believe I attended every funeral of every law enforcement officer killed in the line of duty on our watch. One of those was in September of 2016. A young man, he was 44. It was Master Deputy Brandon Collins. I remember going to his funeral. It was in a large auditorium at Mid-American Nazarene University in Johnson County, Kansas. Master Deputy Collins had been a cop for 21 years. He was on patrol in South Johnson County on US 69 highway on the night of September the 11th, 2016, which was a Sunday. He was there after midnight, so it was in the early morning hours. It was dark. He had pulled over a vehicle for a tail light that wasn't operating, a standard traffic stop. There was a father, a mother, and their child in the car. By all accounts, he was having an appropriate and almost appropriately jovial interaction with the folks he had stopped. He walked back to his cruiser, which was parked behind that vehicle as it would be at a stop. And then the folks who had been pulled over testified they heard a loud bang. And the loud bang was the sound of another vehicle driven by an illegal alien who was drunk. His BAC was .16. He was returning from a party on the Missouri side of the state line to his home on the Kansas side. He had slammed at a high rate of speed into the back of Master Deputy Collins' police vehicle, shoving it into the vehicle that had been stopped. Brandon was killed. The three people in that car were all injured. Ultimately, that individual pled guilty to reckless second-degree murder of our law enforcement officer and to 3 counts of aggravated battery. Was sentenced to, I think, ultimately around 12 years in the Kansas State Penitentiary, and he'll be deported when he's done. But here's the kicker. He had a previous conviction for DUI in California in 2001, when he also was not supposed to have been in our country.
I've actually never gone and pulled those records. I don't know if that was a felony conviction, so somebody just filed up the paperwork and he should have been gone. I don't know if it was a misdemeanor conviction under state law, so perhaps it wouldn't have been covered. I don't know if it was a misdemeanor conviction under some local jurisdiction's local code covering DUI, so perhaps it wouldn't have been covered. But here's what I know. This bill makes sure all of that would have been covered. And had this been law, and had folks done their job in 2001, I would never have attended that funeral, and Master Deputy Collins' wife and their kids would still have their loved one. This is the right thing to do. And while there may be other right things to do, that's not what we're talking about today. Hope we pass this bill. Thank you.
Well said. Gentleman yields back. The gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. This gets filed under, I just can't leave it alone. So the ranking member mentioned the Senate bill last year, and again, every time it's said, I have to correct it. That Senate bill that was supposedly so good never even got a Senate vote. That Senate bill that was supposedly so good didn't stop, catch, and release. The Senate bill that was so good didn't rebuild the wall. The Senate bill that was so good didn't expedite individuals back to their country immediately, to country of origin. The Senate bill that was so good didn't have Title 42, and it codified and allowed up to 1.8 million illegal aliens to come into this country every year. It was a bad bill. It's why it couldn't even get the votes in the Senate. I don't care who the sponsors are. Quite frankly, I don't care what party they are. It was a bad bill, and that's why it never saw the light of day in the House. Secondly, nobody's saying that Americans don't have issues with drinking and driving. And I've always been supportive. Again, I was a state senator. I was a state assemblyman in New Jersey where we have some, I think, pretty good laws. I was a sponsor of Michael's Law. I won't go into that, about somebody who lost their son and broke their hearts for their whole lives. We get it. That's not the issue here. That's not the issue. The standards are different for American citizens and illegal aliens. They're supposed to be. They should be. They need to be. They're not legal Americans. They broke the law once. I understand some of them don't have evil intention. I understand some of them aren't bad people, but they did break the law. But we're not even dealing with those that are just here and broke the law. We're dealing with the criminal element to some degree. So whatever the reason that you came here illegally, if you break the law again, and we've done bills that went through this committee and went through the House and were signed now by this president, that said if you attack a police officer, if you beat a police officer, you're going to be detained, get due process, and deported. If you steal from a store, or you steal in general, you're going to be detained, deported, you'll get your due process, but you're going to leave. And you should. Americans are afforded certain rights and availabilities that illegal people aren't. So I don't understand, I really don't, the other side. I don't understand, there almost seems to be a perverse desire to protect and help people who are illegal more than legal immigrants, more than legal Americans. I don't get it.
Will the gentleman yield for the question?
I will in a minute, maybe. The bottom line is, why would you argue this? They broke the law not once, but twice. And yeah, it is slightly different. And it doesn't mean that an American who makes a mistake, or somebody who is here legally makes a mistake, drinks and drives their first time, that they should go to jail for 10 years. No, I also believe in forgiveness. And there has to be different standards for what the violation is. But the bottom line is here, you broke the law. You came here illegally. You broke the law again. You beat up a cop, or you broke the law again and you drove drunk. You're gonna be deported. I have a friend of mine that wants to get citizenship in Portugal, dual citizenship. You know what? In the country of Portugal, you have to be able to speak Portuguese before they'll give you citizenship. In America now, we're saying, yeah, we don't care. You committed a crime, it's okay. We don't care. You drive drunk, it's okay. You killed somebody, it's okay. Come on. Americans are tired of it. They're sick of it.
The gentleman,
I support Congressman Moore's effort here. It is a good effort. And there are Americans, many Americans out there from every state in the union who support what he's saying. Now, who wanted me to yield?
Right over here.
Gentleman from New York.
I yield to the gentleman from New York.
Thank you. I respect and appreciate very much the gentleman's comments, but they are not applicable to this law. We're not talking about undocumented immigrants who commit drunk driving. They are already immediately deportable. What we are talking about here—
I will reclaim my time for a moment. Forgive me. But just from we heard from the gentleman from Kansas, that's not always accurate, number one, and we have to clarify that. And if that's the issue, let's clarify it. And secondly, in speaking with Mr. Moore, if further clarification of this bill is needed as we go along on a floor amendment or whatever else, that's possible too. But the bottom line is it does apply to what I was saying. I yield back to you again.
And the only other thing I would point out is what we're really talking about here is misdemeanor drunk driving. That's what we're talking about. That's what's not covered already by the INA. The INA covers pretty much all felony drunk driving. And this bill would say that for misdemeanor drunk driving, if you are a lawful permanent resident here, you are removable. And I think you would get a lot of support if we narrowed it a little bit, because that seems draconian and unnecessary and against our own. This is not just a visa. This is someone who is committed to living here and has gone through the whole process to get a green card. We're just talking about misdemeanor, DUI.
You have a responsibility for a green card. I reclaim my time. I yield back.
Time has expired. Gentleman yields back.
Mr. Speaker?
Question.
Mr. Chairman.
The gentleman from New York is recognized.
I yield to the other gentleman from New York.
Thank you. I've finished. I yield back to my colleague.
Will the gentleman yield?
I certainly will.
Thank you kindly. You know, we may have arrived at the end of our destination here, Mr. Chairman. I'll just say the art of legislation is drawing distinctions. And rhetorically, I can understand the profound impact of talking about either just someone who is killed in a drunk driving accident, regardless of who does it. And I can understand the impact of talking about an undocumented person who gets in a car drunk and goes out and kills people. But that's not what we're talking about. We're talking about here permanent residents who don't hurt anybody, who do it for the first time. And I just find myself in an ironic position because I've been a champion of very tough DUI legislation, and I continue to feel that way. But always when it's raised, when the question is raised about DUIs on the first offense, when nobody's hurt, that's when I always have the toughest time, and I began to yield to people to say, okay, that's when you don't want people to go to jail for 5 years or 10 years. And I think the argument that is being made on this side is simply let a judge sort that out to see whether the person is in fact a real danger. As the gentleman from Arizona says, whether there's a history there that may not have resulted in an actual DUI, whether that person was upset for whatever reason and got in a car and drove drunk, but nobody was hurt, and their family's been here for 20 years or whatever. So I think that that is just the line drawing exercise that legislation requires us to do. And I do look forward to working with everybody on this committee for what I think we all would agree would be comprehensive legislation that will make the roads a lot safer, with passage of legislation to favor the installation of compulsory ignition interlock devices for anybody, regardless of their citizenship or immigration status, who drives drunk on the first offense. And I would hope that's something that everybody could agree to. And I yield back to the gentleman. Thank you.
Other than to say that I agree with the ranking member, I yield back.
Gentleman yields back. The pending question is on the amendment by Mr. Biggs to the amendment in the nature of a substitute. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it. The question is on adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the bill is ordered to, Okay, and the bill is reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 176, the No Immigration Benefits for Hamas Terrorist Act, for purposes of markup, and move the committee reported favorably to the House. The clerk will report the bill.
H.R.
Without
176.
objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the subcommittee chairman, the gentleman from California, Mr. McClintock, for an opening statement.
Thank you, Mr. Chairman. Although our political differences these days are vast, there are still some things we came together on in this committee during the last session, and one of them was an enduring opposition to Hamas and the terrorism they unleashed on innocent civilians in Israel a little over 500 days ago. Just last week, the barbaric inhumanity of Hamas was revealed again in the macabre and infuriating spectacle of returning the bodies of the Bibas family. We last saw Sherry alive on October 7th, 2023. She was seized, terrified and sobbing, begging for the lives of her 2 little boys as they were dragged into the hell on earth that Hamas created. Last week, their murdered bodies were returned as trophies, and later we learned in a final act of cruelty that Sherry's body had been substituted for another. We all came together on this committee last year and said that such monsters as these should never be admitted into our country, never given safe haven on our soil, and never tolerated when we find them. H.R. 176 says that anyone associated with Hamas or Palestinian Islamic Jihad in any capacity, or anyone who assisted their terrorist activities in any form, will not be allowed into this country under any circumstances, will be immediately removed if we find them here, and under no circumstances will we allow them to receive any immigration benefit under our laws. For reasons I find inexplicable, the Senate couldn't be bothered to take up this bill in its last session. Hopefully they'll find the time this session. Under current law, being a member of Hamas or being associated with its barbaric attack against Israel is not an explicit ground for inadmissibility or removability, and that's just not good enough. Anyone who gave them support in any form should never be allowed into this country. During the Biden years, the number of known or suspected terrorists encountered at the southern border soared to 392. Too many were allowed into this country. How many more were among the 2 million known gotaways is anybody's guess. After the October 7th attacks, Director Wray warned that the FBI, quote, cannot and does not discount the possibility that Hamas could exploit the conflict to call on their supporters to conduct attacks on our own soil, end quote. In the last month, we recorded a 95% reduction in illegal border crossings thanks to President Trump's determination to protect our country and to secure our borders. This bill will give them an additional tool to quickly remove dangerous foreign nationals from our soil, and it will make it impossible for future presidents to wave in these monsters to take residence in our communities. This bill sends an important message around the world. If you've associated with Hamas, you will get no comfort or quarter here. You are persona non grata in America, and you should be as you should be in any corner of the world that values peace, justice, and human dignity. With that, I urge adoption of the bill, and I yield back.
Gentleman yields back. The ranking member is recognized for an opening statement.
Thank you, Mr. Chairman. The terrorist atrocities committed by Hamas in Israel on October 7th and the subsequent devastating war in the region have been a colossal catastrophe for all of humanity. We hope that a permanent ceasefire can be negotiated so that we'll see the return of all the hostages to their families and an end to the gruesome violence and suffering in the coming weeks. Every week, the world has watched with horror as Hamas has paraded emaciated hostages across the world stage, forcing them to smile and wave while surrounded by terrorists hiding grimly behind masks with their guns. We're happy to see families finally be able to embrace their loved ones, some of whom were actually held captive for over a decade. But we also mourn for all the families, Israeli and Palestinian alike, who will not be reunited in this lifetime. The Bibas family weighs especially heavy on me. Our hearts were broken several times by the devastating loss of Shiri, Ariel, and Kafir, and the callousness with which Hamas treated their remains. More than anything, the images coming out of the region fill me with outrage. Outrage at Hamas for their brutal assault on Israeli civilians, many of whom were actually strong advocates for peace, for their attacks on Gazans who dare speak against them, and the tactics that put so many people in harm's way, but also dismay at the miserable failure of leadership that got us to this point, from the Trump administration's focus on the Abraham Accords, which pointedly ignored the condition and fate of millions of desperate Palestinians, to its plan now to engage in ethnic relocation of the Palestinians from Gaza, to the Palestinian Authority's ineffectual and corrupt governance, to the Biden administration's inability to bring the parties to the table for an enduring ceasefire, and to Netanyahu's empowerment of extremists like Ministers Smotrich and Ben-Gvir, who repeatedly sabotage peace deals and progress at every turn. Getting to a just and lasting peace in the region will require the creative leadership and hard work of true statesmen, not the casual cruelty of bullies who see ethnic cleansing as a solution to political conflict and a way to boost property values in the Middle East. But we can all agree to advance this bill, which passed the House with near unanimous support last Congress. No one affiliated with Hamas nor anyone involved in the horrific attacks of October 7 should be admissible to the United States or eligible for any immigration benefits whatsoever. That's an obvious political and moral principle. This is, however, another missed opportunity for us to work across the aisle in a productive bipartisan manner, Mr. Chairman. It's my understanding that in the markup last Congress, then Ranking Member Nadler pointed out that this is essentially a visa sanctions bill. For decades, we've relied on pre-negotiated bipartisan and bicameral text for every visa sanctions bill. As Mr. Nadler noted, and I'll observe again, the legislation today departs from this practice by directly amending the INA to impose visa sanctions. To put into perspective how unusual this is, consider our response to 9/11. In the aftermath of that national catastrophe, we revised our immigration laws to overhaul significant parts of the immigration system, and we created the Department of Homeland Security. Yet even then, we did not amend the INA to specifically reference the events of 9/11 or to bar the people involved in the planning or commission of those attacks from entering or remaining in the United States. And why? Because the laws that we have in place already bar non-citizens who engage in terrorism or who are involved with terrorist groups from entering the United States. And for those who happen to be here, our laws allow us to remove them and prevent them from collecting any immigration benefits. So under sections 212A3B and A4B of 237 of the INA, any non-citizen engaged in terrorist activity or who's provided material support to terrorists or is a member or representative of a terrorist group is inadmissible and deportable. So I will support the legislation today. I would ask once again if the chairman would work with us to improve the legislation before it goes to the floor. We want it to be as strong and effective as possible in general, while adhering to the bipartisan traditions that have long defined the work of the committee. Thank you, Mr. Chairman. I yield back.
Gentleman yields back, and we will certainly work with the ranking member and the minority on this legislation. A group of us had the opportunity last week to spend a week in Israel. And as both the ranking member and the sponsor of the legislation indicated, we had a heavy day. We went to the concert site where so many Israelis were killed and taken hostage. We went to the kibbutz where they lost a fourth of the people who lived there at that farming community. So we can't. I appreciate the gentleman bringing the bill forward, and it's certainly the right approach.
Mr. Chairman.
The chair now recognizes the gentleman from California to offer an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 176 offered by Mr.
Without objection, the amendment in the nature of substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair recognizes the gentleman from California to explain the amendment.
This amendment simply makes a minor change to the short title. It doesn't change the substance of the bill. I'd urge support of it in the nature of a substitute to H.R. 176.
Thank the gentleman. The gentleman from New York is recognized.
Thank you, Mr. Chairman. I, of course, support this bill, but I want to make a broader point. I think what we have seen over the last couple months, as thankfully some hostages have been returned, is that Hamas is not defeated. And they have used the return of hostages as a spectacle that has drawn a lot of support from those who are not in Hamas fatigues in Gaza. And they have used it to continue not only their control and their power, but also psychological warfare against Israel, including by bringing 2 of the hostages to the exchange to watch, even though they were not released. And I believe they thought they were going to be released that day. So the threat of Hamas is not over. And this bill is just a small way to address it. But we cannot underscore the importance that not only the United States and Israel recognize the danger of the terrorist group Hamas, but the rest of the world, including the Arab states that both border Israel and Gaza, but also make up the rest of the Middle East. And there can be no peace in that region if Hamas still retains power. We cannot lose sight of the threat that they pose that was exemplified so clearly on October 7th when they invaded Israel and brutally murdered 1,200 people. As the chairman said, many on kibbutzim in the south. Those people who live in those kibbutzim are probably the most liberal Israelis who worked the most with the Palestinians. And it did not matter to this terrorist group. And so the conflict cannot end until the hostages are returned, for sure, but also until Hamas is neutralized. And certainly I appreciate this administration putting pressure in whatever way they can, but there also needs to be pressure from those countries that are speaking with Hamas, to include Egypt and Qatar. And there needs to be broader pressure around the globe to neutralize and eliminate Hamas so that we can rebuild Gaza as a independent entity, sovereign entity, where people can live in peace and security next to Israel. And so I appreciate the gentleman from California bringing this amendment. I echo the ranking member's words and suggestion that we continue to work closely in a bipartisan way to address the issue of terrorism. And I would just note one other aspect of addressing terrorism, which is that we have to have a nonpartisan, apolitical Department of Justice, FBI, and intelligence community in order to effectively combat terrorism. If we cannot trust, and those around the world cannot trust, our intelligence community and our law enforcement agencies to protect information and protect intelligence from abroad, then we are going to lose sources and methods. We are going to lose intelligence sharing with our allies. And we are going to make this country much less safe and make it much more open and susceptible to terrorist attacks. So I applaud that we are pushing very aggressively against Hamas and the Palestinian Islamic Jihad. But let's not forget that there are other terrorists out there who would want to come into this country and commit terrorist attacks that are often thwarted by the FBI and intelligence community because of our superior intelligence. Politicizing those agencies and those institutions will undermine our own national security. And I yield back.
Gentleman yields back. Gentleman from New Jersey is recognized.
Uncharacteristically quick, I believe I will be. First of all, I agree with the gentleman from New York. I think his points are well said, and he stated it well. I can't really state it any better. I would say also, when we talk about, the Department of Justice, the FBI, and being sure that we're strong against terrorism, That's why in this committee, we exposed so much of what's happened over the years, quite frankly, in the last administration. And that's why we had a subcommittee hearing yesterday in Oversight, again, exposing all that's happened over the years. We cannot weaponize our Department of Justice. We cannot politicize our Department of Justice. We need an FBI, a Department of Justice, and a rule of law that is strong, that is fair, that is objective. And of course, that will help us. And I believe that's what we're going to see now as we go forward and try to root out and destroy Hamas and others like them. I yield back.
Gentleman yields back. Gentleman from Texas is recognized.
I thank the chairman. I thank the gentleman from California for his legislation. It's important legislation. I would note that today, if I think I'm correct, is 32 years to the date of the World Trade Center bombing in 1993. And I think, obviously, then 8 years later, the second attack on the World Trade Center resulted in a much worse result. But it's a sign, again, sitting here today, 32 years later from that first bombing, in which I believe 6 Americans were killed, including a pregnant woman. And I think 1,000 or so were injured. And that was, I think, the first glimpse into what we were seeing in this current era of terrorism that we then saw unfold from Hamas perpetrated against our friends in Israel in October a year and a half ago. I would note, and I know we've got a sort of bipartisan feeling here about trying to move this forward, but one thing I would respond to the gentleman from New York, I was pleased that 45 of my Democrat colleagues joined in support of the bill that I introduced to sanction the International Criminal Court for its activities directed toward the Prime Minister of Israel, Prime Minister Netanyahu, which also would be able to be turned toward American men and women in uniform and American representatives by a lawless body trying to, put its own authority over sovereign nations defending themselves and engaging in defense of their own nation. And that was what was occurring in this case. So I was glad that 45 Democrats joined with virtually all Republicans in sending that over to the Senate. And unfortunately, for whatever reason, the Democratic leader in the Senate mobilized the Democrats to oppose it when the Majority Leader Thune put it on the floor of the Senate. I wish that the Congress had spoken with one voice when there's that much bipartisan support in solidarity and in defense of our own sovereignty. Unfortunately, that wasn't the case, but I appreciate the gentleman from California putting this important bill forward with respect to Hamas, even though that certainly we could be able to have inadmissibility based on our proving up their connection to terrorist activity. It is much cleaner and better to make it very clear that association with Hamas should result in inadmissibility in the United States for both our safety and just frankly on principle. I appreciate the gentleman from California. I yield back.
Gentlelady from Vermont's recognized.
Thank you, Mr. Chair. Just briefly, I want to associate myself with the remarks from Ranking Member Raskin and also Representative Goldman from New York. I just want to add one thing that has been weighing on me since the vote at the UN a few days ago, in which the United States stood with our adversaries, Russia and North Korea, on a vote regarding Ukraine. And the way in which it involves what we're talking about here is my concerns about the safety of Israel and security in the entire region. And you had in January, Russia signing a strategic partnership with Iran. Iran is no friend to Israel. I'm very, very concerned that this strategic partnership involves AI, control of the internet, and other cooperation between Russia and Iran. And I know many of us on this committee care deeply about the safety and security of the state of Israel. I am deeply concerned that this administration has taken its eye off the ball in regard to what this would mean for Israel, for us to move closer to Russia and North Korea. Thank you. I yield back.
Gentlelady yields back the questions on the adoption of the amendment in nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. All those opposed, no. In the opinion of the chair, the ayes have it. The amendment in nature of substitute is adopted. The questions on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up the Authorization and Oversight Plan for the 119th Congress and move that the committee adopt the plan. The clerk will report.
Committee on the Judiciary.
Without objection, the plan will be considered as read and open for amendment at any point. The chair is now recognized for an opening statement. The Authorization and Oversight Plan we are marking up today reflects a crucial role that our committee plays in the House of Representatives. Congress is entrusted with the responsibility of conducting oversight to review the adequacy and efficiency of the laws that govern this great country. We have an important task in this committee. Our committee is charged with protecting the Constitution, the Bill of Rights, and the liberties that the citizens of America enjoy. That is a commitment that both sides of our committee share. In recent years, we have seen the federal government weaponized against the people that it's supposed to serve. The very taxpayers who pay their bill have been weaponized. Government's been weaponized against them. The White House pressured big tech companies to censor American speech online. The Department of Justice was weaponized and redirected from its core law enforcement activities toward prosecuting political opponents. The FBI was used to target the very Americans it's supposed to protect. Surveilled parents who spoke out at school board meetings, said pro-life Catholics were extremists, and sent confidential human sources to the Capitol on January 6th. These issues should concern all Americans, and this committee's jurisdiction over the First Amendment means we have a duty to investigate. The committee also must examine instances of waste, fraud, and abuse in the agencies under our jurisdiction to ensure that they are responsible stewards of taxpayer money. The plan before us today sets out the committee's priorities on these and many other issues. It is measured and ensures that the committee will meet the challenges facing Americans. I know our Democrat colleagues may not agree with everything, but I look forward to our discussion, and we are happy to add any minority views that they want to submit to the plan. And with that, I would recognize the ranking member.
Mr. Chairman, thanks a lot for this opportunity. And I'm glad that Mr. Nadler is still here for this conversation. Regardless of which party was in leadership for many years, the House Judiciary Committee, as I understand it, treated the adoption of our biennial oversight plan as a bipartisan consensus agenda-setting exercise where we would agree generally to the formal oversight jurisdiction of the committee, if not necessarily to our later substantive evaluation of particular problems that we oversee. Because the oversight plan does not necessarily bind our work in any way, our practice has almost always been to work together to reach an agreement on language that we could adopt by unanimous consent. There should be no problem with fulfilling our modest obligations under House rules by producing a responsible bipartisan oversight plan and saving partisan battles for another day. That strikes me as a decent and hopeful tradition. Alas, for reasons still not clear to me, Mr. Chairman, we are now set on a far more partisan path. I know last Congress, when you took over leadership of the committee for the first time in our practice, or at least to the memory of members and staff, you offered an oversight plan much more like this, which has a lot of partisan shots. When, in the hope of correcting that mistake, Ranking Member Nadler offered an amendment to bring us back to the more neutral text for the oversight plan that could have easily passed under Chairman Goodlatte or Chairman Conyers, that was rejected. Again, nothing in the oversight plan will limit your ability as chairman to set hearing topics as you see fit, to call in the witnesses you want, to conduct any investigation you like. So I'm not sure why we need to plunge the committee into a fight over a needlessly partisan oversight plan, which is a departure from our traditions. This one is backward looking. When I first read it, I started thinking about the Rocky Horror Picture Show, because it seems like we're doing the time warp again. It's back to, this scandal from the Biden era, that scandal from the Biden era. Okay, that invites my members to say, no, we should be doing oversight then if we're gonna be picking out particular scandals. What's going on today with the unlawful federal funding freeze? What's going on today with the Trump administration's assault on the Article 1 powers of Congress to spend money as we see fit. What's going on today with the purge of career prosecutors, FBI agents, and staff at the Department of Justice, or the replacement of leadership at those agencies with Trump loyalists, and so on. Everybody wants to talk about the corrupt bargain with New York City Mayor Adams and the purge of 7 Department of Justice lawyers, including extremely conservative lawyers who clerked for justices like Justice Scalia, rather than have the DOJ participate in the corrupt cover-up of political corruption. So we can go down that road. We have a whole bunch of amendments lined up. But my first amendment is just to go back to the more objective, anodyne description of what we're going to do. But, everybody's got their goodies and sleeping bags, and people can hang out, and we can do that. The way it's written now makes it seem as if the biggest threat to America today is the Biden-Harris administration. I flipped through the report, which mentions Biden-Harris 21 different times, more than fentanyl, firearms, federal judges, Mayor Adams, purge of January 6 prosecutors and FBI agents combined by a lot. So basically, if we're going to be doing some political finger painting on the oversight plan, then our members will be introducing a bunch of amendments, but I will introduce one that could help us avoid that process. I hope you could accept that amendment and the members would be persuaded by it. If not, then our colleagues will be invited to, deal with our reaction to some baffling claims in this document, like the baseless rhetoric about the politicization of criminal investigations and prosecutorial decisions in the Biden administration, where it was Trump-appointed prosecutors like the Hunter Biden special counsel David Weiss, whose names have been dragged through the mud by our colleagues, although neither Weiss nor any of the others he worked with were ever disbarred, disciplined, or even reprimanded for politicizing their work. Compare that to the disbarments or other serious bar discipline imposed on numerous Trump lawyers like Rudy Giuliani for repeatedly lying to the court, or Kenneth Chesebro, who lost his license and pled guilty to a felony count of conspiracy to file false documents, John Eastman, Jenna Ellis, and on and on and on. So we will get into that kind of partisan tit for tat if we insist on going forward with the text as currently written. The current text does not, although it goes back to a lot of Hunter Biden stuff, it does not mention the scandal taking place with the nullification of the criminal indictment adopted by a grand jury in New York against the mayor of New York for bribery, conspiracy, and a series of other corruption charges. That's something that troubles a lot of our members. I assume it troubles some members on your side, or certainly it would if Joe Biden had done it. But in any event, we will talk about all of that stuff if we're moving from kind of the more general description of the subjects that we look into, if we move from that to basically partisan hits. I think all of us by this time know the difference. And I hope you can entertain with some equanimity that First Amendment. And if not, we will have some other ones to offer. I yield back to you, Mr. Chairman.
The gentleman yields back. I would offer another alternative. The ranking member's opening statement could be entered as minority views in the actual oversight plan. And you just laid out all the concerns you have, the things you want to talk about. Put that in the plan. We can adopt the plan. That'll be in there as minority views. And we don't have to go through the amendments that you indicated are going to be offered by your side. So there's that option, which I think makes all the sense in the world. That's why we have a thing called minority views in the oversight plan. But if not, we're happy to debate the amendments that the gentleman and his side bring up.
Well, Mr. Chairman, I thank you for that. Unfortunately, what I laid out was a tiny fraction of the objections that our members have, and not in any sense exhaustive. But I appreciate the gesture there.
Well, I would argue that what I laid out in my opening statement was even a smaller tiny fraction, because my opening statement was much shorter than yours. So we're offering you the longer bit that you can put in as minority views. If not, we will debate the amendments, and that's what the good Lord put us here for to do. So the question now occurs, who seeks recognition? Gentlelady is recognized, from North Carolina is recognized.
Thank you, Mr. Chairman. And I know we're going to get to some of these amendments, and I hope that the First Amendment that the ranking member offers is accepted. You know, this is a really important committee. And being a member of the House of Representatives and being a member of the legislative branch is really important. And we are at an unfortunate time in our history where the executive has no respect for the legislative branch. Zero. That goes to the foundation of what we are as a nation. And our oversight responsibility should extend to the entire executive branch, regardless of who the president is. That is our job. We swore an oath on the Constitution, and part of that constitutional responsibility is to protect the right of the legislative branch to give oversight for excesses that the executive branch engages in, not to pick sides, to pick the American people. This oversight plan is an insult to this body, to this committee, and to the Constitution. And if we're not going to take those responsibilities seriously, there is something seriously wrong with this place. So I will be supporting the ranking member's amendment, First Amendment. I don't think we should be having partisan fights about oversight. I think we should do our duty and uphold our oaths of office. And I yield.
Will the gentlelady yield for 1 second?
I yield to the ranking member.
I want to thank you for that very trenchant statement you just made. And it just reminds me that the founders of the Constitution, when you read the Federalist Papers, were emphatic that they thought that members of each branch would stand up for themselves institutionally, not based on political party, but rather members of the House would stand up for the House and the Congress. Members of the Senate would stand up for the Congress. The executive would zealously promote their views. The judiciary would stand up for the role of the judiciary. And at a time when our spending power is being nullified and trampled, and courts are having to strike down what the executive branch is doing, at a time when departments and agencies we've created, and we have the power to nullify if we want to, are being hollowed out or destroyed by the executive branch, it's very important to remember that we do have a responsibility as members of Congress to stand up for Congress's powers and prerogatives completely aside from political party. We can debate the substance of particular bills and so on, but I would defend any legislation that we've done that is constitutional against an unconstitutional executive attack, even if it hurts my political party, because we have got to defend the prerogatives of Congress. And I yield back. Thank you.
And I'll just say, that is what the people of this country have elected us to do. They didn't elect us to do.
Microphone.
The people of this country elected us to represent them, not to represent the executive. And that is why we must exercise our oversight responsibilities, regardless of party, and in the best interests of the American people. And I yield back.
Gentlelady yields back. The gentleman from New York is recognized.
Thank you, Mr. Chairman, and I appreciate the eloquent words from my colleague from North Carolina and the ranking member. As I read this oversight plan, it looks like it was simply cut and pasted from 2022. It's the same tired, baseless stories, baseless allegations. But then the thing that really strikes me is a sentence in here that says, the American people elected President Trump with a resounding mandate to transform how Washington works. And it's consistent with what I've been hearing for the last 2 months, which is that Donald Trump won the election, and so therefore anything he wants to do was supported by the American people. That's hogwash. That is absolutely absurd. First of all, there was no resounding mandate. He got 49% of the vote. And none of the mandate was to transform how Washington works. It may be partially to address waste, fraud, and abuse, to address the efficiency of government. I mean, that certainly came in behind, in all the polling and exit polling, the economy, which he has not addressed in the least, other than to increase inflation and to increase cost of eggs and to increase the cost of prescription drugs. But this notion that this oversight plan would not stand up for Congress's own authority. What is happening right now is that the Republicans control the Senate, the Republicans control the House. And those senators and members of Congress are happily giving away all congressional authority and power to Donald Trump. They are sitting silently as Elon Musk, with his $13 billion of government contracts, uses whatever algorithm he has to identify keywords that he doesn't like and just starts cutting programs. We all would love to address waste, fraud, and abuse. We'd love to address government efficiency. But you cannot sit here, not a single one of my Republican colleagues can sit here and say, you know what Elon Musk is cutting, that you know it to be waste, fraud, and abuse. You don't. Nobody does. He doesn't even know if it's waste, fraud, and abuse because there's no investigation, there's no evaluation. Instead, he's just cutting, and you all sit there silently, letting some unelected billionaire get access to our personal identification information, cut programs willy-nilly, cut funding, potentially stop funding. I don't understand on what planet do you stop the funding for a program and then investigate it? Why aren't you investigating it while it continues? So the status quo can continue, so that Americans who rely on this money can continue to believe that they will have this money. And in many cases, that Congress appropriated and designated and obligated, and they're stomping all over that down at 1600 Pennsylvania, and there isn't a single Republican member of Congress who's willing to stand up for Congress. For us, for Congress. Just because Donald Trump has designated Elon Musk to do the work, and you're either afraid that Donald Trump will support a primary opponent, or you're afraid that Elon Musk will put $10 million into a primary opponent, and so you happily turn over all of your own authority. What is the point of being here? Why do you run for office? Why do you want to be elected to Congress? So that you can bend the knee to the executive? So that you can bend the knee to Donald Trump? There's no mandate for Congress hiding in a cave. The mandate is to address the issues that the American people are facing, which is inflation, which are high costs, which is affordability. And if you want to address waste, fraud, and abuse, we're happy to do it with you the right way, by coming back to Congress and showing us what's wasteful, what's fraudulent, what's abuse, so that we can vote as the owners of the power of the purse to make those decisions. And I yield back.
Gentleman yields back. I would just respond. He said none of the mandate was to transform how Washington works. I would argue that's exactly what the mandate was. It wasn't like President Trump was keeping a secret from us. He said, we're going to establish DOGE, we're going to have Elon Musk run it, we're going to try to identify waste, fraud, and abuse, and we're going to deal with that. And where there's a question about it, Congress can weigh in, the courts are certainly weighing in. We've had decisions that were favorable to President Trump's
What's Congress been weighing in on?
We've had decisions that were favorable to President Trump's position, Elon Musk's position. We've had decisions from courts that weren't.
Well, Mr. Chairman, if you may yield for one question.
I gave you extra time. Let me have a little more than the 40 seconds I've got. Oh, I guess we're still running on your time.
Well,
I would just say this. We'll get the clock. We'll get the clock straightened out. Instead of helping us stop the ridiculous spending, Democrats just want to keep attacking the guy exposing the ridiculous spending. So I'd actually like to try to deal with the ridiculous spending, which is something I think we'll probably do in the course of this Congress, and certainly part certainly part of our oversight plan. And what I said in my opening statement, things we'd like to get answers to. It's why we sent 7 subpoenas two days ago to the FBI. We still have concerns about what happened, and this is the direct jurisdiction of the Judiciary Committee dealing with the Department of Justice. We still have concerns about why the Department of Justice wanted to investigate moms and dads showing up at school board meetings. We still have concerns, and we don't think we got all the information relative to the Richmond field office memorandum, which said if you're a pro-life Catholic, you're an extremist. We still have concerns about a number of things that we want information and answers to questions that we have, like the 26 confidential human sources who were there on January 6, 2021.
Parliamentary inquiry.
So we're gonna try to look at all that. That's why we spelled it out in our plan.
May I have a
relative to the DOGE effort, instead of helping us deal with the ridiculous spending, all you guys seem to want to do is attack the guy who's exposing the ridiculous spending. And with that,
may I have a parliamentary inquiry?
The gentleman can say it as inquiry.
Does the oversight plan include an investigation if the executive branch defies court orders?
You can read the plan, draw your own conclusion, and you can also do what I suggested a few minutes ago. You can file your minority views where you lay out whatever you want to lay out, and you can go longer than Mr. Raskin's opening statement. You can put all kinds of things in there.
So I take that as a no.
You read the plan yourself, and you can reach your own conclusion. Who seeks recognition?
I have an amendment at the desk, Mr. Chairman.
Gentleman from Maryland is recognized. The clerk will report the amendment.
Amendment to the Committee on the Judiciary Authorization.
Amendment will be
Oversight
considered
Plan.
as, without objection, amendment will be considered as read. The gentleman from Maryland is recognized to explain his amendment.
All right, this is the aforementioned amendment, which is simply to go back to the Judiciary Committee's tradition of articulating an oversight plan that states the general subject matters. So it is innocuous, it's anodyne, it doesn't sound like Fox News, it doesn't sound like MSNBC. There are not partisan hits on the other side. But perhaps it's too late in the day for this, Mr. Chairman. Perhaps politics saturates everything, even the oversight plan. I will say, just in response to your typically pungent and most recent provocation, that we are not upset about waste, fraud, and abuse. We're afraid of the guy who's going after it. I've got some problems with that statement. Okay. One problem with that statement is that the very first thing that Elon Musk and his friend Donald Trump did the first week of the inauguration was to fire 17 inspectors general. These are the people whose job it is to ferret out waste, fraud, and abuse in each department. Last year, they saved us $91 billion in waste, fraud, and abuse. I'm not sure Elon Musk has saved us $91 in waste, fraud, and abuse. They're just sacking, air traffic controllers. They're sacking food and drug safety inspectors. They're sacking assistant U.S. attorneys who worked on prosecuting the January 6 cases. They're trampling the civil service, and they're firing people, and then the next week they have to go back to try to find them again because they realize that we actually have a government and we have a need for federal workers. They sacked a bunch of nuclear reactor safety inspectors and guards, and then since they cut off their email access, they couldn't find them the next week when they realized what they had done. I mean, this is just absurd and outrageous. We've got an oversight committee. I mean, what a telling critique it is of our own oversight committee that you say we need to create a fourth branch of government in Elon Musk Nobody can seem to identify even what his job is, but we need him to go out and start ferreting out waste, fraud, and abuse with a band of, 30 or 40 workers. I think 24 of them, someone will get me the article, just resigned, saying this is not working. His own workers within DOGE resigned yesterday to say that it's not working. So the whole country is in an uproar. So I will go back to the colleagues of the comments of my colleague from New York about us having some institutional self-respect at this point. They're trashing the Consumer Financial Protection Bureau. We created that. They reduced credit card late fees from $38 or $40 down to $8. Anybody want to overturn that and destroy that? They reduced bank overdraft fees from an average of $35 or $40 down to $5. Anybody want to trash that? The reason why we have a Congress is so we can make decisions for our constituents about the public good, not Elon Musk, an immigrant, by the way, an undocumented immigrant for a long time, but he was an immigrant from apartheid South Africa who came to our country on a college student visa, left college, and at that point was no longer in the country lawfully, stayed and worked illegally until he was sponsored by his employer. I'm glad we're a country with a big heart, big enough to take in an undocumented immigrant like Elon Musk. But he's showing some kind of gratitude for the hospitality of our country, that he comes in like a bull in a china shop, destroying everything that the U.S. Congress has done, and trampling the constitutional rights and the civil service rights of tens of thousands, if not hundreds of thousands of federal workers. He sent out a message giving them a Godfather offer, verbatim taken from the memo he sent to the people at Twitter when he took over Twitter, telling them to hit reply in order to resign. He asked 2 million American workers to resign and to take an 8-month paid vacation at the expense of the U.S. taxpayers. And as far as I know, he didn't consult the president. He certainly didn't consult Congress. And we're going to sit here on our hands and take that? What an outrage. What a scandal that is, that the Congress of the United States would allow itself to be rolled in this way. So that's what we're going to talk about, Mr. Chairman, because we no longer are going to have a nonpartisan objective oversight statement. I yield back to you.
Gentleman yields back. Who seeks recognition? Question is on the amendment. Gentlelady from North Carolina is recognized.
Thank you. I'd like to speak in favor of the amendment because, as I said in my initial remarks, this amendment reflects what our responsibility is as members of the Judiciary Committee and members of the legislative branch. And it shows no favor depending on who is in the executive branch. It also makes sure that our U.S. Department of Justice, and we just had a turnover, responds to the needs of the American people. That is our job, and this amendment reflects it. Thank you, and I yield.
Oh, wait, go with the gentleman, you'll please.
I yield to the ranking member.
Thank you. First of all, I've got the exact information. 21 DOGE staffers resigned, saying they will not help dismantle public services. These are people working directly for Elon Musk, as far as we can tell. Now, last week, the administration filed legal pleadings disavowing the suggestion that Elon Musk actually works for DOGE. And yesterday, I think they named someone who actually is running DOGE. What then is the role of Elon Musk? He seems to be in charge of the situation, and maybe one of our colleagues, because they are in the same party with Elon Musk and Donald Trump, could tell us what role he's playing, but we don't understand that. He's not a public employee? I'm sorry? Oh, okay. Well, I know very little about him. I know that everybody in this room who works for the government has got to file ethics forms and do a financial filing. Elon Musk has not done a financial filing. So we know that he collects billions of dollars from the U.S. government as a federal contractor. I hope somebody gets me that article. I think it just came out exactly how much he gets. It's built on a $38 billion It's the title here, and I'll introduce this to the record from the Washington Post this morning. Elon Musk's business empire is built on $38 billion in government funding. So the guy that we have somehow...
Without objection.
Thank you kindly, Mr. Chairman. The guy that we've somehow entrusted with the job of doing our job of oversight to ferret out waste, fraud, and abuse is himself collecting $38 billion in government funding. The person, as the gentlelady from North Carolina says, that we've entrusted with the private data of 300 million Americans in the country, although the courts have moved in to stop that. There are now 25 temporary restraining orders or preliminary injunctions against the absolute lawlessness and chaos unleashed on the U.S. government and the American people by Elon Musk. So I would like to also introduce this one. The 21 DOGE staffers resigned, saying they will not help dismantle public services, Mr. Chairman.
Without objection.
Thank you kindly. Well, look, the gentlelady from North Carolina refocuses us on the proper question here. What's the role of Congress? What's the role of the president, right? Now, the Congress is created in Article 1, the first article of the Constitution. It flows right out of the preamble, immediately after the preamble, which says, "We the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and preserve to ourselves and our posterity the blessings of liberty, do hereby ordain and establish the Constitution of these United States of America." The very next sentence establishes Article 1 of the Constitution. It says that the legislative power is vested in Congress. Then you get page after page after page of what Congress's powers are. In Article 1, Section 8, the power to regulate commerce nationally and internationally, the power to declare war, which is a congressional power, the power to coin currency, naturalization, you name it. And even in Article 1, Section 8, Clause 18, all other powers necessary and proper to the execution of the foregoing powers. Then you get to Article 2, right? 4 short paragraphs. One of them is all about how you impeach a president for treason, bribery, and other high crimes and misdemeanors. Sometimes colleagues will say, we're a co-equal branch. Really? First of all, co-equal is not even a word. That's like extremely unique. That's not a word. Are we an equal branch? I don't think so. We had a revolution against a king and a monarch. The framers were very suspicious of what one individual, what one mad king could do if they thought they were smarter than everybody else. The core job of the executive is to take care that the laws are faithfully executed, not trashed. I yield back to you.
Gentleman yields back. The chair recognizes the gentleman from Arizona. Would the gentleman yield? Second, if you...
Yes, I'll yield.
I just want to make one quick point. The ranking member mentioned the term private data, or the words private data. I think it's worth noting that yesterday we discovered that this Mr. Charles Littlejohn got a contract with the IRS with the express purpose of leaking taxpayer information. And the goal was to leak the return of President Trump. And in doing that, actually 405,000 either businesses or individuals' data was breached and leaked in violation of 6103. So there are concerns certainly about private data, but it happened in the Biden administration with the guy who went there with the goal of going after President Trump's tax return. So I think we got to be concerned about all of that.
Mr. Chairman, what should happen to someone who takes the private data of U.S. citizens from a government?
For this guy, he was only charged with one count.
But in general,
405,000 individuals and business entities and individuals had their data made public in violation of the law.
What should happen to someone like that?
So I think I'd like to reclaim my time.
It's actually not my time. I apologize. Hey,
I'd like to get a word in edgewise on my time. No, it's okay. So I do think it is a bit rich that my colleagues on the other side of the aisle, a couple of you have focused at least a portion of your objection of the plan on separation of powers issues. As I am all about separation of powers, and this business of 3 co-equal branches of government, that's not what the founders intended. This branch is meant to be the most powerful branch, and within this legislative branch, it is this body, the House, that's meant to be the more powerful of the two. So I do find it really an almost laughable argument to hear from my friends on the other side of the aisle, their beef about the executive branch. And some of your arguments may hit the mark. Maybe they hit the mark. Maybe you might find an overextension now, but in the executive branch, maybe you don't, because I think you're all over. You guys have this kind of shotgun approach on your position. But here's the thing that I find incredibly laughable. For decades, we have watched the expansion of the executive branch. The executive branch has grown like Topsy. Didn't matter whether it was D's or R's in this branch. They didn't step into the breach and say enough is enough. And largely because when one's political party has the executive branch, yeah, you're a little bit more generous in sharing or delegating power. But here's the deal. I know this because I have introduced many bills to try to rein in executive power, both when there's been an R in the office, when there's been a D in the office. But almost unanimously and almost universally and almost without any kind of reflection on any attempt to actually rein in the executive branch, my colleagues across the aisle, rein in the executive branch, my colleagues across the aisle have voted against my efforts. Well, so here, and I find it kind of odd that the rationale that you have against this plan that's out there is because it doesn't do what you want it to do with regard to the Trump administration. Well, I think I have to defer to the chairman. I think he's right on this one. You guys have listed so many things that you have a beef with the current administration. Put that in your minority report. Go ahead and do it. But by golly, don't sit here and lecture us about your sanctimonious, self-righteous opposition to the expansion of the administrative state or the executive branch, which are one and the same, ostensibly one and the same, and tell us that you're really beefed about that, because history will demonstrate you haven't really cared too much, and recent history as well. Why? I just had a bill that went to the floor 2 weeks ago. Every Democrat voted against it. It was a bill dealing with regulations and providing relief to it. You guys didn't care about that at all. So don't be here today making us laugh with your position. Yield.
Thank the gentleman from Arizona who seeks recognition.
Mr. Chairman.
Gentleman from New York.
Thank you. Mr. Chairman, the Trump administration and what it's done presents us, in my opinion, with the greatest challenge to the Constitution of the United States since 1861, when there was absolute nullification and rebellion. What do we have with the Trump administration? They're disobeying the laws. Musk is not an appointed official. He is not confirmed by the Senate, and yet he is given the authority to destroy agencies established by Congress. The United States Agency for International Development was established by Congress in 1961. It was authorized. Appropriations were made. And yet, Elon Musk says we're putting it through the wood chipper, RIP USAID, and all the money stops. And the food is rotting on the piers in Africa instead of being given to people who are starving. Not to mention our farmers who suddenly aren't selling food. And that's just one example. Another example, all the agents who were assigned, not chose to, but were assigned to investigate January 6th the insurrection instigated by Mr. Trump against the election of the United States, they are all being fired. Why? Because they did their jobs. They didn't volunteer, by the way, for their jobs. They were assigned to their jobs. And yet we are seeing the systematic disparagement of law, the systematic destruction of Congress appropriations power, the systematic destruction of the Senate's confirmation power by having unelected officials have all this power. And then you look at the Justice Department. I talked about the Justice Department, but all the people who are being fired at all the local offices around the country because they are true to their jobs, because they are true to their oaths. This is the real threat that we face now. And what do we see from this committee? Are we investigating? Are we looking at this threat? No. We're looking at what happened in the last administration. Well, let me give you some information about the last administration. It's over. There's nothing we can do about what happened. What we have to deal with is what's happening now, what's happening in the future, what we can affect. Now, if we want to write historical reviews of the last administration, if that's the job of Congress, I don't know, that's fine. I have no objection. But our real job is to govern this country now, to see that the president obeys his duty to see that the laws are faithfully executed, which he's clearly not doing.
Will the gentleman yield?
I will yield.
Thank you, Mr. Nadler, for those eloquent remarks. You know, not only are our colleagues letting Elon Musk and Donald Trump presumably get away with the usurpation of congressional power, when the courts strike it down, as they've done in numerous cases, they move to impeach the judges. So we've had courts come out and say that, no, you can't take everybody's data from the Department of Treasury. No, you can't violate the rights of workers at the Agency of International Development. And so what do you think about this attack on Article III power?
Well, I was coming to that. And we have the Vice President of the United States saying that the President can ignore judicial orders. That the Vice President is saying that the law essentially is what the President says it is because he doesn't have to obey presidential orders.
With the gentleman yield for a question?
He doesn't have to, no. He doesn't have to obey judicial orders.
Okay. No?
It is the core, since 1803, we've recognized that the law is emphatically the duty of the judiciary to declare what the law is. And now we have an administration that says no. And if the president, or when the president perhaps, disobeys a court order, as the Vice President said he could do, then we have no remedy at all. Then we have no democratic republic. And for the 16 seconds I have left, I'll yield.
Thanks. Oh, you're going to yield? You're not going to yield?
I did.
Oh, yeah. I guess my question, and now in 6 seconds, is this. When you say you should yield to the court's opinion, is that like with student loan repayments and that type of thing?
All I don't know about the student loan repayments.
But I do.
Well, the chair will advise. There's a rhetorical question ending the gentleman.
All I know is that in this country, the courts declare what the law is, and the executive must obey it.
All right, the gentleman's time expired. Who seeks recognition on the amendment? The question is on the amendment. Offered by the gentleman from Maryland. Those in favor say aye.
Aye.
Those opposed?
I'd like a recorded vote on that, please.
The clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Biggs. Mr. Biggs. Mr. Biggs votes no. Mr. McClintock. Mr. McClintock votes no. Mr. Tiffany. Mr. Massey. Mr. Roy. Mr. Roy votes no. Mr. Fitzgerald. Mr. Fitzgerald votes no. Mr. Klein. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Ms. Hageman, Ms. Lee, Mr. Hunt, Mr. Fry, Mr. Grothman. No. Mr. Grothman votes no. Mr. Knott. Mr. Knott votes no. Mr. Harris. No. Mr. Harris votes no. Mr. Onder. No. Mr. Onder votes no. Mr. Schmidt. Mr. Gill. Mr. Gill votes no. Mr. Baumgardner. Mr. Raskin. Mr. Raskin votes aye. Mr. Nadler. Aye. Mr. Nadler votes aye. Ms. Lofgren. Mr. Cohen. Mr. Johnson. Mr. Swalwell. Mr. Liu. Mr. Liu votes aye. Ms. Jayapal. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes aye. Mr. Neguse. Ms. McBath. Ms. Ross. Ms. Ross votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Garcia. Mr. Garcia votes aye. Ms. Kamlager-Dove. Ms. Kamlager-Dove votes aye. Mr. Moskowitz. Mr. Goldman. Ms. Crockett. Mr. Issa votes no.
The clerk will report.
Mr. Chairman, there are 8 ayes and 12 noes.
The amendment is not adopted. Who seeks recognition? The gentleman from New York.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the Committee on the Judiciary Authorization and Oversight Plan for the 119th Congress, offered by Mr. Nadler. On page 8,
Without objection, the amendment will be considered as read. The gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I almost feel sorry for this Republican majority. For 2 years, they did nothing but launch baseless investigations and attacks on the Biden administration in a desperate and ultimately failed effort to impeach Joe Biden. And now, with President Biden no longer in office and Donald Trump in the White House, they clearly have no positive agenda for governing and certainly no appetite for meaningful oversight. So what are they to do? They have been reduced to looking backwards with a hopelessly partisan oversight plan that rehashes the same tired conspiracy theories and false narratives about the Biden administration that dominated this committee's last Congress. In so doing, they have shown themselves to be willfully blind to the ever-multiplying scandals now enveloping the Department of Justice under the Trump administration. My amendment would shine a light on just one of the many stunning acts of corruption we have seen in the opening days of this new administration. It would call on the committee to examine the Trump administration's decision to overrule a grand jury, the U.S. Attorney for the Southern District of New York, and senior officials at the Public Integrity Section of the Department of Justice in order to strike a corrupt bargain with New York's Mayor Eric Adams, who was charged by a unanimous grand jury with 5 felony counts of criminal bribery and soliciting illegal campaign contributions. Every person, no matter who they are, is guaranteed due process and is presumed innocent until proven guilty in a court of law. But Mayor Adams tried to short-circuit this process. Rather than take his case to court, he took it to Mar-a-Lago. And lo and behold, shortly thereafter, the Justice Department moved to dismiss the charges against him and said they were doing so not because they were convinced that they did not have a case, but because they were convinced that they could bend the mayor to their political will in exchange for dropping the charges. In return for dismissing the case against him, the administration expects the mayor to help carry out President Trump's extreme immigration enforcement policies. Notably, when they sought to dismiss the charges, they reserved the right to file them again, holding a sort of Damocles over the mayor, holding him on a short leash if he is not sufficiently loyal and compliant. Indeed, Tom Homan, the administration's border czar, joined the mayor on Fox News recently and threatened, and I quote, "If he doesn't come through, I'll be back in New York City, and we won't be sitting on a couch. I'll be in his office, up his butt, saying, 'Where the hell is the agreement we came to?'" Close quote. The corrupt quid pro quo could not be any clearer. It is happening before our eyes on national television. But where is the Republican majority? Still blinded by their unwavering loyalty to Donald Trump, no matter what scandals unfold daily. If our Republican colleagues are unable to see the corrupt bargain over the Adams prosecution for what it is, at least some dedicated prosecutors who are more loyal to their oath of office than to Donald Trump took a stand against this improper deal. Several career prosecutors courageously resigned in protest after being ordered to drop the prosecution rather than going along with this bargain. They were led by interim U.S. Attorney Danielle Sassoon, who was a former clerk for Justice Scalia and a Federalist Society member, is certainly no liberal. She was joined by the case's lead prosecutor, Hagan Scotton, another bona fide conservative who clerked for Chief Justice Roberts and Justice Kavanaugh when he served on a lower court. In his resignation letter, Scotton wrote, quote, "I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion, but it was never going to be me," close quote. Sadly, he was right. Emil Beauvais, the acting deputy attorney general, filed such a motion last week. The case is now in the judge's hands, but this committee must act as well to perform our constitutionally required oversight function and to examine the details of this corrupt bargain. Mr. Chairman, I understand that Republicans yearn for a simpler time when their political opponent was in the White House and they could spend their time inventing false scandals to investigate while the country was being governed by a responsible administration. But there is a new reality and a new administration, and they can no longer hide their heads in the sand. Just weeks into the Trump administration, crisis after crisis is unfolding in the Department of Justice and across the government, and the country needs Congress to be a check and balance, but this majority refuses to take its oversight responsibility seriously. If they want to examine, quote, the politicization of criminal investigations and prosecutorial decisions, close quote, as they claim in their oversight plan, they will begin by shining a light on the Adams prosecution, as this amendment does. I urge all members to support this amendment, and I yield back the balance of my time.
Thank the gentleman from the New York. He of course is free to put any of those remarks into the minority views, and would suggest that he do so. The gentleman from New Jersey.
Of course he's free to do that, but he doesn't want to do it because they want to play this out. It's political again. We've gone through it before. Look at the shiny object, really don't look at the matters at hand. It is rich to me. It is rich that the other side will say, you know, why are we looking back at all? First of all, anybody that knows anything about history, you have to understand your past to know where you are now. Anybody that knows anything about what's happened, unfortunately, in this government over the past 4 years knows that we never want to do that again. We literally almost lost our America. It is nothing less than that. Think of what went on. Think of what happened with the IRS, how it was weaponized, the Department of Justice, how it was weaponized, the Attorney General's office, how it was weaponized, the FBI, how it was weaponized, Facebook, how it was used for censorship. And this isn't just this committee that uncovered it. Why did we do? Don't feel sorry for what we did. You should feel good about what we did, because this committee was integral in finding out and exposing and detailing all that was so wrong. We're losing our freedom of speech. You were getting in trouble for what you believed. We had, you know, it's unbelievable. And it isn't just the Catholic Church issue with the FBI. That was just one big issue, traditional Roman Catholic churches. It wasn't just what happened with FISA. Literally millions of times it was misused. It wasn't what just happened with the IRS. It's everything and everybody. If you disagreed, if you didn't want to go along, and if you weren't in the in-group was the president, his son, the cabal of people around him. Amazing how they slow-walked that case. You want to talk about IRS, you want to talk about something that's wrong, looking at records. How about we take a look at what happened with Hunter Biden after the president of the United States, Joe Biden, promised absolutely that he would never give his son a pardon. Of course, he pardoned him. And we talk about some pardons that President Trump did. There was over 8,000 pardons given by this past president, Joe Biden. What happened to America was awful. So we're going to detail some of that. And we are going to talk about some of that again. And we're going to talk about how to prevent it so it never, ever happens in our future again. But besides doing that, We need to make sure that the committee, and it's the right thing to do, both sides can have their voice, say what they want to say, and they're heard. And that was the purpose, I guess, of what we're going through now. But they could have done that in the report. They could put that all in as the minority viewpoint. So we're playing this out. We're playing it out for politics. We're playing it out. They're playing out to look good. They're playing it out to appeal to their base. And that's fine. But let's call it what it is. But don't talk about how things aren't good now. Everything's out in the open now, whether you like it or you don't like it. But what happened before behind closed doors to good people in secret was awful. And as I said before, and I do not exaggerate, it literally was almost the loss of the United States of America. With that, I yield back, Mr. Chairman.
Gentleman yields back. Ranking members recognized.
Thank you very much, Mr. Chairman. I rise in very strong favor of the amendment from the distinguished gentleman from New York. He says that he wants the language included in our oversight plan to focus on the Trump administration's decision to overrule a grand jury, the U.S. Attorney for the Southern District of New York, and senior officials at the Public Integrity Section at the Department of Justice in order to strike a corrupt bargain with an elected official charged with taking bribes and other illegal benefits from foreign nationals. How can the Judiciary Committee of the United States House of Representatives not look at that? In other words, we've got a grand jury indictment, a unanimous grand jury indictment in New York against a high-ranking public official for bribery, conspiracy, collecting other illegal benefits, and then when it's about to go to trial, the Department of Justice itself orders that the U.S. Attorney in the Southern District get the subpoena quashed, get the grand jury indictment quashed, and withdraw its investigation when it found there was probable cause to believe all these crimes had taken place. And the grand jury, as a matter of law, had to have found that there was probable cause to believe that all these crimes had taken place. And there's a 50-page plus indictment that went out in that case, and the grand jury the Attorney General or the Deputy Attorney General, Mr. Bove, insists that all of it be killed. Okay, now here's the extraordinary part. The U.S. Attorney for the Southern District of New York says no. Says, I won't do it. I would rather leave my job than to participate in something so corrupt as a deal to crush a corruption prosecution of a public official. I won't do it. And especially because I know why they're doing it. Because the president had a visit from that corrupt official or allegedly corrupt official in which he said, I'll play on your team. I'll do what you want me to do politically. And then the president said, fine, we'll withdraw the indictment. Oh, but guess what? We'll withdraw it without prejudice. Without prejudice, meaning we can reinstate it. And then as the distinguished gentleman from New York quotes, you've got Mr. Homan, the director of the border czar, Homeland Security, saying, yeah, and if you don't keep up your end of the agreement, you don't keep up your side of this corrupt bargain that the whole world's looking at now, then we're going to be, quote, up your butt to go and enforce the agreement. So guess who resigns? Republican colleagues, I hope your ears will perk up for this one. Guess who resigns? The United States Attorney for the Southern District of New York, Ms. Danielle Sassoon, a career member of the Federalist Society. She clerked for Justice Scalia. Justice Scalia, who I've heard our distinguished chairman quote many times over the years. So she said, hell no, I'm not going to do this. Then they go to the next guy, a decorated veteran, himself a Republican, also a Federalist Society activist. He clerked, check this one out, for both justices, Chief Justice John Roberts and Kavanaugh, when he was an appeals court judge. He clerked for Kavanaugh and Roberts, and he said, you've got to find a fool or a coward to go and crush this indictment. a fool or a coward, and he quit. And then 5 other people were forced out in this outrageous abuse of judicial process at the Department of Justice. And these guys don't even want us to look at it? No hearing? Suddenly, they strike a demure silence. No, they want us to go back and talk, I don't know, is it Hillary's emails or it's Hunter Biden's laptop? Maybe we can get Marjorie Taylor Greene to bring us some dirty pictures that she found on it. I don't know. This is a crisis in the justice system that this is taking place. An absolute crisis that this is going on. And it is a manifest illustration of the corruption that now pervades the executive branch of government. They are firing assistant U.S. attorneys, civil service lawyers, prosecutors, just because they worked on the January 6th prosecution and were assigned to do so. They asked for a roundup of FBI agents. My friend, Mr. Jordan, talks about a memo that was sent by the last Attorney General that didn't even mention parents or mothers and fathers. He's still talking about that. 5 years later, they're asking for the names of all of the FBI agents who worked on the January 6th investigation. I yield back to you, Mr. Chairman.
Gentleman yields back. Who seeks recognition? Gentleman from Missouri is recognized.
Thank you, Mr. President. Mr. Chairman. My colleague from New York referred to, quote, desperate attacks against Joe Biden. Does he even hear what he's saying? The libelous, bogus Russian collusion hoax, 2 utterly bogus impeachments against President Trump that he himself led the charge on, 88 criminal charges in 4 Democrat-controlled jurisdictions, 34 felony accounts on a highly contrived case in a venue where the president could not get a fair trial by a politically motivated prosecutor and judge. Ruthless censorship by the president, by Democrat-aligned or coerced social media, a SWAT raid on the president's home in Mar-a-Lago. Oh, desperate attacks against Joe Biden. Desperate attacks against Joe Biden. Why do we talk about the Hunter
Committee will be in order.
Why do we talk about the Hunter laptop? Because the Hunter laptop and many, many, many other facts suggest that the first family may well have been on the take from the Chinese Communist Party. Poor Joe Biden. Desperate attacks against Joe Biden. So I think we should look in the mirror when we start criticizing the work of this committee. And Mr. Chairman, I yield back.
Yields back. The question is on adoption of the amendment from the gentleman from New York. All those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it. The gentleman from New York has asked for a recorded vote. The clerk call the roll.
Mr. Jordan?
Nope.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgardner? Mr. Raskin? Yes. Mr. Raskin votes yes. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Aye. Mr. Liu votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Aye. Mr. Correa votes aye. Ms. Scanlon? Aye. Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Aye. Ms. Ross votes aye. Ms. Ballant? Aye. Ms. Ballant votes aye. Mr. Garcia? Aye. Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Aye. Ms. Crockett votes aye. Mr. Issa votes no.
Clerk report.
Mr. Chairman, there are 11 ayes and 11 noes.
The amendment is not adopted. Who seeks recognition? Gentlelady from Pennsylvania is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the Committee on
Without
the
objection, the
Judiciary.
amendment will be considered as read, and the gentlelady from Pennsylvania is recognized to explain her amendment.
Thank you. I've reviewed the oversight plan proposed by the Republican majority and find that it has some obvious but perhaps unsurprising omissions to the oversight plan for this term, which it is our constitutional duty to undertake. Because nowhere is President Trump's evasion of accountability and his desire to weaponize the government for vengeance and to promote unquestioned loyalty, nowhere is it more clear than in what's happening at the Department of Justice. The Trump DOJ has already fired hundreds of career prosecutors and FBI agents simply for doing their jobs. The same jobs that DOJ attorneys have been doing without fear or favor for over a century, regardless of which party is in power. Shamefully, as this amendment makes clear, the White House has specifically targeted thousands of veteran agents and FBI employees who helped investigate, identify, and arrest the people who violently attacked this building, the U.S. Capitol, on January 6th, and attacked hundreds of law enforcement officers. This is a clear attack on the rule of law to punish the people who were trying to enforce the rule of law, and therefore it attacks the foundation of our country. Not satisfied with threatening these law enforcement officers with firing, the president has put his seal of approval on political violence, so long as it supports him, by pardoning more than 1,000 of his supporters who'd already been convicted or pled guilty for their roles in that assault on our Constitution. So ultimately, these actions undermine morale and capacity among our federal law enforcement officers, threatening their ability to protect our communities and to respond to threats. The American people deserve a Justice Department that's guided by the rule of law and the public good, not political whims or petty vengeance. And I think all of this deserves oversight action by this committee. I would hope that my Republican colleagues can agree on these basic democratic and constitutional principles, and I would ask them to support my amendment to add this much-needed oversight to the committee's agenda. I yield back.
Gentlelady yields back. Who seeks recognition? I would just point out that, again, the proper placement of this amendment language is in the plan is in the section where the minority gets to express their views and their viewpoints. That would be appropriate, and I've said that now multiple times. With that, I would yield back. Question occurs on the amendment from the gentlelady from Pennsylvania. All those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it. Gentlelady requests a recorded vote. The clerk will call the roll.
Mr. Jordan?
Nope.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner, Mr. Raskin,
Aye.
Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Ms. Jayapal? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett?
Aye.
Ms. Crockett votes aye. Ms. Hageman, you are not recorded. Ms. Hageman votes no. Mr. Issa votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 12 noes.
Amendment is not adopted. Who seeks recognition? Gentlelady from Vermont is recognized.
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will report.
Amendment to the Committee on the
Without
Judiciary.
objection, the amendment be
Authorization.
considered as read. The gentlelady from Vermont is recognized to explain the amendment.
Thank you, Mr. Chair. I have an amendment at the desk, as I said. Today, we're considering the Republican majority's plan for an essential function of Congress, conducting oversight. It's one of the jobs of this committee. We should be all over the corruption in this current administration right now. But the plan offered by the chair, I believe, is deeply flawed. I'm offering an amendment to bring the oversight plan more in line with its purpose, which is, in fact, congressional oversight of the Trump administration. Elon Musk, a senior White House official, the world's richest man, and a prolific internet troll, is actively suppressing speech and promoting white nationalist propaganda on the platform he owns and actively controls. And let's be clear, Elon Musk is in many ways right now acting as president, and he also controls media. As a Congress, we are asleep at the wheel if we do not investigate Elon Musk. Special government employee Musk uses his own social media platform to promote anti-Semitism and anti-immigrant content. We have so many examples of this. Attack and discredit journalists and the media, and silence critics by suspending users with whom he disagrees. This is a man who claims to believe in the purest form of free speech, unless, of course, it contradicts something that he says. And while we're at it, I believe this committee should really use its time to investigate what is happening in the White House press room. The Trump administration has banned journalists from the AP because of a disagreement over what to call the Gulf of Mexico. This stupid, petty, small issue is getting in the way of something we all hold dear, I would hope, which is a free press. Trump then made the unprecedented move to take over the responsibility of deciding who gets into the room, a role that is previously reserved, again, for the free press, and the president is controlling which reporters get access. And it is let's just be clear. When you are controlling who gets access, when are you controlling who gets to report? This is part of a slide into authoritarianism. It's, in fact, straight out of Putin's playbook. So now only friendly reporters to the president will get to report on the president's propaganda? It seems like this is extremely ripe for an investigation into government censorship. I would hope that my Republican colleagues who have talked so passionately about the dangers of government censorship through tech companies would join me in supporting this amendment. I cannot see a plainer violation of the First Amendment, and I believe it is our duty on this committee to investigate. I yield back.
Gentlelady yields back. I would just add access to the media. He's the most media accessible president maybe in certainly my lifetime. People stand and do a press conference for hours. Like the idea that somehow he's hurting the press. I just fail to see that argument. But I would have a question for the gentlelady's amendment. It says page 8 strike collusion between the Biden-Harris administration and big tech to censor political speech. Are you arguing that that didn't take place?
I believe that the most important thing right now, in this moment, I do not believe that took place. I should put that out front. But I believe in this moment.
You don't think that happened?
I do not.
So the letter that Mark Zuckerberg wrote this committee, he was lying to us? That's a question. He wrote us a letter.
I cannot speak for
the letter was, I mean, the very news people you were talking about, the letter was all over the news. He wrote us a letter last summer and said, the Biden administration pressured us to censor. We did it. We're sorry. We're not going to do it again. And they've subsequently changed their policy. So I'm asking, you said you didn't think that happened. He admitted it happened.
Would the gentlelady yield?
Company runs the company.
Gentlelady yield?
I will.
No, it's not your time. It's my time.
Oh.
I will not then.
Yeah.
Turns out I can't yield.
No,
exactly. The gentleman yield.
You can't yield. I'll be happy to yield to the
Thank you. I just want to point
out
that what Mr. Zuckerberg was saying was censorship, in fact, was fact-checking.
That's right.
Which he decided that Meta would no longer do. Fact-checking, especially in an era when we have a president who lies incessantly, is essential. I yield back.
Well, I think it's interesting they got rid of the fact checker because the fact checker always turned out to be fact checking and stopping real speech that's protected under the First Amendment. So again, the proper place. Absolutely. First of all, you said you wanted to strike the language that's true, and you want to add in this other language. The proper place for this, as I've said again multiple times, is to put it in the minority views, which will be part of the oversight plan. But for some reason, that doesn't seem to be good enough for the minority.
Will the chairman yield?
Yeah, sure.
Just to pursue this point for a moment, this claim that this was fact-checking, wasn't this a suppression of New York Post reporting on the genuineness of the Hunter Biden laptop, which included the most incriminating evidence against a president involving family influence peddling that I think has ever been produced, and it turned out to be true. So what they were actually doing was suppressing facts, not checking them.
Suppressing facts and doing violation to the First Amendment and free speech rights of Americans. Who seeks recognition? Gentlelady, Ms. Crockett is recognized.
Thank you so much, Mr. Chair. It's so interesting to me that we all swear an oath to the Constitution. And we say that we take that oath seriously, but when it comes into actually doing something that looks like preserving that oath or looks like preserving the Constitution, we get a little wobbly, and I'm not really understanding what's going on. Freedom of press doesn't look like kicking out the Washington Post, or actually the Huffington Post has been kicked out. We know that the Associated Press has been kicked out, and now the Washington Post is not going to allow for op-eds in any way if for some reason they criticize the sitting president of the United States. What this is starting to feel like is a smaller version of Russia. And I am trying to tell you that we are nothing like Russia. We are not supposed to be like Russia, but that is what we've got going on. And I'm sorry, I know that some of my colleagues still struggle with answering the question of who won the election in 2020. And you may have felt a way when you had social media checking people and saying, no, Trump did not win the election in 2020. That is absolutely factual. And unfortunately, because some people got all riled up because they believed the lies, they ended up getting locked up because they decided that they were going to believe the lies. They ended up at the Capitol on January 6th, and they were trying to tear this thing apart because they felt like their country was falling apart in front of their eyes because for whatever reason, there were people in power that were peddling a lie about the election. We also know, and some of y'all may still say that COVID was a hoax. COVID wasn't a hoax. Tell that to the over 1 million people that died under Donald Trump's first watch. It wasn't a hoax. So no, I do believe that it was okay. In fact, I do believe that it was ethically right for social media to check people because you had people that didn't know anything about science and decided that they were going to put out whatever lies or propaganda or conspiracy theories they wanted to, and people died. At some point in time, we have to evaluate what is factual, and I know that facts hurt y'all, and I just wish we could get on the same page, but we do know during the presidential election that the president would not go and participate in anything if fact-checking was going to be a part of it, because he didn't want to be fact-checked. We know that the vice president got upset in his vice presidential debate when he was fact-checked. It used to be a time in this country that we as members of Congress or elected officials thought that it was okay to just tell the truth. Instead, we're pushing conspiracy theories, and some of them are killing people. It's the same thing that we have coming out of DOGE. It's the reason that people are dying. It's the reason that farmers are losing their farms, because we continue to peddle conspiracy theories. It is time for us to say, Mr. President, guess what? Russia invaded Ukraine. Can we at least agree on that one? Facts matter. Y'all, this is literally potentially putting us into an international crisis. We may be heading towards the next world war because we have a president that wants to pal around with Putin and wants to do everything to make him feel good, including lying about who invaded who. Mr. Chair, I got a minute left, but I really want to yield to any of my colleagues and ask them if they will say today, very basically, that when it came down to the war in Ukraine, that it was not Ukraine that invaded Russia, it was the other way around. Is there anybody in here that has enough courage to say that Russia invaded Ukraine?
You can have my time.
And this is yet the problem. This is the problem. That is not infringing upon free speech.
Will the gentlelady yield?
I will yield to the right.
Thank you, Ms. Crockett. To be clear, your challenge, I think, was across the aisle, because I think every member on your side of the aisle agrees with the obvious fact that Vladimir Putin ordered the filthy, bloody, imperialistic invasion of Ukraine. And in fact, at the time, Donald Trump as president never denied it. In fact, he praised it. He said it was, quote, an act of genius when Putin ordered the invasion of Ukraine. So I would hope some of our colleagues would consent to at least that historical point, since we think history is so important. There are people who want to relive that in our oversight report.
And therein lies the problem.
The time of the gentlelady has expired. The gentleman from California is recognized.
I'd yield to the chairman.
I just wanted to make a point. We talked, gentlelady, previous speaker talked about factual information. We've talked about fact-checking. Fact-checking, you know what fact-checking is truly supposed to be in this country? The First Amendment. Not some expert who can sit on and look at posts and tweets and different things and say, oh, that's not factual, take it down. That's not how it works. Fact-checking is the First Amendment. Someone says something stupid, and that happens every day in this Congress. Someone says something crazy. Someone says something that's not quite true, not quite accurate. You know what the fact check is? Someone says something else, and you have debate. That's what we do in this committee every day. And this is the committee who's supposed to protect that fundamental fact. Real fact checking is the First Amendment. Our Supreme Court has been clear about that. You don't like certain speech, the best speech for wrong speech is more speech. The best speech for false speech is true speech. That's how it works. You have a debate and you trust we, the people, to figure it out, not some expert who's going to fact check every tweet, every post. And we saw this in the Biden administration. We're seeing it in Europe now. We're seeing it in Brazil. That was the first bill we dealt with from the gentleman from California, his good legislation that we all agreed on. We're going to work on and put a good bill on the floor. So that's the key. That's what And we know it happened because, again, we had the guy who runs one of the biggest companies in the world, most successful tech companies in the world, tell us it happened. We had on the third day of the Biden administration an email from the White House to Twitter saying, take down this tweet ASAP. The government telling a business to take down a tweet. And the tweet, ironically, was from RFK Jr., who was going to be running for president against the guy in the White House. So he was saying, take down the speech of my opponent. That's not how it's supposed to work in this country. That's what we're concerned about. That's why it's in our oversight plan. And if you want additional things to look at, again, put them in your viewpoints. We're happy to accept them. We'll take everything Mr. Raskin has said today, everything the gentlelady from Texas has said today. We'll take everything the Democrats said. You want to put all that in your plan? Put it in your plan. That's fine. That's how it works. But no, that's not good enough. That's not good enough. I yield back to the gentleman from California.
I thank the gentleman, and back to the point of what the chairman was saying, we have two plans, not one plan. We have the majority plan, which is the committee's plan. The minority report or opinion reflects additional items asked for. And this committee does have a long history of, when appropriate, granting minority days, minority hearings, or in every case, including a minority witness when it's not like it was with obviously with the judge on a specific item. But we do that so that both opinions are heard. And I applaud that tradition. I will say that the one thing that was originally said by the gentlelady that I have to take umbrage with, there's no such thing as settled science. The fact is, a fact is, that there are often multiple competing ideas that each claims as a fact. The chairman said rightfully so, the best fact check is the other opinion being heard and documented in a way in which people may judge the authenticity of it. The gentlelady, Ms. Crockett, said, COVID killed millions, and so there's an undeniable fact. When we were here in the midst of that beginning crisis, and Dr. Fauci hid the fact that it came from a lab in China, hid the fact that he had paid for gain of function, and caused us to believe a lot of other things, some of which turned out to be true, some of which turned out not to be true. And maybe some more will be discovered that will modify what I just said. But freedom of speech is about never having to accept that the earth is flat or that Asia was discovered by Christopher Columbus. We have the ability to continue to have discussion, and we should do it. Our oversight plan absolutely lives up to that expectation. That's why I'll support it. Mr. Chairman, I yield.
I appreciate the gentleman yielding a second time. I would just point out the gentlelady brought up the COVID, and so did the gentleman from California. I would argue almost everything he told us turned out to be false. Not just where it come from, not just gain of function issue, not just the fact that it was our tax dollars used at that location where it came from, but everything else he told us. He actually told us that people who got the vaccine couldn't get the virus. Wrong on that. He told us people who got the vaccine couldn't transmit the virus. Wrong on that. He told us masks work. Wrong on that. He told us this was the first virus in history where there's no such thing as natural immunity. Wrong on that. Almost everything he told us. And if you questioned it, you got censored by the previous administration. What we're saying is no, let the debate happen. We're not saying you can't say the wrong things, Dr. Fauci. But what we are saying is don't censor the people who disagree with you, because that's how America works.
And Mr. Chairman, everything you just said, if you had said it when you said it in real time, was in fact taken down or ratcheted down. I yield back.
Exactly. Gentleman from Maryland is recognized.
Mr. Chairman, thank you very much. I'm inspired by your First Amendment passion. You are the
I knew you would be.
You are the John Stuart Mill of the House of Representatives and the Voltaire of Congress, and you put me in the mood of Justice Brandeis. But I want to ask.
Stop there.
No, I got to keep going a little bit, because I have to know whether or not your First Amendment passion and principles, which I take to be completely true, and I've always known that about you, extend to one citizen named Donald Trump. Now, let's talk about Donald Trump for a second, okay? He is, after all, I think, the President of the United States. And check this out, okay? everybody in this room who's sitting on this side of the dais is a politician, okay? We have people say stuff about us and say stuff about our rivals and our opponents all the time. I don't know if there's anybody here who's ever sued anybody in politics for libel or defamation. I'm taking that no. I imagine a lot of us have felt like, have you? Well, I'll be curious to hear about that later, Mr. Issa. But the vast majority of us don't sue people even when we feel really aggrieved by the mean things that people say. And yet, Donald Trump gets to be president of the United States, and suddenly he decides he doesn't like Jim Jordan's approach, which is the answer to bad speech is good speech. The answer to false speech is true speech. The answer to nonsense is the dialectics of expression. That's the spirit of the First Amendment. Well, check this one out. Donald Trump personally suing CBS for $20 billion. The president of the United States is suing CBS for $20 billion. Why? What did they say about him? Did they lie about him? Did they defame him? No, it has nothing to do with him. It has to do with the way he thinks they unfairly edited a video conversation with Kamala Harris. He said that the way the video looked in the commercial for 60 Minutes was different from the way she appeared. The president of the United States is suing them for $20 billion and ordering the FCC, which is part of the U.S. government and under his unitary executive theory, reporting directly to him like a monarch. He's ordered them to go out and investigate CBS. And meantime, his close friend is trying to take over Paramount. And so he's, of course, completely entangled on the business side. That's not the first time. He did it to ABC with George Stephanopoulos, which settled a suit for him for, I think that one was $15 million. The president of the United States is shaking down the media. Would you guys really be so silent and taciturn about this if it was Joe Biden doing that? Honestly, I'm just waiting for one person to answer me honestly about it. Would you guys be okay if Joe Biden had been the one who had said destroy a grand jury subpoena against the Democratic mayor of New York for corruption? Would you be okay with that? But suddenly, because it's Donald Trump, you don't want to do oversight on it. It's the most amazing thing in the world. And there are young people watching, and this is the US government. And we're going to be silent with all of these attacks on the First Amendment where the president is saying, I don't like the words you use. I want you to say Gulf of America, not Gulf of Mexico. Associated Press is now banned from this room. I'm kicking you out. I mean, come on. This is the United States of America. Will any of my friends over there, all of whom understand and love the First Amendment, say it should apply even against the President of the United States? And I know you voted for him, and you'd vote for him again if the Constitution changes and so on. But leaving all that aside, does the First Amendment not apply to him? So I find that we are in an astonishing situation right now.
Will the ranker yield?
I would gladly yield to the gentlelady from Texas.
You brought up the Gulf of Mexico, and, you know, I just left and I was talking about facts versus fiction. I'm curious to know, do y'all agree that it's the Gulf of Mexico? Can we say that that's a fact? Are any of y'all willing to say that it's the Gulf of Mexico instead of Gulf of America?
Well, but reclaiming my time, I would say that these days, that's a matter of opinion. It's a matter of fact from the standpoint of objective sources. But if people want to say it, that's great. I would never kick them out of the room for saying something different. But that's what's happening with Donald Trump. He's kicking people out of the room and punishing them, subordinating their role as press because they're not complying with his orders. That's not the First Amendment. I yield back, Mr. Chairman.
Gentleman yields back. Gentleman from Arizona is recognized for unanimous consent.
Yes, Mr. Chairman, I would like to submit for the record this rather ironically titled document. It's actually put out by the Associated Press. It's a little old, it's a little dated, but I just do think it's ironic anyway, nonetheless apropos for today. It's called Report, Obama Brings Chilling Effect on Journalism.
Without objection. The gentleman from New Jersey is recognized.
Thank you, Chairman. I'm trying. I am trying to be quiet. I just can't do it. I mean, I couldn't do it. Didn't do it so much. First of all, let's just go over some of the things that were mentioned real quickly here. Ukraine. Let's really remember what happened in Ukraine. Joe Biden was president. Russia was making noise, saying that they were going to, and they did, were moving some troops, moving some equipment into the borders of Ukraine. Joe Biden said it was a minor incursion. No worries, nothing to see there. It was that weakness that created the mess and the war, the horrible tragedy that exists now. It was the weakness of a president who didn't deal with an issue head on. That happened before. It happened when President Trump was the president in the previous administration before Biden, and he absolutely made it clear, you do that and you got big trouble on your hands. Mideast, Iran, we empowered Iran, literally, which is the evil empire. Empowered it, catered to it, did anything we could to cajole, didn't do anything to stand up to it and tell them they better damn well cut it out, unfroze their assets. So now we ended up with a war in the Mideast, a weak administration and a weak president. And then we talk about fact-checking. That was the other thing that came up. Let me tell you, somebody's facts over there in reality are censorship. I mean, whatever you say, everybody should have an equal voice and everybody should be heard. I got to tell you, man, I just remember from things I've said, meetings I've been at, speeches I've given, when it's covered by some of the legacy media, it's just not what you hear and it's not what you see. Because the reality that the legacy media, CBS, NBC, ABC, the New York Times, the Washington Post, they're not telling it as it is. You're not getting both sides. So, of course, when you have a press corps in the White House, you want to give a chance to some of those who never get heard, other than Americans are thirsting to hear the truth. Why the hell do you think people aren't watching ABC, CBS, NBC, and reading these newspapers anymore? Because they know it wasn't the truth. They know it wasn't the real deal. They know they weren't hearing the real story. And you know what? It even applies to things that we know from the good work that was done in this committee. Remember Russian collusion? Man, I remember Russian collusion all over the media. Every TV station, they all had the same script. The newspapers, they all had the same script. The magazines, whatever media it was. And it wasn't true. The damn thing wasn't true. But when it came out in an objective report, the Durham report, that it wasn't true, somehow you never heard about that. It was never heard. It was crickets, man. Nobody talked about it. The truth is that the FBI paid a guy, Igor Danchenko, a bad international actor, hundreds of thousands of dollars to lie. He did his job. He lied. He did his job before the election. And then, of course, now admits that he lied. And the FBI is embarrassed and apologized. But you don't hear that. Boy, we don't hear it. You don't hear it now. You didn't hear it then. So, of course, we want to have other voices in the White House. You want to hear it all. You want to hear the conservatives. You want to hear the liberals. You want to hear the middle of the roaders. Fact-checking. Hey, you know, fact-checking, how come there wasn't fact-checking when the 51 former intel officers said that the laptop was non-existent? There was no such thing. Man, that was all over the news. I remember watching TV, reading, seeing it everywhere, hearing it everywhere. 51 former intel officers said that it wasn't true. And damn it, it was true. And COVID, in some cases, and you know what? I'm one of the few, there's a few of us here that sit up. I was trained in medicine. I'm a dentist. Went to 9 years of school, including a residency. A lot of what happened in COVID was wrong. The way we dealt with it is wrong. Our children have still been held back that should have been in school during those years was wrong. Some of the treatments were wrong. That it came from a wet meat market in Wuhan was wrong. It was a lie. Fact-checking, man, real fact-checking, I guess, would be a good thing. But let the people decide. Let them hear both points of view. Let them hear the debate like we're doing today. and then let them make their mind up. And you know why? That's why Americans more than ever, they're looking at podcasts, they're getting online, they're looking at X, they're looking at whatever it is, liberal, conservative, everything in between, because they know what was supposed to be truthful, what was supposed to be fact, indeed was often fiction and was a lie. And they're tired of it, and everybody should be tired of it. I yield back.
Gentleman yields back. Question occurs on the amendment from the gentlelady from Vermont. All those in favor say aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it.
Recorded vote, please.
Recorded vote being requested, the clerk will call the roll.
Mr. Jordan?
Nope.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Harris? Mr. Onder? Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgardner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Aye. Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett?
Aye.
Ms. Crockett votes aye.
Mr. Chairman, how am I recorded?
Gentleman from Missouri.
Mr. Onder, you're not recorded.
Votes no.
Mr. Onder votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 10 noes.
The amendment is not adopted. Who seeks recognition? Gentleman from Georgia is recognized.
Mr. Chairman, I have an amendment at the
Clerk will report.
Amendment to the
Without
authorization.
objection, the amendment will be considered as read. The gentleman from Georgia is recognized to explain his amendment.
Thank you, Mr. Chairman. I would, before explaining my amendment, I would like to remind my colleagues that there is a commandment that I learned growing up as a child in the home, going to Presbyterian church, and it was that thou shalt not bear false witness against thy neighbor. In other words, it's wrong to lie. And there is truth, and sometimes the truth is hidden, but the search for the truth is certainly worthy of discussion. But when you're simply trying to obscure the truth, parading as you are spinning truth, which you know is not truth, which you know is deceptive, is wrong. And but I have an amendment which I would like to, on page 9, strike, quote, the unwarranted attacks on and threats on the Supreme Court, end quote, and replace it with this language: the need for an enforceable code of ethics at the Supreme Court and threats of impeachment, removal, and physical violence against federal judges who rule against the Trump administration in ongoing litigation. As ranking member of the Subcommittee on Courts, Intellectual Property, Artificial Intelligence, and the Internet, I'm invested in maintaining the integrity and safety of our judicial system. As Alexander Hamilton wrote in the Federalist Papers, quote, The judiciary has no influence over either the sword or the purse, end quote. So it's essential that our judges and justices hold themselves to the high standards that will engender public trust. It's also essential that we protect judges' ability to rule according to the law, even when that angers the president. Democracy can only continue if we respect the rule of law and ensure the court's ability to rule without fear or favor, which is why I offer this amendment. Some on the other side of the aisle have dismissed my calls for an enforceable code of ethics at the Supreme Court. They view it as an unwarranted attack on the independence of the court. But when fewer than half of Americans have a favorable opinion of the court, we have a problem. One piece of fixing that problem is to require, as we have the authority to do, and indeed the responsibility of doing, is to require that the Supreme Court justices follow a code of conduct that is at least as strict as every other federal judge, so that the public can trust that they are ruling according to the law, rather than ruling in a way that benefits those who have purchased luxury RVs and send them on luxury vacations yearly and hunting trips to exclusive resorts. The American people don't want those kinds of justices making decisions on ultimate issues that impact their lives. My amendment also calls for investigations into threats of impeachment, removal, and physical violence against federal judges who rule against the Trump administration in ongoing litigation. Just this week, Representative Ogles introduced an impeachment resolution against a federal judge who had the temerity to rule against the Trump administration. And earlier this month, Representative Crane introduced articles of impeachment against another federal judge who temporarily blocked co-president Musk's DOGE organization from rifling through the Treasury Department payment system. This filing articles of impeachment to terrorize and intimidate federal judges is wrong, and it needs to end. It's dangerous, and the courts serve as a check on the other branches of government, and they should not be subjected to terror and intimidation as members of this, as members of the opposite caucus are trying to do. And so to make sure that we investigate those offenses, that's why I offer this amendment, and I hope that it is acceptable to my friends on the other side of the aisle, and with that I will yield back.
Gentleman yields back. It is not acceptable to your friends on this side of the aisle. Again, I think the proper place for the language that the gentleman wishes to insert is in the minority views. Who seeks recognition? Question is on the, I'm sorry, the gentlelady from Texas is recognized.
You know, it's interesting because I feel like I keep going back to elementary school and a lot of conversations that are taking place to basically educate people on the fact that we have 3 co-equal branches of government. And right now, when many of us say that we're in a constitutional crisis, it is because we feel as if the executive branch is being enriched of power that it should not be enriched in. And part of that consolidation of power is because, unfortunately, so many colleagues on the other side of the aisle seem to have pledged more loyalty to Trump than they did to the Constitution. But here it is, we're 3 co-equal branches of government. The last time I checked, we have an ethics that we are to be held to. We have a process, a due process, whenever there is a concern about our ethics in the House. There's a code of ethics that the Senate has to deal with. And so why it is, and the judiciary as a whole, it's the Supreme Court that is lacking. And here's the reality. The tables can turn any day. This is what I want you to imagine. Imagine that Planned Parenthood, I know how y'all love Planned Parenthood. Planned Parenthood says, you know what? Judge, let me come pick you up. So they pick you up on the Planned Parenthood plane. It's pink with Planned Parenthood all over it. And they take you on these fancy trips. And the next thing you know, there is a case that comes before the Supreme Court, and it has to do with whether or not a woman should not be a part of the Handmaid's Tale and should have a right to choose what she does with her body. But nevertheless, all of a sudden we see that there's this link between the justices that vote for this particular case and the justices that ended up on that Planned Parenthood plane. Now, I'm guessing if that happened that y'all would be in an uproar, but I could be wrong. And so what I'm trying to say is that what has been proposed is actually what we should be doing in this Congress. This isn't about politics. It shouldn't be about politics. It shouldn't be about party. It should be about what is right and wrong. That is what ethics is in the first place. Ethics is what's right and what's wrong. And so if we have to be beholden to ethics, and if every other branch of government has some kind of ethics, why is it that the highest court in the land would not have a level of ethics that they had to abide by to make sure that we could all trust the decisions that were coming out of our high court? These are decisions that literally change lives. Some people lose their lives. Some people lose their rights. Some people gain their rights. We should have trust in the system. And right now, people don't trust us because it's like we turn a blind eye when it's our side. This shouldn't be about our side. Ethics should be something that we all say, you know what, ethics are good. When we look at Elon Musk and we're talking about the fact that he has conflicts of interest, that would go to ethics. We should all have concerns about this. This is the only thing that Hank is trying to do with this amendment. And guess what? It wouldn't just apply to the Republican appointees. It would apply equally to the Democratic appointees as well. And I will yield to the ranker.
Thank you very much, Ms. Crockett, for those comments. And I want to pick up with where you left off when you said it shouldn't be a partisan thing. And, you know, I was thinking about this terrible situation that we've got with Mayor Adams and the Department of Justice dismissing a grand jury indictment. Now, we could be taking the partisan instinctual position on our side of the aisle and say, wait, that's a Democratic mayor who's being charged with bribery and conspiracy and corruption charges. Don't talk about it. Just let this dirty deal go through. Let's be silent about the corrupt bargain. I've not heard a single Democrat say that. Not heard a single Democrat. And yet our colleagues are willing to be completely silent about this corrupt bargain, this dirty deal, because the Republicans are running the Department of Justice. But it's the Department of Justice, and we're the Judiciary Committee, and we're supposed to be standing up for the objective principles of the rule of law, as the gentlelady was saying. We've got the opportunity here with that because it's bipartisan corruption that's being fostered by a Republican president and DOJ and a Democratic mayor in those defending. We have the opportunity to clarify for the country that we stand up for the rule of law together. Thank you for yielding, and I yield back to the gentlelady.
Time of the gentlelady has expired. The gentleman from Arizona is recognized.
Mr. Chairman, I just have a UC.
Gentlemen, we can say this unanimous consent request.
Yes, thank you. This is from Newsweek. Schumer telling Brett Kavanaugh he'll pay the price for Roe, where he said in there, you won't know what hits you if you go forward with these awful decisions, and those threats that he made.
Without objection. Gentlelady from Wyoming is recognized.
Just a couple of points to make here. Contrary to what the proponent of this particular amendment states, the courts do not serve as a check on the other branches of government. They serve to interpret the law. We are a co-equal branch of government with the courts and the executive branch. One other thing is that the federal court system is the third branch of government, and we do not have the constitutional authority to dictate the ethical rules that the Supreme Court follows any more than that the Supreme Court would have the constitutional authority to dictate our ethical rules. With that, I yield back.
Well said. Gentlelady yields back. I think we can go twice with it. Since you're the ranking member, you get to recognize twice.
Actually, I don't think I've been recognized. I was yielded time, but let Mr. Iapolo go first.
Thank you. I rise in support of this amendment from Mr. Johnson. We've both done a lot of work on Supreme Court ethics and transparency. And in the proposed oversight plan, my Republican colleagues are claiming that there are, quote, unwarranted attacks on the Supreme Court. I just want to make the point that these are not unwarranted attacks. I think Americans across the country would be shocked, absolutely shocked, to know that the highest court of the land is the only court that has no enforceable ethics standard. I think most Americans think that the Supreme Court has an enforceable standard of ethics. And I think we need to let people know that that is not the case. It is a well-documented crisis that we have right now. Justices Thomas and Alito have run afoul of the ethical standards that I think the American people expect from them and expect that they are being held accountable to. And I'll just touch on a few facts regarding Justice Clarence Thomas. The justice for years has accepted trips from GOP mega donor and developer Harlan Crow, including on his private jet, his super yacht, without disclosing them on financial disclosures as federal law requires. I actually think that's lying on your federal disclosures. Crow has also paid 2 years of tuition for the justice's grandnephew, whom the justice has custody of, so that the grandnephew can attend 2 private schools. And these payments similarly were not disclosed. The justice also sold a string of properties in Savannah, Georgia to Crow in 2014, including the home where his mother still lives. This again was not disclosed. The justice attended at least 2 donor summits for the Koch network and the Koch brothers and participated in a dinner with high-level donors without disclosing his appearance at the summits or a private jet trip that he took to and from the event in 2018. I could go on, but I do think the American people do not like corruption. They don't like conflicts of interest. They want to know that if a justice is on the Supreme Court, the highest court of the land, that that justice is not being bought and paid for by a whole bunch of donors that appear before the justice in a number of varied suits. And I think that the idea that we would have an enforceable ethics standard for the Supreme Court is one that I bet the vast, vast majority of the American people would agree with. So I don't think it's beyond the scope to say if the justices themselves refuse to even put into place an ethics standard that is enforceable by an outside enforcer, then we need to, in Congress, make sure that that happens. Now, I also would say I'm confused by the previous speaker on the other side's statement that, I don't want to misquote her, but my understanding was that she said that the judicial system is not a check. I didn't understand that because in my reading, and I think every 5th grader knows this, there are 3 branches of government, and those are the checks and balances. The Congress has specific Article I powers. The Congress has specific checks on us as well. The judicial branch is a check on Congress, and I think the American people expect that these 3 branches of government will interact in a way that provides certainty to the American people, that their interests are being protected, that none of us is exceeding our authorities, and that there are checks and balances built in. The only problem with the checks and balances, as I'm seeing it right now, and it goes back to the free speech conversation we were having in the previous amendment, it goes back to a number of things that are happening with the funding freezes and the illegal appropriation of authorities around funding, which are congressional authorities, Article I powers, that we have to authorize and appropriate funding that cannot be taken away by the executive. The challenge is the Founding Fathers were great, but they weren't completely all-knowing. They actually expected that people on both sides of the aisle would stand up for those powers and for those checks and balances. They did not expect people in Congress to so easily give away Article I powers because a president tells them to. They didn't expect that there would be all of these instances where people would defend behavior that is corrupt and is unethical. They thought that we would all stand up for some of these basic premises. So I support this amendment and commend my colleague from Georgia for offering it. I yield back.
The gentlelady yields back. Gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. Just quickly, the ranking member referred to, he didn't use these words, so I'm going to use these words, almost the purity of the Democratic Party in that it is criticizing Eric Adams, who was a Democrat mayor of the city of New York. You know, I just want to give my viewpoint. I would maintain that criticism began when Eric Adams, as he did over months, really started to criticize what was happening to his city with illegal immigration, what was happening again in other ways, and expressed real concern about some of the immigration issues, what it was doing to the kids in school, and a whole lot of other issues. I would maintain that if Eric Adams was doing that with a Democratic president, it probably wouldn't have been a problem at all. And I also think of Elon Musk. Elon Musk was a Democrat hero. He was the electric car guy, charging stations everywhere, you know, the whole bit. And you know, it used to be, it's not true anymore, but it used to be if you saw somebody driving one of his vehicles around, you figured they were probably a Democrat. Now, I admit that's changed. So I don't know if, you know, forgive me to the ranking member, but if it's a purity thing or if it's just more of a practical thing, once individuals start working with or are part of the Republican Party or a Republican administration or agree with some Republican values, then they no longer have value and they are no longer good people. With that, I yield back.
Will the gentleman yield?
I yield to, yes, to the chairman.
I thank the gentleman for yielding. Again, I just want to look at the amendment itself because this is, I think, a pattern in the amendments from our friends on the other side. They talk about what they want to insert into the oversight plan, but I think now at least a couple of amendments, maybe all of them, yeah, they all start with striking language we have in the plan. And so I would ask the question, they want to strike on page 9 the unwarranted attacks on and threats on the Supreme Court. And I would ask the question, do they not think there were attacks on the Supreme Court?
Would the gentleman yield?
Be happy to yield.
Yes, certainly.
Well, it's Mr. Van Drew's time, but Mr. Van Drew, yield to the gentleman? Okay.
Yeah, the language that I seek to replace would pretty much essentially include the same language. It's just restated in my language, which would include also, on top of physical violence against federal judges.
Well, let him finish that.
Yeah, it would include the need for an enforceable code of ethics at the Supreme Court as part of this committee's oversight responsibilities. I think it's a legitimate place to add that language, and the only question is whether or not my folks will, on the other side, will accept that language.
Well, but that's not accurate.
I'd be willing to leave the language that I seek to strike in, if you would agree to add
2 points.
The language that I'm offering.
2 points. First question was, do you believe there have been unwarranted attacks on the Supreme Court? Does anyone not believe that that's happened? I mean, there was an assassination attempt on Justice Kavanaugh. So we know that's happened. After the leak, something's never happened in the history of the court, the leak of the DOGE opinion. But to the gentleman's point that his language would cover what you're trying to take out of our language, that's just not accurate. Because when you read it, it says the need of enforceable code of ethics, which Ms. Hageman addressed, and threats of impeachment removal and physical violence against federal judges, then you have the qualifying language, who rule against the Trump administration ongoing litigation.
Well, Mr. Chairman,
it's not about
I would
threats of
gladly.
violence. It's not your time. It's gentleman from Mr. Van
And
Drew's
he
time.
yielded to me.
No, he didn't. He yielded to me. So you have the qualifying language in there. So you're getting rid of what we know happened. Yeah. Unwarranted attacks on the Supreme Court where they were someone tried to assassinate Justice Kavanaugh. We all remember. They had to have all kinds of security protection around our Supreme Court justices in the aftermath of the leak of the Dobbs opinion. So that's why we have the language in there. If you want this language, which does not cover what we have in ours, if you want it in yours, if you want that language in the plan, put it in your minority views. Again, we've said that, I think I've said that maybe 10 times today, because that's the appropriate place to put it. With that, I yield back to the gentleman from New Jersey. Gentleman yields back. Gentleman from...
Go to California.
The gentleman from California is recognized.
Thank you, Chairman, and I'll yield to the gentleman from Georgia.
Thank you, Congressman. I would gladly delete from my amendment the scratching out of the language that is in the majority language, and just simply offer to add the language that I have offered as a way of moving us forward. And so the question then becomes whether or not my friends on the other side of the aisle want to bind themselves to look at the need for a binding Supreme Court code of conduct with an enforcement mechanism. That's what the question becomes. Is that an acceptable amendment to my amendment that would cause my colleagues on the other side of the aisle to support it?
And reclaiming...
And if not, why not?
Yep. I'll yield. Yes, go ahead, Mr. Rice.
To my ranking member, we have in the past, as you know, we've had things related to the court, and it is fully within our subcommittee's plan to have a ongoing and a thorough review of the overall state of the ethics, honor, and accuracy of the court, which would clearly include the question of judges that have been disciplined, haven't been disciplined, should be disciplined, and so on. And I'm happy to work with you thoroughly on that because I believe every Congress, we should look at that and the question of oversight. And as you know, in the last Congress, we actually created a better mandate for the court reporting their financial disclosures, one that we, gentlelady and I are very proud that we said, look, we're only asking them to have the same level of transparency that the other two branches have, and they have acquiesced to that. So I look forward to working with you on it. I think there is a lot to do about striking versus not striking. If you have things like this that you want to make sure we look at, please put them in your plan, or at least tell me, and if they fit within the plan, we will do them.
Well, reclaiming to the
I'll
extent,
reclaim my time and yield to you.
that I can. You know, it's better to have the language actually in the majority's language, because then it gives, it's something that you will not ignore, as you will ignore what we write in our proposal. And so just for the sake of ensuring good governance and fair play as we move forward, I'm just simply asking that we include that language and actually embark upon a oversight of a need that is glaring to protect our third branch of government from itself, actually, because the longer that they proceed without a code of conduct and the longer that corruption continues to infect the court as it has, the worse it gets in terms of the public confidence and trust, the erosion of it. That's bad for our democracy. And so this is a good sense, good faith effort to protect our democracy. And I hope that my friends on the other side would accept my offer to leave their language in, but simply add our language. And with that, I owe you back.
Sure, reclaiming my time. I support the gentleman's amendment, but I also support the amendment to the amendment because I don't think any of us here want it to appear that we don't condemn violence against judges, whether it's a Republican-appointed judge or a democratically appointed judge. What Justice Kavanaugh went through is wrong. He shouldn't have had to go through that. His family should not have been subjected to that. And likewise, for many of my colleagues, some of them who are here, who receive death threats every day because of doing their job. But I think what Mr. Johnson is saying is that the American people, for the first time in our lifetime, have dramatically lost faith in the courts, and they have abused the right to police themselves. They're not policing themselves. And when you see justices who have spouses who went to a rally on January 6th and organized a rally on January 6th, and then that justice is hearing a case about January 6th, that betrays their oath to recuse when they have a conflict of interest. And then, of course, the trips that were just referenced by my colleague, Ms. Jayapal. So I think we're being reasonable here. And I support the gentleman's amendment to the amendment and yield back to the chairman.
Gentleman yields back. The ranking members recognize, and I'll go to Tennessee.
Okay.
Wait. Unless ranking members recognize.
Mr. Chairman, thank you very much. I want to speak in really strong favor of the gentleman from Georgia's amendment. Before I do, I just want to respond to my friend from New Jersey, who I think taxed me with only opposing corruption in my party if the person is some kind of policy apostate or heretic. And I could mobilize a number of, I think, refutations of that. One comes from your state. Senator Menendez is someone who I don't think was any kind of policy apostate from the Democratic Party, but when he was indicted, I took a very strong position that he should leave office. So I just don't think it's true that everybody around here is a partisan robot, whether they're in the Democratic Party or the Republican Party or both, or either at different times. I think that there are people who try to stand on principle as much as they can. I'll give you another example. I know a lot of people on my side of the aisle and a lot of people on your side of the aisle voted to expel George Santos before he was either given the benefit of due process in a criminal conviction or before he went through our civil process here of ethics. And I voted no, and I spoke strongly against that, regardless of the fact that, that was a chance to score party points. So maybe we'll get to know each other better and you'll think a little more highly of me than that. But look, the gentleman from Georgia has raised a profoundly important point here. Again, this is the United States House of Representatives Judiciary Committee. We have a crisis in ethics at the Supreme Court that's acknowledged by huge majorities of the American people and people on both sides of the aisle. They don't have a binding ethics plan. The highest court in the land has the lowest ethical standards. And so we can get into the specific individuals if we need to do that. I think a couple of my colleagues talked about Justice Thomas, who had taken luxury trips all over the world, island hopping on a yacht with his friend Harlan Crow. He received a high-end motor coach that was originally part of a loan of $267,000 from another millionaire or billionaire friend that got forgiven as a loan. This is a high-end motor coach that had a kitchen, a dining room, and a bedroom inside of it. I can't even quite picture that. But in any event, he didn't pay anything on it, or maybe he paid for the first few months and then he stopped paying, and they forgave the loan for $267,000, and it was never reported on his taxes as a gift. And every lawyer on this committee, indeed everybody on this committee, knows that an unpaid forgiven loan becomes a gift, which becomes income to you that's got to be reported. But in any event, the point isn't this or that member and their various entanglements. It's that there's no process by which people can raise ethics violations on the part of the Supreme Court. And Mr. Johnson has been singing this tune for a long time now, that the Supreme Court needs to have a binding ethics plan at least as strong as United States District Court judges, at least as strong as United States Appeals Court judges. In fact, how many of us come from states where there is a binding ethics plan for the highest members of the judges on our state Supreme Courts? All of us do. All of us come from states like that. So that's the kind of thing that really should be bringing us together in this time of utter ethical, moral, political, and constitutional danger and collapse that's going on. Let's restore standards. Let's improve our standards so we can deal with the crises of our day. And I don't know if Mr. Johnson needed any more time. Oh, Ms. Crockett, always available. I yield my time to the gentlelady from Texas.
No, you know what? You always spark so many things in my mind. That's the professor in you for sure. But I will say that when I think back to law school, I think about the conversations that we had about Lady Justice being blind. And the one thing that I would challenge my colleagues to is, I thought about what you said about George Santos, but I would say, if you put these issues on paper and didn't put a name, didn't put a party, where would you stand? Because at the end of the day, I can guarantee you, if someone gave me $267,000 as the lies have been floating around, that I somehow now have an extra $9 million lingering around and an extra 3, cribs, this is not factual. but this is on X, of course, because that's what they do, is they put out lies in order to disparage people. But I'm saying if I somehow had an extra almost $300,000 and y'all found out that somebody, let's say George Soros, because y'all love to throw his name and stuff, George Soros gave me an extra $300,000, y'all would kick me out of Congress. That's just the bottom line. So my deal is, if you would kick me out of Congress for it, then you should take issue with it. So maybe what we should start doing is looking at the scenarios and removing the names and removing the political affiliation to determine whether or not there is an ethical issue. Because it shouldn't be an ethical issue if it's only one of us.
The time of the gentleman has expired. Gentleman from California is recognized, and I'll come to CC.
Mr. Chairman, I'll be brief. It is interesting that we're having this expansive debate on something that could simply be added to the minority views, and we've already said we would participate in a hearing related to this in an expansive at the subcommittee. But I have to look at my colleague, the ranking member, and laugh a little. You brought up Bob Menendez. He was censured by the Senate, who then returned him as the chairman of a powerful, very powerful committee, the Foreign Affairs Committee, where he was able to extort from 2 other countries in betrayal of his own country. And no, the Senate, with all of that process that we're talking about, they have to have ethics and an ethics committee. The Senate did nothing, essentially, until, he was on his way out. They let him continue to vote. They let him continue to bear. They only took him away from his chairmanship after he was formally charged, which, by the way, was years after the crime and their awareness that he was under investigation. So allegations about the high court, I'm sorry, I take umbrage that we do it better. I take umbrage that somehow we've got the answer here, because we haven't, certainly the Senate hasn't shown it. And I just want to add one more thing. The gentlelady from Wyoming will be back here shortly, but she said something short and succinct and profound. And I'll summarize it in my limited ability compared to her constitutional scholar type capability. We are limited by the Constitution and our founding fathers for a reason. We are limited to being 3 branches who balance each other based on specific rules. One of them is the right to impeach members of the other 2 branches and remove them from office, which we have done 15 times in history to federal judges. We have that ability to do that on our own accord, and we have done it. We do not have the ability to threaten them with prosecution, to harass them with set rules that they must have and ethics standards that we demand they have. And remember, this is the high court. This is our peers. It's not 670 lower court judges. It's 9 judges. Our founding fathers wisely set up a number, originally 7, now 9, for the court. The president, originally 1, still 1. Us, a fraction of 435, today 435. We are balanced in a way in which the Constitution very clearly says what our ability to oversee the others are and their ability to oversee us. I don't get up every day saying, boy, I'll tell you, that Constitution was perfect. I don't even get up every day saying all 25 of those 27 of those amendments were perfect, particularly the 27th I take umbrage with. The fact is, we should, as the Committee of the Constitution, recognize that we can't necessarily change it. Yes, we can make some statutes. Yes, we can encourage the court. Yes, we can even use our funding to help encourage them to do certain things. Cameras in the courtroom to give better access, things like that, which are projects that I've worked on. But I do think when we're looking at oversight, what I offer to the ranking member, and I stand behind, is transparency in an honest way of events of all of history, but particularly the last 2 to 4 years, so that we can have that evaluation. The only guidance I would give that I've heard here today that I did take umbrage with, I am personally tired of the attacks on one or another justices. if we want to have the court do certain things, including establish written guidelines or establish process that we think would be better, we're not going to do it by attacking a member of the court. Most of the members of the court rally, and both parties rally behind that as unfair for our branch to stand in judgment of the other branch unless we do so under the Constitution. So I took a lot of time to say, let's move on to the next subject. I believe that this has had a good hearing, and I hope that my ranking member on the subcommittee will put this in the minority request, knowing that I will hold a hearing. I yield back.
Gentleman yields back. Gentleman from Tennessee is recognized.
Thank you, Mr. Chair. I think I left when we were talking about DWIs. Good time to have left, wasn't it? But then I tuned in and I saw y'all were talking about some issues, and I'd strike the last word. It's basically a request I was going to make to the chairman. 2 weeks ago, give or take, I wrote Kristi Noem, and I asked her to let me know how many people who had been deported were guilty of, or had an indices that they were guilty of, murder, child sexual offenses, or rape, which is what the administration has said they were going to go after. And Kristi said we're going after the worst of the worst. And I asked for her to let her know how many people that had been deported were of that class, where they had been picked up, because I find it kind of hard to believe that people that have committed rape or child sexual offenses or murder are not in jail. If we knew that they'd done it, they'd be charged. I doubt they'd be put on bond, or very few of them would. So would you, I've written there, would you join me in a letter to, because it's immigration's under our committee, criminal law is under a committee, and try to get, for the education of this committee, and it would have been relevant, I think, to DWIs maybe too, what offenses the people that are being deported have committed, where they've been arrested, so we know if they were arrested, taken out of jail. If they were in a jail, you know, they weren't really a risk to us, but if they were out there on bond, which is rare, but maybe so, but where they were, how many of them have committed those kind of crimes, as distinguished from just the people that are being deported?
Yeah, the gentleman, get us the letter. We'll take a look at it.
Thank you, Jim. Appreciate it. And otherwise, I support Mr. Johnson's recommendation, and I understand what Mr. Issa was saying. I could take all my time to go against 6 of the justices, but I won't do that.
Would the gentleman yield for? Would the gentleman yield?
Someone's asking.
Sure.
Would the gentleman yield? I don't even need my.
Happy birthday, by the way.
Thank you.
Oh, wow. Happy birthday.
What a lovely way to spend it.
Yeah. Could have been done a lot sooner there, Mr. Goldman.
I would merely just want to point out that this is an apolitical, nonpartisan recommendation to investigate ethics of a group that includes Republican appointees, Democratic appointees, and will forever include appointees of both parties. So this would apply to Democrats just like it would apply to Republicans, and that it is therefore, on its face, nonpartisan. And so we may have examples that dig into partisan issues, but all we're talking about is a binding ethics code that exists for us, it exists for all other federal judges, to exist for the highest court in the land. And I yield back.
Gentleman yields back.
I think I still have the floor.
I'm sorry.
I yield to Mr. Johnson, the drummer from Atlanta.
Thank you, Mr. Chairman, or Mr. Ranking Member. I'd ask the chairman of the full committee whether or not he would accept my offer to amend my amendment to state as follows on page 9, after the language that you have in there, which is the unwarranted attacks on and threats on the Supreme Court, to simply add the following: and the need for an enforceable code of ethics at the Supreme Court and threats of impeachment, removal, and physical violence against federal judges who rule against the Trump administration in ongoing litigation. Would the chair be willing to accept my amendment to my amendment?
No.
Well, then in that case, I would ask for unanimous consent to accomplish the same objective.
Object. Wait, unanimous consent to what? Change?
To change the language.
Oh, you want to change the language in the amendment, and then we can debate that and still have a vote on that. So if you want to change the language, you're going to get rid of strike and put in after. So the amendment will now read on page 9, after the unwarranted attacks on and threats on the Supreme Court, insert the following, the need for, You still have the focus on the Trump administration, but yeah, you can change that. I'm still going to encourage our team to vote against it.
All right, I want to yield to Mr. Van Drew.
Well, then I'll just leave it.
Yeah, you can just leave it too.
as
That's
it
fine.
is.
Yeah. Well, I mean, look, like I said, like many of us have said multiple times, put it in the minority views, and that's fine. You can structure it however you want.
You can ignore it from there.
Well, we don't always ignore minority views, but sometimes we do. Yeah.
Most of the time, I think. I feel that mine will suffer the same fate as all of the others that I'm aware of.
Let it be known that I tried to yield to Mr. Van Drew, but time eluded me.
Okay. The time of the gentleman has expired. The question occurs on the amendment from the gentleman from Georgia. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not adopted.
I'd ask for a recorded vote.
Gentleman requests a recorded vote. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Garcia votes aye. Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Ms. Crockett votes aye.
We got a few more, and we need to get some members here.
I think we got it.
No, you don't have it.
Can you give us the early returns, Mr. Chairman?
Mr. Gale votes no.
It was Gill? You got him? Okay. We're doing this again next week. We got one more coming, I think, planned for next week, too. When do we have to notice that to you guys?
You don't have to notice it until Monday, but we generally get a friendly phone call from the gentleman to your right a little earlier than that.
We're doing another markup next week.
Yeah. It'd be fine. fun?
Forget what's on the calendar. We just went over it yesterday, but I kind of forget what's, I don't think it's,
What do you mean by fun?
Yeah.
Exactly. Well, if we're being euphemistic, then that's makes
Parliamentary inquiry.
it a long work. I think it's gonna be a long day. Guess that's up to us.
I couldn't hear. Parliamentary inquiry?
I think we're pending vote, pending business. So when that's concluded, I'll be happy to entertain your parliamentary inquiry.
How long is business pending?
Pinned a long time, in my experience. How we doing, Isella, on the phone? And we're gonna need more on Mr. McClintock.
Mr. Baumgartner votes no. Mr. Liu, you're not recorded. Mr. Liu votes aye.
Madam Clerk, what is the unofficial tally?
Mr. Kiley votes no.
They're not coming, Mr. Chairman. No matter how much you call them, they're not coming. I think we should call the vote. Call the vote right now, Mr. Chairman.
It's just an
Let's
amendment.
let regular order preside in the great Jim Jordan's Committee of the Judiciary.
Let's have some ethics
Chairman's
about
smiling at
ourselves.
me. It's that time, Mr. Chairman.
Mr. Harris? Mr. Harris votes no.
Mr. Moskowitz, do you happen to have a tally?
1610, or no, 1611,
12.
1612.
16 meaning Democrats?
We're winning for now. You know, as the president said, it's that late vote that comes in.
And now it seems like they may steal the vote. It seems like it's going to be stolen. Yeah, I know.
I bet you're supporting mail-in
It's those late. Stop the steal. Stop the steal.
How's the gentleman from Texas?
Mr. Gooden votes no.
Everybody got up at the same time and left.
Mr. Tiffany votes no. Mr. Neguse, you are not recorded. Yes. Mr. Neguse votes yes. Ms. Kamlager-Dove, you're recorded as yes. Mr. McClintock votes no. Mr. Knott? Mr. Knott votes no. Mr. Fry, you're not recorded. Mr. Fry votes no. Mr. Chairman, there are 17 ayes and 17 noes.
The amendment is not adopted. Committee will come to order. Who seeks recognition?
Give us 1 second to get organized here. We're trying to wrap things up.
You got one more amendment, or are we going to just the bill?
I think
Or just to
we're
the,
going to have one more amendment, but
okay.
we're trying to pick. It could be 4 more. We have many more amendments prepared if you'd like to see more. We have a whole menu of options.
All right, all right.
All right.
We'll do one more amendment, because then we get everybody out in time for 4 o'clock, right? Is that when they're calling votes?
Yeah. Can we tell Ella that people need to stay, because we're going to wind up pretty quick? Okay, who's going to? Gentlelady from the committee will come to order. Gentlelady from California is recognized. No, you did not. But you tied.
Thank you, Mr. Chair and Ranking Member. I offer an amendment relevant to the oversight of the administration. Oh, sorry, I have an amendment at the desk.
Clerk will report.
Amendment to the Committee on the Judiciary.
Without objection, the amendment will be considered as read. The gentlelady is recognized to explain her amendment.
Yes, thank you again for that. I am offering an amendment relevant to the oversight of the administration, because this administration has been doing a lot already, and I don't even think we're 2 months in. So I certainly think that this oversight plan should include oversight of this president's administration, and why wouldn't it? Unless my colleagues on the other side of the aisle are afraid. And if Republicans are afraid of this president and Elon Musk and all that they are doing, then I think it's only fair that you all say that to the American people. And let the American people know who they have in office and what they are working with in their elected members of Congress. That's why we have town halls. That's why we're out talking to our members and talking to our constituents. So this amendment focuses on one of the president's very first acts, his pardoning of the January 6th insurrectionists. Because, among other things, this committee is supposed to administer jurisdiction over how we interpret, apply, and respect the law. And law enforcement is part of the law. We know that on January 6th, hundreds and hundreds and hundreds of individuals showed up at the Capitol, and they were not peaceful. They were not respecting of the building, the institution, and they certainly were not respecting of the law. And they did not model how American citizens should behave. Individuals punched, killed, shoved members of the Capitol Police. They sprayed law enforcement with pepper spray, stomped on their heads, struck them with a metal crutch and broken pieces of furniture. And in fact, members of the Capitol Police of law enforcement were killed. And last I checked, it is against the law to assault and or kill a member of law enforcement. If those things happen, the penalties are stiff, and the offenses are punishable by more time in prison. And in fact, in Washington, D.C., where the Capitol is located, where this incident happened, assaulting a police officer carries an enhanced penalty meaning if you assault a law enforcement officer, you can face a harsher punishment compared to a regular assault charge, with the potential for a felony conviction and up to 10 years in prison if the assault causes serious bodily injury or creates a grave risk of significant harm to the officer. So regardless of what a president does, and a president certainly has the right to pardon, this body should at the very least discuss the acts and then stand up and condemn violence against law enforcement. Or not, don't do it and say why, but say something, because real talk, you're the only ones not talking about these pardons and acting as if the behavior that precipitated the charges and subsequent arrests were okay. And if that is a fact, then you are also saying that this is condonable behavior in which every other American can engage. And the American people want to know if you're saying that. As I said, these individuals who attacked and killed members of law enforcement, Capitol Police, were pardoned by the president. And a family member of one of the fallen officers said, the pardons were a betrayal of decency. Some might say that those actions desecrate the honor and memory of those heroic and honorable Capitol Police officers, people who protect this body and the visitors who enter this space every day. So I am offering this amendment because I think our Capitol Police officers deserve our respect and for us to stand up and say we back them. I think we owe it to all of law enforcement to say that the carnage that happened on that day to our Capitol Police is not okay. And at the very least, talk about it, because the majority of the American people, 83%, do not support those pardons and deserve to see where this committee stands. And I hope you all will join me in supporting this amendment.
Gentlelady yields back.
Okay, thank you. Yes.
I thought, or were you yielding to the gentleman from Florida?
To you? No, that's fine.
Gentlelady yields back. Recognize the gentleman from Wisconsin.
Thank you, Mr. Chairman. I mean, the discussion about pardon power is under the exclusive authority of the president, right? So when President Biden issued broad in the preemptive pardons to his family members for over 10 years, I'm just trying to make a slight point on this. The pardons that President Biden issued were obviously unusually broad and extended to any offenses, or in the case of Hunter, of which if you sat through the depositions, it's just, it's kind of unbelievable that this happened the way it did. But I just want to make the point that unlike President Trump's pardons, which were issued after legal proceedings had played out, President Biden's pardons allowed his allies to kind of evade the full judicial system. And I think that gets lost on the difference between the Biden pardons and what President Trump did. Even if you don't fully agree with everyone that was pardoned, after looking at some of their records later, should have been pardoned. It was done in proper sequence. I yield back.
Would the gentleman yield for a quick question, a friendly question?
I would.
It's not exactly the case that we have nothing to do with pardons. For example, it's against the law to sell a pardon. So there are certain things around the pardon, but your general point is correct that it's within the president's power. But would you concede that a president's power to pardon for a particular offense does not mean that that defendant is then, by definition, free for all other offenses?
Well, I think it would go back to whether or not you think that each one of the defendants that ultimately was run through the legal system had an opportunity to defend themselves,
right,
and had the ability to actually have due process offered. Right?
Gotcha.
So
just to be clear, like if someone had due process, they were convicted of a particular crime, say trespass of the Capitol, and they're pardoned for that crime, that should not extend to other crimes like a murder or a rape that took place that had nothing to do with January 6th.
I would agree with that.
Okay, thank you very much. I yield back to you.
Gentleman yields back. Who seeks recognition? Gentleman from California, and then we'll come to the gentleman from Florida. Gentleman from California is recognized.
Matthew Huddle. I want you to think about the name Matthew Huddle. just last month, after being pardoned by Donald Trump for his conduct on January 6th, where he had picked up, racked up, was arrested for 4 separate cases after January 6th, this guy tries to pull a gun on a police officer in Indiana. Thank God the officer is alive and defended himself, and Mr. Huddle is not. But what do you think was going through the mind of Mr. Huddle as he was pulled over by a police officer? What do you think he was thinking? He was thinking, I got pardoned. I'm invincible. You can't touch me. The president said that if I commit violence or I'm with people who commit violence, it's okay. So he tried to shoot a cop. That cop almost didn't go home that day because Mr. Huddle was on the streets. So what this amendment is saying is, shouldn't we track the people who were released, 1,500 people, many of them who committed violent acts, many of them who have since been arrested for child pornography. One of them was arrested at the Capitol just a couple days ago. And you know what? If you want to compare to the gentleman from Wisconsin, the Biden pardons to the Trump pardons, I'll put those lists next to each other and see who reoffends. I'll take that bet. I'm going to bet, and I'll bet it all, that you're going to see more of the Trump pardons back in custody because of this sense of invincibility that the president has bestowed upon them. And by the way, the Department of Justice also just said, just this week, that one of the January 6 individuals whose home was searched and explosives and weapons were found, that he can't be charged with those because they're connected essentially as fruit of the poisonous tree of what was done for January 6th. So this is a pardon that goes beyond just what they did on that day. We have allowed the most dangerous people who attacked our Capitol back into our community. By the way, a man who would release 1,500 of the most dangerous people who committed crimes on his behalf will also seek to lock up 1,500 of his most vocal opponents. That's the kind of mindset somebody like that has. But I just want to ask my colleagues, because many of you were with us on the floor on January 6th. I see many of you over there who were. Many of you ran as we were told to leave the floor, and we listened to the instructions of the Capitol Police who were in the chamber, and you heard the on the door outside, and we didn't know what the hell was out there. We saw the chairs stacked up in the press gallery. And we finally were allowed to leave. Some of us had gas masks on. Some of us were carrying the gas mask. I remember Ruben Gallego telling all of us, because we didn't know what the hell to do with the gas mask, how to put it on because he had served in theater. I saw heroic members on your side who had served in theater pushing a desk against the back doors of the chamber. We were all one team that day. We were Team America, and we knew what team the rioters were on. And when we got to that safe location, and in the hours after when we went back to the floor, you thanked the Capitol Police. We thanked the Capitol Police because we knew what they did that day. And now imagine how they feel when they have to stand guard, as they did last week, for a Proud Boys rally that was on the same grounds where those same Proud Boys viciously and violently attacked them. So the very least we could do together as we thank them that day is to tell them, we're going to track the people who were released. We still think you're heroes. We still think that what you did that day is probably the bravest thing you'll ever do in your life and probably one of the bravest acts any of us will ever be a part of and witness to. That's what this amendment seeks to do. I hope we all can pass this amendment, and I hope we can all look the Capitol Police in the eyes when we leave today and go to the floor and know that we still have their back. And I yield back.
Gentleman yields back. The gentleman from Florida is recognized.
Thank you, Mr. Chairman, and thank you for the amendment, Ms. Canlonger-Dove, and thank you, Representative Swalwell, for that reminder. But I'm confused, and if you want to answer, either of you want to answer me, I'm confused. We were told it was a perfect day. Was it a perfect day?
Still doesn't feel perfect.
No. But we were also told that they were just getting a tour and got like lost while on their tour. We were told that there were no guns there. Right? No guns. Nobody had any guns. The police had guns, but nobody in the crowd had guns. Very minor incidents with police, we were also told. But I like this quote. This is my favorite one that came out from all of that. If you committed violence on that day, you shouldn't be pardoned. And who said that? The current Vice President of the United States, J.D. Vance. I yield back.
Gentleman yields back. The gentleman from California is recognized.
Well, Mr. Chairman, I agree that the events of January 6th were an abomination. There were violent acts committed that day. There were people, I myself saw a Capitol Police officer with a serious eye injury being led away as I made my way back to the office. But let's be entirely honest about what happened. It was not an insurrection. It was a riot. It disrupted one of the core constitutional functions of this government, the counting of the electoral vote. But the government wasn't moments away from being overthrown by a lunatic wearing Viking horns. The moment that the last of these yahoos was kicked out of this building, we returned and completed our work. Now, there were some who should have had the book thrown at them for vandalism, for assault, and for disrupting our proceedings. But the vast majority of the crowd hurt nobody, broke nothing, and sincerely thought they were merely peacefully exercising their right to protest. I wish that President Trump had been more discerning when he extended pardons to those who perpetrated actual crimes. But I also wish that President Biden had been more discerning in prosecuting people who merely were there, as President Trump said, to peacefully and respectfully express themselves to their elected representatives. I think the Democrats would have far more credibility on this issue if they had made these distinctions and if they'd insisted that those who burned our cities to the ground during the George Floyd riots were treated with the same ferocity as so many were in the January 6th riot. I yield back.
Gentleman yields back. I think I got, I'll go to the ranking member. The ranking member is recognized, and we'll go to Mr. Maguse.
Thank you, Mr. Chairman. And I thank the gentleman from California for not denying that it was the Proud Boys, the Oath Keepers, the Three Percenters, the various white supremacist and white nationalist groups that came to storm the Capitol at the behest of Donald Trump, who said, "Be there, we'll be wild." It was not Antifa, despite what some of our colleagues have said. It was not a tourist visit, although if it was, that might explain why American tourists aren't that popular these days. And it was not the FBI. And it was not the FBI. Okay, so I appreciate that. I was a little surprised to hear the word discerning in the same sentence as Donald Trump. You wish that he'd been a little bit more discerning in what he'd said. Yeah, I wish he'd been a little more discerning when he said you got to go and fight like hell, and if you don't, you won't have a country anymore. I wish he'd been a little bit more discerning when he set out a tweet when he knew that the Capitol had been overrun and his own vice president was fleeing with his entourage, when he said Mike Pence did not have the courage to do what needed to be done. I wish he'd been a little more discerning about that. He was pretty discerning the next day when he said that he denounced what had taken place as an atrocity and that the people would be held responsible. But then he wasn't very discerning when he began to back off of all of that and begin to say these people were heroes and political prisoners like Alexei Navalny and Alexander Solzhenitsyn and Nelson Mandela. And when he said they were hostages, like the people held by Hamas. A hostage is somebody who's been kidnapped and abducted by a terrorist or a criminal group and held for ransom. And he was just a little undiscerning when he described these people who'd had every benefit of American due process and American right to counsel and the right to testify if they want to, when he described them as hostages. What an abomination, as the gentleman says. What an abomination it was indeed. But look, we have the opportunity now to actually deal with one of the major issues that is arising right now because of this nightmare. And it is that there are people who were arrested and prosecuted and convicted for their crimes on January 6th who are now getting off of other crimes because of the pardon that they received from Donald Trump. They are being released from jail, from prosecution, by the Department of Justice for other crimes that they committed that were worse crimes than what they committed on January 6th. I'm going to introduce for the record an article. Department of Justice says Trump's January 6th pardon covers man convicted of possessing hand grenades, classified information. That's in Politico.
Without objection.
February 25th. Well, they went to arrest him for what was the relatively mild crime at the time of just trespassing into the U.S. Capitol and not leaving the Capitol. This is Jeremy Brown. But when they got to his house, what do you know? What do they find? Well, not just hand grenades, but an illegal modified assault weapon, an AR-15, a sawed-off shotgun, and classified reports that he had taken from the Army when he left the Army, okay? So all of those things added up to a 7-year criminal sentence when he was prosecuted for those things. But now the Department of Justice says that he should be immediately released based on President Donald Trump's mass pardon of the people, which included his pardon for trespassing at the Capitol. Now, I would hope that the gentleman from California, the gentleman from Wisconsin would agree with me. That is a matter squarely within the jurisdiction of the Judiciary Committee, whether people should be able to be released by the Department of Justice for offenses completely unrelated to January 6th because they were pardoned for things that happened on January 6th. And what a dangerous principle that is. I mean, will it lead to the creation of a private militia of people who owe their freedom to the President of the United States? These foot soldiers who are willing to do anything for the President and the Department of Justice because they seem to have a clean slate, including for crimes that had nothing to do with January 6th. Is that something we should look into? I think we should. I commend the gentlelady from California for bringing this amendment forward. That is absolutely something we need to examine because there's lots of other offenses that we've determined are out there with these people. Child pornography, domestic violence, other arms charges. Do we really want to give people a get out of jail free card because they went to work for Donald Trump's orders and invocations on January 6, 2021? I yield back.
Gentleman yields back. Question. Well, that's right. Mr. Nagus was up. The gentleman from Colorado is recognized.
I think the chairman, and I have great respect for my colleague from California, and I suppose if he's willing to indulge me in a colloquy, I just might ask him and give him an opportunity to kind of clarify for me. Is it your position that what happened on January 6th was not an affront to our Constitution?
On the contrary, I think it was a terrible affront. I've called it an abomination. It disrupted one of the most important constitutional functions of our government, and we should not tolerate that. And the people that were responsible for assaulting our officers, the people who were responsible for vandalizing this sacred building, should have the book thrown at them. I've said that all along, and I think it was a mistake for the president not to differentiate between those people and the vast majority of people who, as I said, broke nothing, hurt nobody, and simply thought they were exercising their First Amendment rights.
So given that, why object to a simple amendment that simply seeks to probe, as an oversight matter, the very thing that you purport to disagree with? I mean, your point, right? You've called President Trump's pardon.
Yes, well, that is, but the pardon is.
I would hope you would support this particular amendment if that were the case.
The pardon is the exclusive prerogative of the executive under our Constitution.
I see. Well,
and I do believe in that separation of powers.
I would simply say, Mr. McClintock, again, I have great respect for you, but I don't know how you can make that argument in a straightforward way to make the case that you disagree with these pardons and you believe that they shouldn't have been granted, but you object to a mere investigation or any kind of oversight by this particular
We have no
gentleman
authority to
in regards to
investigate the exclusive prerogative of the executive.
Right, with the gentleman
let me, in a moment, Mr. Chairman, but I'm enjoying my colloquy with Mr. McClintock. Would you describe what happened on January 6th, Mr. McClintock, as an attack on our Capitol?
I would describe it as a riot.
As a riot. Okay. I'm going to read to you a tweet, or an X, whatever they call it these days, from January 6th, 2021, at 4 p.m. Quote, "The attack on the Capitol strikes at the most sacred act of our democracy, the peaceful transfer of power. It is an outrage and a threat to our most fundamental principles as a free people." That's from your Twitter account.
Yeah, I don't gainsay a word of it.
On January 6th. Well, you called it a riot. You denied it was an attack a few moments ago. These are your words, or at least whoever posted these from your account 4 years ago, in the throes of that particular day when we were all on the floor, as Mr. Scanlon
I was outraged from
referenced.
it. I'm still outraged by the people who broke our laws, who were violent, who vandalized our building. But we have to recognize that that was a relatively small group compared with a large number of people who came here simply thinking that they were exercising their right to protest.
Well, let me just distinguish this point, because again, that sounds very different than the way in which many members have characterized January 6th in the past. You're making this distinction with respect to individuals who committed violence or didn't commit violence. I'll read you another statement. "What happened here on January 6th was an affront to our Constitution and national disgrace. Those who entered the Capitol with the intent to disrupt the counting of electoral votes deserve to be denounced by their fellow citizens and prosecuted to the fullest extent of the law."
Exactly.
That's yours. Well, that sounds very different than what you just said, that there were a couple of violent people. But the vast majority, well, hold on, Mr.
Those who
McClintock.
broke into the
Mr.
chambers of the House, those who came here intending to disrupt our proceedings, I have no sympathy for.
Well,
but I don't think that describes the vast majority of the people who entered the building.
belongs to the gentleman from Colorado.
I thank the chairman. The vast majority of those individuals, again, the broad way in which you framed it in your statement in July of 2022, a year later, that any individual who disrupted the proceedings or attempted to disrupt
who intended to disrupt them, yes.
the electoral counting procedures ought to be fully prosecuted under the law.
And I still believe that.
Well,
and I believe that the
sounds very
pardons
different.
of those people
Sounds
were
very
a
different than what you're
mistake.
saying today, Mr. McClintock. I yield back. I know my time is up.
Gentleman yields back. Gentlelady from Texas is recognized.
Thank you so much. And I am going to join my other colleagues and say simply thank you to the gentleman from California. Because earlier we had a conversation about facts. And the reality is that out of all your colleagues on that side, you are the only one that is courageous enough to actually say these are the facts. Whether you like what happened, hate what happened, agree that it should have happened, the facts are the facts. That's what happened. And so I appreciate you, because I think one of the things that we're getting frustrated about on this side is that there seems to be an attack on facts, so that when people put out fiction, that people will get drawn to that. So I appreciate you for not reimagining what happened as a beautiful day that was just a tour. But I will disagree with you to this extent. When you originally opened, you said that it wasn't an insurrection. And in my mind, I initially was like, it absolutely was an insurrection. And so if I read the definition from Google, it says a violent uprising against an authority or government. Call it what you like, but it fits the definition of an insurrection. And the other thing that I'll disagree with you about is you talked about having issue with the way that Joe Biden prosecuted them. I do want to clarify for the American people, if you are watching right now, that the President of the United States, at least historically how our presidents operated, the DOJ was separate and you didn't have, attorneys that work for the DOJ saying that they are the president's attorney instead of the people's attorney, but that's where we are now. It wasn't the President of the United States that actually prosecuted anyone. It was his Department of Justice, I will say that. But I decided that I would go in because it seemed like you felt like there was a heavy hand for a lot of people. So literally, I just decided to look this up because I did not know the numbers. We've talked a lot about the fact that there's been 1,500 pardons, but we've never really kind of dug into the numbers. So January 6th of this year, there was an article that was put out that laid out, and this is from PBS, where it talks about kind of where the trials stood. So I'm assuming on January 20th, this number probably is still very much valid. There were 1,020 people that entered pleas of guilty. So regardless of what anybody thinks of the criminal justice system as somebody who did criminal defense, these defendants stood in front of a judge and said, yes, I am entering a plea of guilty. And they have to say voluntarily and freely before they can get through a plea. If a defendant ever says that it's not voluntary or it's not freely, then the judge rejects the plea. So that's number one. So 1,020 of them did that. There were approximately 250 defendants that went to trial and it resulted in guilty pleas. They either went to a trial by jury or a trial by judge, but they were given an opportunity to decide if they wanted a jury trial or a trial by the court, and they went through their due process in that way. I will tell you that if I go back a little bit further, because I did not have the numbers from this article, if I go back just about 3 more months before this article came out, it said of all these pleas that we've heard of, 255 were for felonies. 255 out of 1,500 does not sound heavy-handed. That means the other people most likely enter pleas for misdemeanors. They only, when the people that still should be behind bars are the people that did what Eric talked about. The people that Enrique, whatever his name is, y'all know his name.
And will the gentlelady yield real quick? Quick question for you.
Okay.
In your experience as a lawyer, someone who defended people, what's a lawyer's obligation if someone says, no, I didn't really do this, I can't plead guilty?
We are not allowed to plea that person out. You can literally have your bar card snatched from you. It is unethical to enter a plea, and a defendant can get out of that plea if they say that they told us that they didn't do it and we told them to plea anyway. Then that could actually be our bar card. But the last thing that I was gonna say about Enrique is they let him out. He should still be behind bars because then he went and he harassed our former officer, Fanone, just the other day because he feels like he can do whatever he wants to because he's now gonna be lawless like the rest of these 1,500 people. And when we talk about being safe in our communities, this is what we're talking about. We should not be letting criminals just roam the street after they've gone through the process.
Thank
you, Mr. Chair. I appreciate you.
Time of gentlelady has expired. She yields back. The gentleman from, can we
Can I talk on this, Chairman?
Mr. Massey, can you grab some time for us?
I'd like to yield my time to Mr. Fitzgerald.
I thank the gentleman. I mean, that's the point, though, that these individuals did go through the system. And some of them were found guilty, and they were incarcerated. And they spent days, months, years in jail. And then the president had the ability to pardon them. And we're kind of lost in a discussion about back and forth on J6, now January 6th. But that was the point I was trying to make, I guess, at the onset was President Biden did not do that. And the preemptive pardon, I would love to know what the ranking member thinks about the preemptive pardons, and I believe that he was even granted one, because that is egregious. And quite honestly, we have no idea how that's going to end up. But guaranteed, if Hunter Biden breaks the law again, which probably a pretty good chance it's going to happen at some point, then we'll be able to see what presidential pardons are all about, right? That'll be the real gauge. I yield back.
I yield back.
Mr. Massey yields, gentleman yields back. The gentleman from Georgia, and then we'll come to Vermont. Gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I rise in strong support of the amendment offered by my colleague, Congresswoman Kamala Dove, which seeks to take the Republicans on the committee out of an embarrassing situation where they have proposed to use this committee's jurisdiction to look into, quote, unprecedented and aggressive law enforcement tactics against political opponents of the Biden-Harris administration, as if there had been any, and she's simply wanting to replace that with something that is important to the American people. I mean, President Trump ran for election promising and pledging to make our community safer. And what he has done, first minutes in office, to pardon more than 1,500 unrepentant and unrehabilitated criminals back into our communities. He's actually made us less safe. That is something that our committee should be looking into. The fact of the matter is these more than 1,500 unrepentant and unrehabilitated criminals are even more radicalized than they were when they went in. They have committed offenses against the Constitution and against the laws of this country. Then they have seen a man elected who was able to escape accountability himself, and once he gets in position to relieve them of accountability, he does so. And so now they feel like they can do just about anything. Now, Mr. Chairman, I expect that with the State of the Union address coming up next week, there's going to be a lot of invitations extended to a lot of Oath Keepers, 3%ers, and Proud Boys to be in the gallery to cheer on the man who pardoned them, the man who exempted them from accountability for their illegal acts, the man who would say to them that it's okay for you to use violence to accomplish political objectives that I have, and I'm going to pardon you if you do that. I'll pardon you again with my power. I'll be here for 4 years. So it's scary, the kind of situation that has been put upon us by this blanket pardon. 600 of those individuals pardoned were convicted of assaulting Capitol Hill police officers, and now our officers are going to be looking dead in the faces of the perpetrators who exacted such punishment upon them on January 6th 4 years ago. They're going to be facing that. And so the least that we can do as a committee is to use our power and authority in a just way to look at the impact of those pardons, and to perhaps out of that will come some ability to protect ourselves from the danger that has been unleashed on our communities. And Mr.
With the gentleman, oh, sorry.
I'll gladly yield to the gentleman.
Thank you, Mr. Johnson. Just a postscript to your comments. The founders of the Constitution discussed pardons of insurrectionists as a possibly impeachable offense, because you can see the danger if a president incites people to insurrection and then, it fails, but then they're pardoned for it. You can see how that creates a huge danger for the republic. Insurrection, incidentally, is not some kind of peripheral issue in the Constitution. In half a different places, insurrection, where it's equivalent, is condemned and specifically opposed by the founders. Treason, of course, the only place where a criminal offense is defined in the Constitution, consists of levying arms against the Union, right? In Article 1, Section 8, Congress has the power to summon the militias of the states in order to, quote, repel invasions and suppress insurrections. Insurrections is a very big deal in the minds of the framers coming out of Shays' Rebellion. Thank you for yielding.
Thank you. And with these folks now being reconstituted to exact harm upon the American people, it's time for us to investigate the impact of that pardon. So I support the gentlelady's amendment, and with that, I yield back.
Gentleman yields back. I would just point out that as the gentlemen from Wisconsin and California have stated, the pardon power is exclusive to the president. He gets to do it. You guys didn't like some of the pardons President Trump did. We had concerns with the pardons President Biden did. But nowhere in our plan do we talk about what President Biden did with the pardon power, even though we got real concerns with things that he did, particularly with his family, when he told us one thing and then wound up doing just the opposite and applied it to not just Hunter Biden, but to all others. But that's not in our plan. But what is in our plan is the language you want to strike, the use of unprecedented and aggressive law enforcement tactics against political opponents of the Biden-Harris administration, or just policies that they didn't agree with. And I remember in this room when we had the lawyer for Brian Malinowski, where the ATF went to his house, supposedly because he sold 6 firearms that he wasn't supposed to sell, went to his house. By the way, Brian Malinowski was the language you want to strike, the use of unprecedented and aggressive law enforcement tactics against political opponents of the Biden-Harris administration, or just policies that they didn't agree with. And I remember in this room when we had the lawyer for Brian Malinowski, where the ATF went to his house, supposedly because he sold 6 firearms that he wasn't supposed to sell, went to his house. By the way, Brian Malinowski was the highest paid municipal employee in Little Rock, Arkansas, ran the Bill and Hillary Clinton Airport. FBI had been surveilling this guy, ATF, had been surveilling this guy for several weeks. They could have went to his house to execute a search warrant the week before, but he wasn't home, so they said, we're going to wait. We want to go pre-dawn raid on his home while he's there, a guy who's in the gun business, for goodness sake. How crazy can you be? And of course, what happened? Something terrible. They show up, put tape on the doorbell cam, and 53 seconds later, Brian Malinowski is shot in the head.
But Mr. Chairman, he was
shot in the head,
political opponent, though, of the Biden administration.
Shot in the head, later passes away. We want to look at why not just do the simple thing? It's a search warrant. Why not go to the airport where he's there, say, Mr. Malinowski, we're here from ATF. We want to go to your house with you. Call your wife so no one gets injured. We'll go do the search warrant. No. They got to come in gun blazing, cover up the doorbell cam and do that. So we think that's worthy of understanding. Why would they operate in that fashion?
Will the gentleman yield?
That's all we're saying. That's all we're saying. This is not about pardon.
Will the gentleman yield?
I'd be happy to yield.
Yeah, I mean, what proof do you have that that gentleman, Mr. Malinowski, was a political opponent of the Biden administration?
I'm not saying it was. I'm just pointing out the aggressive tactics that we see from law enforcement, and the policy issue relative to firearms is the underlying issue here. I think of what happened to Mark Houck. Those are the kind of things we want to look at. And was it driven by politics? Was it driven by policy? Certainly. Not the power of the pardon power, which rests solely with the President of the United States. And like I said, we disagreed with how President Biden handled it. You obviously disagree with how President Trump handled it. But it's a power that the executive has, that the president has solely. Who seeks recognition? The gentlelady from Washington. Oh, no, that's right, Vermont, then Washington.
Thank you, Mr. Chair, and I will try to be brief. I know we've been here for a long time. I do support this amendment, and I want to just talk about why it's so important that we do look at what happened with the 1,500, as it says, in this amendment, unrepentant criminals back into our communities. When we, in the 118th Congress, those of us who were freshmen coming in, the 118th, we were the first class that came in after January 6th. And when we were assigned to our hotel, we had security guards everywhere, Capitol Police everywhere, multiple police officers on every floor of the hotel, a huge presence in the lobby. And during that time, I got to know a lot of those police officers because they were there around the clock. You went out of your room in the middle of the night, they were there. You went down in the morning to get a cup of coffee, they were there. And I can tell you, we owe them so much more than they are getting. And when I talk to them about what it feels like right now to be in the service of all of us and not hear strong voices in support of them, and instead they hear silence, it really impacts their ability to do their job. I mean that on a human level, as a personal level. It impacts them every day to show up, to defend all of us, and to hear silence across the aisle about what they went through. The other thing I want to say, just briefly, is last week, a bunch of us did town hall meetings back home, heard from a lot of our constituents across the aisle. I did one in a really small town in Vermont. It was packed audience across the political spectrum. And one of the questions was, do you feel safe serving as a member of Congress right now? And my answer was an honest one. I said, in speaking with my colleagues on both sides of the aisle, I said, I think most of us do not feel safe serving now. And I think that should matter to us, because I think we want people to serve. We want people to stand up for the Constitution and the rule of law. And what does it say that people who are currently serving do not feel safe in that work? And I can tell you what it felt like for me walking around the day after the pardons and seeing those folks not just walking the halls of Congress, but holding court in the coffee shop in the basement of Longworth. The people who protect us deserve better than we are giving. I yield back.
Wait, would
Yes,
you yield?
I will yield to you.
Thank you kindly. I want to add to what you just said by that. Some of our colleagues said they would gladly give tours to the released and pardoned January 6th insurrectionists. Of course, I'm not sure they need tours. They probably still have the maps that they used the first time. But in any event, I would like to offer a tour to anybody on this committee, especially of Arlington National Cemetery and the grave of Officer Brian Sicknick, who was viciously attacked, sprayed in the face with bear mace and other chemicals, experienced 2 strokes, and then died the next day on January 7th. And the next time Mrs. Sicknick is in town, I've stayed in touch with Officer Sicknick's family. Next time Mrs. Sicknick is in town, I'd love to go over to Arlington National Cemetery with anybody in Congress who is tempted by any of the stories that this is, some kind of left-wing conspiracy theory or FBI plot or something like that. So I thank the gentlelady for yielding. I yield back to you. I suppose she's yielding back to you, Mr.
The gentlelady yields back. The gentlelady from Washington is recognized.
Thank you, Mr. Chairman. I support this amendment, and I just want to talk about some of what some of us are feeling. I think that's what you're hearing, but also what it means for the country and the scope of this committee's jurisdiction. This is not actually just about pardon power. This is about how we as a country deal with the worst assault on the United States Capitol since the War of 1812. And I think that when you think about it in that context, there are multiple effects on the country and our ability to have a democracy, on our ability to ensure law enforcement is able to do their work, which is something that our colleagues across the aisle constantly brandish as a specialty of theirs, as if we don't care about law enforcement, but also about how the average person thinks about the accountability for this kind of dramatic incursion on our democracy. And so when I think about this, I think about, look, I was trapped in the gallery on January 6th, and I was one of the last members of Congress to make it out of the gallery. And many of us had substantial issues that we had to deal with over the years in terms of our personal safety, as Ms. Ballant has suggested. When I came out of the gallery, when I was finally allowed to leave, which was long after everybody else on the floor was off, I literally was in the last group. We've actually reconstructed the timeline because we couldn't get out because they were pounding, as Mr. Swalwell said, on the doors, and we were not able to get out. We were trapped in the gallery. And when we came out, there were Capitol Police officers surrounding a semicircle of insurrectionists on the ground, face down with their arms over their heads, legs splayed, and the assault rifles that they were carrying with them, the weapons that they were carrying. That is what we were confronting that day. And so when the entire country saw that unfolding, my kids saw me on television. I think we had TV reporters right behind me, so mine was one of the first faces on television, trapped in that gallery, unable to move as a member of Congress, going there to do my job of certifying the election, despite the sitting president disputing that the election had actually been won by the person who won it. And in that moment, as everybody across America sees what happened on that day, and the reactions of good people like Mr. McClintock and others in the moment saying, this is an attack on our Constitution, it's an attack on our democracy, it cannot stand. Good people that day who said that, on both sides of the aisle, because we all experienced it, no matter who tries to erase it. There is then an impact on the American psyche, on the American ability to process whether law enforcement means anything or not, whether the Constitution means anything or not, whether we should have free and fair elections or not, whether the person in office should be transferring peacefully power after an election. And in turn, it has them believe that there is absolutely no accountability whatsoever, and it becomes just a personal choice about whether the party in power wants to prosecute certain things or not. We might go out hard after immigrants who are here, even if they're legal, for something that they've done. But you know what? We're okay with people who want to attack law enforcement and all of us on both sides of the aisle in this place that is supposed to be about the peaceful transfer of power. That's what we were here to do that day, is our jobs. Now you think about the effect also on law enforcement, the people that are here every day to defend us. And the dishonor and disrespect to them of what we do when we refuse to acknowledge what happened on that day. We refuse to say, this is absolutely wrong. President Trump, I know you may have the power to pardon, but this is wrong. What you did is wrong. I can count on one hand the number of Republicans who have said that. And when you do that, you also disregard the people who protect us every day. And I'll give you one other small example here, which is that we, Congress, under Republicans, have refused to put up a plaque that was authorized in the 2022 spending law for a permanent location on the West Front by March of 2023 to honor the law enforcement officials, the Capitol Police officers who were injured and who died and who protected us on that day. What disrespect is that? And in the Committee of the Judiciary, I would argue that it is well within our jurisdiction, our scope to question, I know, Mr. Chairman, but I'm going to take just a second more, because to question the ability of us to actually have the right to look at this and to look at the impacts on the judicial system, on the Constitution, on our democracy. I just hope we would accept this.
Mr. Chair,
I hope we would accept this amendment, and Yes, you know what? We sat here for a long time while you didn't have the votes on the last amendment, so I'm going to take another 10 seconds to say that, Mr. Chairman,
that is
I
all
hope
consistent.
that we would all agree
That is all consistent with the rules. What you're doing is not consistent with the rules. I've been very generous. I've been very generous with the time.
I yield back.
I gave you an extra minute.
I'd move to strike.
There's nothing to strike. Do you want to be recognized?
Sure, I'd
Okay.
move to be recognized.
Okay, can you go quickly? Because I would like to actually have a vote, and then we got to vote on the overall plan. Gentlelady from Pennsylvania is recognized.
Thank you. Do you need more time, Ms. Jayapal? I'd yield to Ms. Jayapal.
All right.
Thank you. Mr. Chairman, I usually listen to you and yield back on time. But
I know you
feel,
do. We've had a good working relationship, and I appreciate the gentlelady's work on FISA and other issues where we work together. So the gentlelady's recognized.
I appreciate it. I just want to emphasize that it is not out of the question for this committee to understand the impact of that fateful day and to actually question what the effect is on our criminal justice system, on our Constitution, on our democracy, by accepting, and if you want to change some of the words in this amendment, maybe Ms. Kamlaver-Dove would be interested in that, so that it is clear what we're doing. We should be looking at what happened on that day. We should be looking at who was pardoned. We should be looking at the impacts on these same offenders, these repeat offenders that are now attacking law enforcement, and the overall effect on our country. I have to tell you, because Ms. Scanlon has been so kind as to yield me time, that the idea of being in the chamber again with Proud Boys who assaulted and killed and led law enforcement, tried to assault us, killed law enforcement, and are there now celebrating because the guy that wanted to not transfer power peacefully in the face of a free and fair election pardoned them. That's painful to me, Mr. Chairman. That is really painful to me. And I think it is painful to every American across the country. I happened to be watching a reel and I saw Robert De Niro, who I really like, being interviewed by Stephen Colbert. And Stephen Colbert asked him, "Who's your heroes?" And first he said Marlon Brando, but then he said the Capitol police officers, the men and women who defended the Capitol during that insurrection on January 6th. And he looked pained that they haven't been even respected. And he named the police officers, Harry Dunn, Michael Fanone. He went through and named them. The American people are watching this. This is within our jurisdiction, Mr. Chairman, and I believe you, as a strong chairman of the Judiciary Committee, should put this into our oversight plan. We should look at the impacts on this. How many of these people that have been pardoned have already committed violent attacks again because they feel immune, because Donald Trump is going to protect them no matter what? Are you okay with that? Anybody on your side? Good people over there? Are you okay with that, Mr. Chairman? I just can't believe that. So I hope we will keep this in some form in our oversight plan so that we can show in a bipartisan way that we are not going to let the worst assault on the United States Capitol since the War of 1812 go by without the Judiciary Committee even blinking an eye at what's happening. I yield back to the gentlelady.
Thank you, and I wholeheartedly endorse your remarks. I would also yield to Ms. Crockett.
Thank you so much. Really briefly, here's the deal. I actually accept the fact that we can't change what the pardon power looks like. I accept that. But one of the things that has been brought up routinely, and maybe you don't experience it on your side of the aisle, is the threats. There legitimately needs to be a threat assessment. We need it documented because honestly, we don't get enough protection as members of Congress right now. Unless you're one of the top people that sit in Congress, you don't have protection for you while people are sending you death threats or sending death threats to our colleagues or sending people over and assaulting our staffers in district. It would probably be helpful if we had the documentation to back this up and maybe be able to show House admin or anybody else that is interested in extending the funds that are needed to actually keep us safe so that we can do our jobs. Because right now, it seems like these guys feel like they have a license to harass and kill and do whatever. And honestly, this emboldenment, it's not just them. It's everybody else. So I think that we should be digging in, and I think that it should be able to inform whether or not we have other parameters that we can explore to keep all members of Congress safe, whether you're a Democrat or a Republican. I'll yield to the ranker.
Look, I'm sorry we couldn't have done this in just an objective summary of what we were going to do, but on the other hand, I think it's been a very fruitful and creative session today, and thank you for your indulgence, Mr. Chairman.
Mr. Van Drew.
30 seconds. I agree with you. We need more protection. I don't agree with all the stuff you say, but believe it or not, people on this side of the aisle, I've had some horrific death threats. Actually, some people are in jail, really bad folks. We do need more protection. It's something that leadership should deal with for all the members.
Question occurs,
I yield back.
Question occurs on the amendment from the gentlelady from California. All those in favor say aye.
Aye.
Those opposed? No, no. The ruling, in the opinion of the chair, the noes have it. Roll call being requested. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman?
You said what?
Mr. Grothman votes no.
Oh, I know, but I'm just saying.
Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Gill votes no. Mr. Baumgardner? Mr. Baumgardner votes no. Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Ms. Crockett votes aye. Mr. Biggs votes no. Mr. Fry votes no.
Clerk will report.
One more vote.
Mr. Chairman, there are 12 ayes and 17 noes.
The amendment is not adopted. The question is now on adopting the overall oversight plan. All those in favor say aye. Aye. Those opposed, no. No. Opinion of the chairs, the ayes have it and the plan is adopted. Members will have 2 days to submit views.
Can we have a recorded vote on that?
Recorded vote being requested. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Yes. Mr. Issa votes yes. Mr. Biggs? Yes. Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes aye. Mr. Nels? Mr. Moore? Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt?
Thanks, guys.
Mr. Gill? Mr. Gill votes aye. Mr. Baumgartner? Mr. Baumgartner votes aye. Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Ms. Crockett votes no.
Clerk will report. Mr. Liu?
Mr. Liu, you are not recorded. Mr. Liu votes no.
Clerk will report.
Mr. Chairman, there are 17 ayes and 13 noes.
The ayes have it, and the plan is adopted. Members will have 2 days to submit views without objection. Staff is authorized to make technical and conforming changes. That concludes the committee's business for today. The meeting is adjourned.
Thank you for tuning into the live show. You know what time it is. It is your boy Genesis. It is currently 12:08 p.m. and today's date is the 1st of March, 2025. How are you doing? Today is Saturday. The year is moving really fast, ladies and gentlemen. All right. Another hearing, DOGE.
And terrorism. For years, criminal networks have stolen personal information from the
our debt is also growing. Welcome, everyone. Without objection, the chair may declare a recess at any time. Also, for today's hearing, Chairman Comer and Ranking Member Connolly will each be recognized for 1 minute after me and the Ranking Member provide our opening statements. I recognize myself for the purpose of making an opening statement. Good morning. Today, we begin the first hearing on the Oversight Subcommittee on DOGE. This committee will be laser focused on bringing full transparency to waste, fraud, and abuse within the federal government and presenting the plans to fix the tremendous problems we expose. We as a country are $36 trillion in debt. That is such a stunning amount of money. It's absolutely staggering to even comprehend how we as a people, we as a country found ourselves here. This is not a Democrat problem. This is not a Republican problem. This is an American problem. To make it clear for everyone, not only are we $36 trillion in debt, but the compounding interest on our debt is also growing out of control. Even if we decided to defund the entire federal government, we cannot escape our debt and the compounding interest owed on our debt, which grows bigger and bigger every year. In 2025, interest payments are projected to be $952 billion, which is more than our entire military budget. In 2026, it will be $1 trillion. And by 2035, $1.8 trillion. Over the next decade, total interest payments are projected to be $13.8 trillion. These interest payments don't serve a single American. They don't build a bridge, a road, provide disaster relief, or fund a single part of the behemoth that is the federal government. These interest payments pay our masters who own our debt, and the American people are in debt slavery to everyone who owns our debt. Our crippling national debt and massively growing interest on our debt will destroy us, not destroy one political party or the other. It will destroy all of us together. It drives inflation, making life unaffordable for Americans struggling to financially survive. It is crippling small businesses struggling to be successful. Our massively growing debt and interest are the chains and shackles harnessed to every American and their children and every generation to come. But first, let us be brutally honest about how this massive debt came to be in the first place. It came from Congress and from elected presidential administrations. And I believe enslaving our nation in debt is one of the biggest betrayals against the American people by its own elected government. The American people's anger over this betrayal is what gave birth to the concept of DOGE, the Department of Government Efficiency. In fact, DOGE became a major part of President Trump's campaign and led to his overwhelming victory in November. Every day, Americans go to work. They run businesses. They have to earn their paycheck. No one guarantees it. And if they don't do a good job, they get fired. They also have to pay their bills, credit card debts, balance their checkbooks, and scrap and save every penny they can in order to plan for that rainy day and hopefully retirement one day. Private businesses only survive on hard-earned income by serving their customers so well that their customers pay them for the services and products they consume. If that business fails, its employees lose their jobs and paychecks, and the owners lose their business and everything they risked along with it. Many go bankrupt in this process and lose everything. No one bails them out. They only survive by excellent customer service and smart financial management. This is the real world that most Americans live, work, and survive in every day. This is the pursuit of happiness, and this is how you pursue the American dream. However, the federal government, government employees, and unelected bureaucrats do not live by the same rules as the great American people and private businesses. The federal government's income is the American people's hard-earned tax dollars, their literal blood, sweat, and tears. And taxes are collected by law at gunpoint. Don't pay your taxes and you go to jail. The federal government does not have to provide excellent customer service to earn its income. It takes your money whether you like it or not. And federal employees receive their paycheck no matter what. Whether veterans receive their benefits or not, whether your mail shows up or not, and whether your tax dollars are used to help Americans in need or sent to foreign countries, for foreign people, for foreign causes. No matter how bad the federal government fails the American people, it still takes your money. It still pays its own federal employees, and it never, ever goes out of business. There are no consequences for bad customer service, total failure, and for enslaving the American people against their will in the ever-growing and future all-consuming national debt. Congress has a dismal approval rating that ranges between 12 and 20%. I don't blame the American people one bit for their sentiment and disgust. The American people will be watching this committee and how we tackle one of the biggest problems of our time. While we are a committee made up of the opposite far-reaching corners of Congress, we were each elected to serve and represent the American people and how their hard-earned tax dollars are spent. We as Republicans and Democrats can still hold tightly to our beliefs, but we are going to have to let go of funding them in order to save our sinking ship. This is not a time for political theater and partisan attacks. The American people are watching. The legislative branch can't sit on the sidelines. In this subcommittee, we will fight the war on waste shoulder to shoulder with President Trump, Elon Musk, and the DOGE team. This week, we turn our attention to improper payments by the federal government, including in Medicaid and Medicare. I'm looking forward to what we find out and how to solve this crisis. I now yield to the ranking member, Ms. Stansbury, for her opening statement.
All right. Well, good morning, everyone. Thank you, Madam Chair, and welcome to the very first subcommittee on government efficiency. As was said, this committee is tasked under the Oversight Committee with ensuring that the government and the vital services that it provides, from healthcare to national security, actually work for the American people. And this is certainly a topic that we have worked on for many, many years here in the Oversight Committee, in which I personally have worked on as a former civil servant who worked at the Office of Management and Budget. And in fact, for anyone who has ever worked on these issues, you know that there is ample ground for bipartisan work to make the government work better for the American people and to ensure that it operates in a more efficient manner. And in fact, all of us here on the Democratic side are ready to roll up our sleeves and to get to work. And just last week, I had the opportunity to sit down with the chairwoman and to discuss these very issues and opportunities to work across the aisle. And like the chairwoman who shared some of her background with me, I grew up in a working family. I grew up working for small mom and pop family businesses and understand the necessity of balancing the books, making sure we can deliver, and fiscal responsibility. And that's why today's hearing is focused on making sure that the federal government is doing what it's supposed to and digging into the more than $236 billion in improper payments that we see going out the door every single year. And we need to get to the bottom of that. And we need to make sure that we're putting into place rigorous oversight and controls to prevent fraud and abuse, and of course, to go after bad actors. And that is why myself and the Oversight Ranking Member Connolly and other Democratic members of the committee sent a set of bipartisan ideas that we'd like to work on together that would root out waste, fraud, and abuse and modernize and streamline how our agencies deliver vital programs for the American people. These are programs that are important for our seniors and our families and healthcare and the education system. And we need bipartisan solutions to get across the finish line. And we've been trying over the last several years to get these ideas out of this committee, but unfortunately, the committee's priorities have been elsewhere under the current majority. So I hope we can fix that this Congress. But we can't just sit here today and pretend like everything is normal and that this is just another hearing on government efficiency. I mean, all you have to do is look across this room and see that it is not a normal hearing. Because while we're sitting here, Donald Trump and Elon Musk are recklessly and illegally dismantling the federal government, shuttering federal agencies, firing federal workers, withholding funds vital to the safety and well-being of our communities, and hacking our sensitive data systems. In fact, while we were here discussing government waste on the House floor yesterday, Elon Musk was standing behind the Resolute desk in the Oval Office with the president, and the administration was making emergency court appeals to try to unlock his team's access to the Treasury payment system, which they claim they are using to study improper payments, which is the topic of this hearing. But here's the thing. The Treasury payment system, which includes Social Security information and bank accounts for millions of Americans and data that's critical to national security and the operation of the U.S. government, and payments that go out the door annually equal to almost a fifth of the U.S. economy, is not where the payment decisions are made, because that happens inside the agencies that are currently being dismantled. And the people who actually investigate waste, fraud, and abuse at these agencies are the inspector generals, who Donald Trump fired his first week in office in a midnight massacre. So we have to ask ourselves, what is really going on here? Why did Republicans block Elon Musk from appearing before this very committee last week? Why is the administration so eager to allow Elon Musk and his hackers to have access to proprietary and private information in the Treasury payment systems? Why are our colleagues across the aisle shielding them as they are clearly breaking the law? And why is the vice president trying to rewrite the US Constitution by tweet and undermine the judiciary. So obviously, we're in the Oversight Committee and we have a lot of questions, and so do the American people, especially while our colleagues across the aisle are trying to scoop up the savings from the dismantling of these agencies to pay for the largest permanent tax break in American history for billionaires and the folks that they're helping on their side of the aisle. So let me close by saying this directly to Mr. Elon Musk. We are well aware that you are eager to engage with members of Congress on social media, but we're not here to play. If you have serious desire to engage in democracy and transparency, we welcome you to the Oversight Committee. Come and testify in front of the American people under oath, because we want to know what you're up to. So if you're interested in talking to us, then please join us here in the People's House in the House of Representatives. And
He's
with
too
that, I
busy
yield
for
back.
that. He's too busy for that.
The gentlelady yields. President Trump signed an executive order on his first day in office called Establishing and Implementing the President's Department of Government Efficiency. The EO simply renamed an office in the White House that was actually established by President Obama in 2014 called the U.S. Digital Service. President Trump can have Elon Musk into his Oval Office anytime he likes. I now recognize the chairman of the Oversight Committee, Chairman James Comer.
Well, thank you, Chairwoman Green, for holding today's hearing to launch a war on waste. President Trump won an electoral landslide with a clear mandate from the American people to eliminate Washington waste and stop the theft of American tax dollars. And he is delivering on his promise. President Trump has empowered Elon Musk and DOGE to conduct a government-wide audit to identify solutions to curb waste and protect tax dollars. That's exactly what the mission of this committee is supposed to be. And I'm glad that my colleagues on the other side of the aisle have found a newfound interest in waste, fraud, and abuse. With a staggering $37 trillion in national debt, we have no time to lose. A key place to start is improper payments. Since 2003, the government has lost $2.7 trillion because of improper payments. Fraudsters, organized criminals, hostile foreign actors, and even government employees have siphoned money away from those who truly qualify for assistance. For years, Republicans and Democrats on the Oversight Committee have condemned this waste. But now that DOGE is taking real action, Democrats are choosing to defend the bureaucracy and status quo instead of standing up for the American people. I want to thank Chairwoman Green for holding this very important hearing, not only to expose the problems, but to find solutions. We stand with President Trump and DOGE in the fight to end waste, fraud, and abuse in Washington. With that, I yield back to Subcommittee Chairwoman Green, and congratulations again, Chairwoman, on holding this first hearing of the DOGE Subcommittee.
Thank you, Mr. Chairman. The gentleman yields back. I now recognize the ranking member on Oversight, Mr. Connolly.
Excuse me. Thank you, Madam Chair. And thank you for having this first hearing on DOGE. Improper payments is not a new subject. I remember joining Steve Lynch and then Todd Platts, Republican member from Pennsylvania, in my freshman year, talking about improper payments. At that time, improper payments were in the range of $35 billion a year. They're now in the range of $280 billion a year. And times 10, we could cut almost $3 trillion from the debt if we addressed improper payments in a deliberative way, which GAO has called for in the high-risk category for years. We can also, secondly, enforce the tax code. It's estimated that at least $500 billion a year is left on the table uncollected but owed because of lack of resources in the IRS. Again, times 10 is $5 trillion over a decade. And finally, we can modernize federal IT systems, which we've championed for years on this committee. We know that legacy systems alone could save hundreds of millions of dollars a year in operating and maintenance costs. So if we want to be serious about it, let's be serious about it. But the way not to do it is to fire the people charged with the remit of waste, fraud, and abuse, namely inspectors general. President Trump has already now fired 19, including most recently the USAID inspector general, who dared to warn that we could lose $500 million of food aid because it's in warehouses not being moved because of the funding freeze that was imposed in AID. That's a cost we need to avoid. And for doing his job, that IG was fired. If we want to be serious, we've got to have objective, neutral inspectors general who are monitoring government waste, fraud, and abuse and expenditures. And I think you would find Democrats more than willing partners in that kind of enterprise if we're going to be serious. But a wrecking crew, a wrecking crane, a wrecking ball is not going to do it. And we're not going to support that approach to waste, fraud, and abuse in the federal government. I yield back. Thank you.
The gentleman yields. The President of the United States has the prerogative to fire anyone that has overseen $36 trillion in debt, enslaving the American people, and rightfully so. I'm pleased to welcome today's expert panel of witnesses who each bring unique experience and expertise that will be valuable to today's discussion. I'd first like to welcome Mr. Haywood Talcove, the Chief Executive Officer for Government at LexisNexis Risk Solutions, Inc. His commitment to customers' needs allows LexisNexis to develop market-leading solutions that have enabled customers to stop fraud, waste, and abuse. Next, we have Mr. Stuart Whitson, the Senior Director of Federal Affairs at the Foundation of Government Accountability. Stuart was previously a special agent in the FBI, a U.S. Army veteran, and now spends his time at FGA advocating to improve welfare, the workforce, and other policy. Next, we have Ms. Dawn Royal, a certified welfare fraud investigator in the state of Wyoming and director for the United Council of Welfare Fraud. She advocates for investigating and preventing fraud of government benefits and has done so over the past 16 years. Finally, we have Mr. Dylan Hetler-Goddett, the Director of Government Affairs at the Project on Government Oversight. Dylan leads advocacy efforts and policy reforms to a wide range of good governance. I thank each of our witnesses for being here today, and I look forward to your testimony. Pursuant to Committee Rule 9G, the witnesses will please stand and raise their right hand. Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let the record show that the witnesses answered in the affirmative. Thank you. You may take a seat. We appreciate you being here today and look forward to your testimony. Let me remind the witnesses that we have read your written statement and it will appear in full in the hearing record. Please limit your oral statement to 5 minutes. As a reminder, please press the button on the microphone in front of you so that it is on and the members can hear you. When you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow. When the red light comes on, your 5 minutes have expired, and we would ask that you please wrap up. I now recognize Mr. Talcove for his opening statement.
Chairwoman Green, Ranking Member Stansberry, and distinguished members of the committee. For over a decade, a silent war has been waged against American taxpayers, not with bombs or guns, but with data and technology. Outdated government systems permit criminals to access unlimited sums of money. During the pandemic, they stole $1 trillion. 70% of those dollars went overseas. Shockingly, it's just not criminals exploiting the system. It's the flawed system itself acting as the accomplice. If left unchecked, the U.S. government will continue to lead the world in funding cyber criminals. This is a data and technology problem, and it demands a data-driven response. Criminal syndicates have turned benefit programs into their personal ATM machines, exploiting those in need who wait months for benefits that may never come. These ruthless crooks use our money to fund child trafficking, disperse drugs in our communities, and terrorism. For years, criminal networks have stolen personal information from the public and private sector. They exploit real identities to manipulate antiquated government systems, siphoning off billions in taxpayers' hard-earned money. We continue to pay benefits to deceased and incarcerated individuals, direct money to bad actors flagged on the do not pay list, and overlook duplicate Social Security numbers by not following best practices. During the pandemic, a simple cross-check of PPP loan recipients against IRS records would have exposed massive fraud and prevented payments to transnational criminals who sold their quote-unquote sauce on the dark web. To stop this, we must reclaim control of our systems, not just from the criminal syndicates, but the flawed systems enabling them. Smarter technology, data, and identity verification are not optional. They are necessities to protect taxpayers and ensure aid reaches those who truly need it. Now, the use of AI is fundamentally changing society, but in the hands of criminals, it has become a weapon. Lawbreakers are now using it to supercharge their war on taxpayers. They use AI to create fake identity documents that pass biometric verifications. Bots flood portals with thousands of fraudulent claims per second, and deep fakes that mimic real applicants bypass the outdated NIST 863 standards from 2017. Honest and deserving people seeking access to government benefits suffer through endless application forms that are nearly impossible to navigate. But criminals from Russia, China, and Romania gain access with ease. The private sector has fraud rates below 3%. Meanwhile, the public sector operates at a 20% fraud rate. The solution is clear. It's already used every day to protect consumers. You seamlessly interact with your bank through an app that verifies your identity in milliseconds. There's no excuse for the government to lag if we do the following. Number one, implement identity verification on the front end. Criminals should never receive a dime. Eliminate self-certification. No more honor system for billion-dollar programs. And continuous auditing. Keep verifying because criminals never stop adapting. Pay and chase does not work. Of the $250 billion stolen in pandemic unemployment fraud, less than $5 billion has been recovered. The idea in government that you cannot have speed and security is fiction. I urge Congress to consider making the following legislative changes. Number one, update the 1974 Privacy Act to allow for data sharing and matching. Number two, fund a budget for fraud prevention in each appropriation bill. The USDA spends 1/20th of 1% on fraud prevention. Mandate that individuals caught stealing from entitlement programs pay hefty fines and are removed from the program permanently. And finally, eliminate broad-based categorical eligibility. This committee has a choice: continue losing this war against criminal cartels and nation states, or fight back and save $1 trillion annually. Fraud prevention is not benefit prevention. It's the key to ensuring that every dollar reaches those who truly need it. Hardworking Americans rely on these programs not just to survive, but to build better lives for their families. When criminals exploit the system, they just don't steal money, they steal opportunities. Stopping fraud isn't about denying benefits, it's about protecting them. This crime has two victims. The first are the taxpayers, and the second are those seeking benefits. The fraudsters, cartels, and criminal syndicates are watching this hearing, I'm sure of it. It's time to show them that America will not fund its own destruction. Thank you, and I look forward to your questions.
Thank you, Mr. Talcove. I now recognize Ms. Royal for her opening statement.
Good morning, Chairwoman Green, Ranking Member Stansberry, and committee members. My name is Dawn Royal. I'm a certified welfare fraud investigator, two-term past president, and a current director of the United Council on Welfare Fraud. The United Council on Welfare Fraud is a national professional organization dedicated to protecting the integrity in our nation's public assistance programs. We are the only national organization singularly focused on the detection, prevention, and prosecution of welfare fraud. For too long, agency bureaucrats have pitted citizens' access to welfare programs against the integrity of those programs. Access versus integrity should never be an either-or dichotomy. We can all agree that access to public assistance is crucial. America's citizens should not be hungry or deprived of medical care because of their inability to pay. However, making sure vulnerable citizens have access to these welfare programs should not mean that we simply turn a blind eye to integrity. We do not pursue the prevention, detection, and prosecution of if we do not pursue the prevention, detection, and prosecution of fraud, taxpayers become the victims as the welfare programs become slush funds for anyone wanting to supplement their income with SNAP benefits, absolve themselves from the financial responsibility of medical bills, and using Medicaid to further taxpayer exploitation by taking advantage of cash assistance, energy assistance, childcare, and other social welfare programs. One example of a welfare fraud is a case that I investigated that was criminally prosecuted last year. The applicant mother failed to disclose her children's father as well as his employment and income on multiple applications she submitted for Medicaid, SNAP, and low-income energy assistance. The co-defendant father worked a steady job, earning a six-figure salary, and provided an enviable lifestyle for his family, including vacations, luxury vehicles, snowmobiles, motorhomes, lavish gifts, including one from the wife to the husband, which was a $1,200 bottle of bourbon. Evidence we presented at trial included a candidate registration forms filed by the defendant father when he ran for town council and later mayor of the town where he declared he lived at the same address provided by his wife on her public assistance programs. This was a case of greed, but it emphasizes how easy it was for these criminals to make false statements on applications in order to receive benefits from multiple programs that they were never eligible for. I could spend the rest of my day providing countless examples of how taxpayer-funded programs are exploited, and the message would be the same. Investigators continue to be hamstrung by antiquated regulations, conflicting directives from federal agencies, and the lack of access to technology. Sadly, investigators have also found themselves at odds with the career bureaucrats who recite watered-down facts about fraud in order to promote their political agendas. Specifically, we can look to the career bureaucrats who have historically claimed that the fraud rate in SNAP is less than 1%. The disregard for the value of integrity is evidenced by the less than 1/20th of 1% of the SNAP budget spent on the prevention, detection, and prosecution of fraud. As part of Medicaid unwinding debacle, the bureaucrats specifically directed states that they, and I quote, cannot recover or recoup the cost of services from a beneficiary, even if they have been found after an administrative hearing or criminal proceeding to have committed Medicaid beneficiary fraud or abuse, end quote. Sadly, it is already apparent that career bureaucrats are not being totally transparent as they attempt to protect spending and broken programs. We fail to understand how mitigating the rampant fraud in Medicaid, SNAP, and other welfare programs stands up or strengthens the welfare programs. Fact is, the opposite is true. Ignoring fraud and gaslighting fraud statistics erodes the very foundations of the programs that are essential to their future viability. There are things this committee can do to help the investigators fighting the war on fraud. Number one, eliminate self-attestation in the application process for all programs. Number two, funding for technology that includes identity verification tools that will help prevent fraud. The current pay and chase model is not sustainable. Number three, immediately implement the National Accuracy Clearinghouse, the NAC, that will provide data to states to prevent duplicate participation in all of the social welfare programs. And four, allocate direct funding with mandates restricting the use of the funding to the prevention, detection, and prosecution of fraud. In closing, we're at a crossroads. Those of us who have firsthand knowledge of the degree in which public welfare programs are being attacked know that reform is absolutely necessary. Reform to the recipient application process, the billing process in Medicaid, and how SNAP benefits are processed, and how providers and retailers are authorized. We thank you for the opportunity for UCOF to participate in this hearing. We feel that the investigators who are on the front lines fighting the daily battle against the war on fraud need to be at the table and participating in the development of action plans that will make a difference in protecting the programs and defending the taxpayers.
Thank you, Ms. Royal. I now recognize Mr. Whitson for his opening statement.
Chairwoman Green, Ranking Member Stansbury, members of the subcommittee, thank you for the opportunity to testify today. On the campaign trail, President Trump promised to take on the bloated bureaucracy in D.C., rebuild trust in the DOJ and the FBI, crack down on waste, fraud, and abuse, and restore common sense. And on day one, he started delivering on those promises with a wave of executive orders and the official launch of DOGE, which he, of course, tasked Elon Musk to lead. Already, DOGE efforts have brought to the public's attention countless examples of wasteful spending, including $59 million paid to luxury hotels in New York to house illegal immigrants, $1.5 million to advance DEI in Serbia's workplaces, $32,000 for a transgender comic book in Peru. The list goes on. But rather than applauding the work of DOGE, the left has launched a coordinated campaign to try to demonize Mr. Musk with the hope of shifting focus away from the disastrous waste, fraud, and abuse that occurred on Biden's watch. But guess what? It's not working. Because no matter what political party people hail from, the vast majority of Americans agree that $10 million worth of food funneled to Al-Qaeda was probably not the best use of taxpayer money. But there's another source, a key source of wasteful spending that DOGE and the subcommittee should set their sights on next, and that's Medicaid waste and fraud. While initially meant as a program for the truly needy, Medicaid is bloated into a massive welfare program for millions of able-bodied adults lured into the trap of government dependency. And as Medicaid has grown, so too has mismanagement. Today, more than $1 in $5 spent on Medicaid is improper. In Medicaid alone, fraud and mismanagement is on track to cost U.S. taxpayers, get this, more than $1 trillion over the next 10 years. When it comes to the problem of improper payments, the Medicaid program is the biggest culprit, encompassing nearly 1/3 of all federal improper payments. And more than 80% of Medicaid improper payments are due to one thing: eligibility errors. If Congress wants to help President Trump address wasteful spending, then targeting eligibility errors in Medicaid should be one of your top priorities. Bottom line, to address this challenge, Congress can take 3 decisive actions. So first, Congress can strengthen the Medicaid program through legislative action. That would include repealing Biden's disastrous Medicaid streamlining rule, which ties the hands of states trying to remove ineligible enrollees. You can and should do this through reconciliation, and it will produce $164 billion in savings if you do. You can also strengthen verification requirements to ensure only eligible individuals receive benefits and ensure a nationwide NAC is implemented without delay. Second thing Congress can do is help President Trump's DOGE effort by ensuring that entrenched partisan bureaucrats don't stand in the way of reform. So Musk and his DOGE team have already found hundreds of billions of dollars funneled into wasteful, fraudulent, and flat out insane projects. But they've only scratched the surface. If this much fraud has been exposed in just a few weeks, imagine what else is buried under layers of red tape and government excuses. But guess what? All of these insane projects have one thing in common. They were all approved and funded by unelected bureaucrats. And these and other entrenched bureaucrats are already pledging to fight against President Trump's efforts to improve government accountability and efficiency. Personnel is policy. And without competent staff to faithfully execute the president's agenda, the DOGE project will fail. And this is where Congress can help. Congress can support the president in carrying out his DOGE effort by making all executive branch employees at will, codifying the president's authority to fire unproductive or insubordinate agency employees as needed. At the same time, Congress can grant the president authority to permanently eliminate vacant positions and consolidate non-essential positions across agencies and departments to help promote efficiency and put the right people in the right seat. The third thing, Congress can make President Trump's DOGE cost-cutting and deregulatory reforms permanent by passing the REINS Act. And so there's only one big problem with the DOGE effort. Most of its work can be undone by a future president with a stroke of a pen. To make President Trump's DOGE reforms permanent, Congress must act. And the best way to do this is to pass the REINS Act. This would return Article 1 budgetary power of the purse to Congress while promoting deregulation. It would also help lock in the DOGE reforms and cement President Trump's legacy as the most consequential deregulatory and cost-cutting president in U.S. history. The American people are watching. It's time for Congress to act. Thank you, and I look forward to your questions.
Thank you, Mr. Whitson. I now recognize Mr. Hetler Goddett for his opening statement.
Thank you, Chairwoman Green, Ranking Member Stansberry, and members of the subcommittee. My name is Dylan Hetler Goddett, and I am the Director of Government Affairs at the Project on Government Oversight, or POGO. I appreciate the opportunity to be with you here today to talk about the critical issue of bringing more accountability and transparency to federal spending, including rooting out waste, fraud, and abuse. Since our founding in 1981, POGO has been focused on promoting more accountability and rooting out wasteful spending and promoting efficiency, especially at the Department of Defense. We have a long and well-established track record on these issues, and we take a back when it comes to promoting a better and more effective government, which necessarily includes a federal government that is a good and responsible steward of taxpayer dollars. Let's take a moment to pause here to talk a little bit about terms that we're going to hear a lot today and the difference between them. Waste is different from fraud. Fraud is different from abuse, and abuse is different from both. When we talk about improper payments, they are a subset of those other three categories. But that doesn't tell us the whole picture either. Sometimes improper payments are a function of bad record keeping. Sometimes they are a function of outdated information technology systems. Sometimes they come about through human error, and sometimes they come about through negligence. There are a variety of reasons why improper payments happen. It just simply is not the case that improper payments are only a function of bad people doing bad things with bad intent. That doesn't mean we shouldn't focus on trying to mitigate improper payments, and that certainly doesn't mean that the American people should not be concerned with how their tax dollars are used. The good news is that there are some time-tested solutions and tools to help mitigate these problems. For example, when we think about the independence of inspectors general, we're talking about a resource that is extraordinarily valuable to the American people. In fiscal year 2023 alone, inspectors general identified over $93 billion worth of potential savings to taxpayers. Whistleblowers are also an incredible resource to the American taxpayer. Through the IRS's whistleblower program alone, billions of dollars have been recouped from tax cheats since the inception of that program in 2007. Whistleblowers have also played an instrumental role in helping the Department of Justice pursue False Claims Act cases that have resulted in billions of dollars in reclaims settlement costs. It seemed to me that if an administration were serious about wanting to root out waste, fraud, and abuse, they would support and resource whistleblowers and inspectors general. They would not demonize them, and they would certainly not fire them en masse in an unlawful midnight purge. There are other reforms we can think about too, reforms that are more technical, but just as important. Key statutes such as the Federal Funding Accountability and Transparency Act, the Data Act, and critical platforms like usaspending.gov were really important improvements and innovations when they came about, but they are in need of overhaul and reform. Currently, the status quo is that we have an extraordinarily hard time tracking federal dollars from end to end. This is due in large part to a broken chain of data collection, of reporting information, and the ability to monitor and track in real time what is happening with federal dollars. This informational black hole is where a lot of impropriety happens. It's where waste, fraud, and abuse live. And yes, this is where improper payments often happen. But more importantly, we also don't have a good, clear, and consistent way of understanding what is happening with tax dollars at the end point. What is the impact that we're having? What is the return on investment that we're having? We now have an annual budget of close to $7 trillion a year. We can't say with any degree of clarity and consistency what we're getting for all of that money. We have some more good news, though. There are bipartisan efforts, and there have been for years, to try and clean up this situation. We at POGO have had the privilege and pleasure of working on some of those initiatives. We were a part of the Federal Taxpayers' Right to Know Act being passed into law just a couple of years ago, which created for the very first time a program inventory of all the programs in the federal government, and that would be available to the public. We have worked with a member of this very committee, the House Oversight and Accountability Committee, to introduce a piece of legislation that would bring more transparency to federal subaward reporting. We have supported and endorsed multiple pieces of legislation that take direct aim at the improper payment issue. We also have additional ideas that don't yet have congressional champions. One proposal is to clean up and modernize and standardize the award descriptions that are available in USA Spending to make them more useful and relevant. We have another proposal to harmonize the amount of data and information we collect between contract spending and non-contract spending. We stand ready, willing, and able to work with anybody who wants to work with us on these common sense solutions. Lastly, I want to put in a quick word for Congress.
Yeah.
And specifically, I want to
The gentleman's time has expired.
Apologies.
Yes.
I can't see the flashing light.
That's okay. Thank you, Mr. Hetler. Got it. We appreciate your testimony. I now recognize myself for 5 minutes of questions. I'd like to thank our witnesses today for your testimonies and the suggestions that you have brought before this committee. I'd also like to thank Chairman Comer for this opportunity to chair the historic Oversight Subcommittee on DOGE. Americans are shocked to learn that $2.7 trillion of their hard-earned tax dollars have been stolen or wasted in improper payments since 2003. You see, in the private sector, companies can't continue to run if they keep employees that allow waste and abuse with their resources. But that has continued for decades here in the federal government. Mr. Talcove, do private sector companies have a lower rate of improper payments than the federal government?
Yes, the fraud rate, that the criminals are taking advantage of in the public sector is around 20%. In the private sector, it's around 3%. And it's really because the tools that are used in the private sector aren't used in the public sector. Front-end identity verification, self-certification, and then finally making sure that individuals are who they say they are. If we start using these tools, you will see the fraud rate go down dramatically, because for the most part, this fraud isn't taking place by real individuals. It's individuals whose identities have been stolen on the dark web. They use that information pretending to be somebody else. And because of the antiquated systems, processes, and technologies in place in government programs, they're able to steal at scale.
Right. So, Mr. Talcove, we would say that private companies that pretty much have to exist on a 20% profit rate, they're not allowed. They can't continue to be successful if they were to allow their customers' data to be stolen like that and used by criminals. However, the federal government, who can continue printing checks and continue in operation, never fixes its problems because it can't be forced to go out of business. Would you agree with that? Yes or no?
Yes. One of the things I noticed during COVID was the criminals learned that government was the mark because it never runs out of money.
Mm-hmm.
And they focus on it at scale. And then the likelihood of getting caught is virtually zero.
I think it's outrageous for Americans to know that their identity can be stolen and then used for child trafficking, drug trafficking, and terrorism, like you stated in your opening statement. Ms. Royal, your testimony states that many programs operate under essentially an honor system in which applicants need not verify their identity, income, residency, or other key eligibility factors. You call this a trust everyone instead of a trust by verify approach. Does this mean the federal government in some states are giving out billions of dollars to individuals without verifying who they are or whether they meet program eligibility requirements?
Yes, ma'am, that's correct.
That's outrageous. Do states have enough incentive to prevent fraud and to recover improper payments?
No, and in fact, states are hesitant to spend their state dollars to protect federal dollars.
Would greater investment in program integrity efforts yield a positive return for taxpayers?
Yes, it could easily be self-funding.
Amazing. Mr. Whitson, your testimony states that both the Biden and Obama administrations issued rules and guidance that made it harder for states to verify eligibility for Medicaid. You say that repealing Biden's Medicaid streamlining rule would save $164 billion over 10 years because the rule restricts eligibility verification that states can perform. Can you explain why this rule is so costly?
Yeah, so the rule does a number of things, but for instance, it prohibits states from verifying eligibility more than once a year. So for non-disabled folks to just go in and look and say, hey, are you still eligible for the program? It says you are forbidden from doing that any more often than once a year. And so obviously people's lives change, and so they may become ineligible. And so it's designed to keep them on the program. Another thing, it prohibits in-person or phone interviews to verify their identity. So people apply for it, and then the person on the other end says, oh, I just want to call and make sure this is a real person, not someone in another country or whatever. The rule prohibits that. And so there's a number of other provisions. It also opens a lengthy reconsideration periods. And this is where illegal immigrants are able to obtain the benefits. And so basically it says once you get, these benefits, you can't interfere with it for a 90-day period or longer. And so there's a number of horrible things. But.
So we can't verify if someone is illegal or legal receiving benefits. Just to correct that, yes or no?
You have to wait a state has to wait at least 90 days. And actually what we're seeing is it's led some states to wait as long as 13 years. And so on the program.
Unbelievable. My time has expired. Thank you very much. I now recognize Mr. Lynch from Massachusetts for 5 minutes.
Thank you very much, Madam Chair. First of all, let me congratulate you and also Ms. Stansbury on your new positions. And I want to thank the witnesses for your testimony. We've already heard some good ideas about how to work together. And Mr. Hetler-Gaudette, I, for one, would be most open to working with POGO and trying to work on some of the legislative ideas that you have to actually get at some of this waste, fraud, and abuse. Since this is my first opportunity to speak in this new subcommittee as the representative for the 8th Congressional District in Massachusetts, I want to first of all make clear that my primary purpose in seeking appointment to this subcommittee is for the singular and sacred purpose to defend our democracy, which I believe is under attack in this country, and to uphold my oath to support and defend the Constitution against those who might secretly or openly seek its destruction. Make no mistake, this is a moment for representative democracy. This is a test of our resolve. In the coming days and weeks, we will all get to decide whether we stand with a couple of billionaires who, despite their own financial successes, still harbor such grievances in their hearts that after all that democracy has provided to them, they remain animated by the desire to dismantle this democratic government and to punch down at some of the weakest and most vulnerable in our society. Two men who clearly understand that the easiest way to incite large numbers of people is to use social media to exploit the dynamic forces of hatred and fear. Madam Chair, if we're going after waste, fraud, and abuse, let's start with abuse. Abuse of power. As of yesterday, there were 55 lawsuits under consideration by the federal courts across our nation as a result of Elon Musk's and President Trump's unlawful acts. Many of those lawsuits have already been sustained by the federal district courts and orders have been rendered to undo those unlawful acts. But this is just the beginning, and Congress has an important role to play, and I, for one, look forward to that opportunity. This is a moment of great consequence for our country and for our democracy, and I remain grateful to the good people of the 8th Congressional District of Massachusetts who sent me here. Mr. Hetler-Gaudette, again, happy to join you on some of your efforts. POGO has worked very closely with our IG community. Is that right? The inspectors generals?
Yeah, that's correct, Congressman.
I know your work is very much similar to what we ask our inspectors generals to undertake. I want to ask you, what do you think? So in the most recent report from the inspector generals, and this is the Council of the Inspector Generals, a nonpartisan group on integrity and efficiency in government, they identified more than $93 billion in potential savings. So the first thing that President Trump did coming into office was to fire 17 agency inspectors general. What can you tell us from POGO's standpoint? What does that do to our ability to identify and root out waste, fraud, and abuse?
Thank you, Congressman. I would say, to put it simply, it completely undermines our ability to root out waste, fraud, and abuse. Inspector General exists for essentially one purpose, and they were originally created in the immediate aftermath of Watergate. And I think you all probably do not need me to give you a history lesson at all on what happened in the Watergate era. There's a reason they were created at that time, because there was a lot of waste, fraud, and abuse happening, and there were not cops on the beat that were internal, that were independent, that were situated in agencies to be able to find these things and expose them and do something about them. That's what Inspector General exists to do. So it's completely anathema to, I'd say anathema to any stated mission to find cost savings and to root out waste, fraud, and abuse, to fire Inspector General and to undermine them. It makes no sense. Those two things do not add up.
Thank you very much. The firings that occurred on the when President Trump came to office included the Special Inspector General for Afghan Reconstruction, Mr. Sopko. I actually did over 20 trips to Afghanistan working with him. He actually uncovered $4 billion in savings in rooting out American taxpayer waste being conducted in Afghanistan. The IG at the Department of Defense, the agency.
The gentleman's time has expired.
Okay. Thank you, Madam Chair. I yield back. Thank you.
Okay,
Appreciate
thank you.
that. Thank you.
I now recognize the gentleman from Texas, Mr. Cloud.
Thank you, Madam Chair. For far too long, DC politicians have gotten away with measuring their personal value and worth by how much of other people's money they give away. And for far too long, they self-righteously have opined that the spending was for altruistic purposes given out of care and compassion. For far too long, they've been more concerned with looking like they cared than having enough care and concern to actually do the due diligence to ensure that the tax dollars were being used wisely and effectively. And for far too long, those of us who've worked to uncover waste, fraud, and abuse have had to deal with what amounts to an unconstitutional fourth branch of permanent bureaucracy that has too often worked to ignore, obfuscate, delay, and frustrate our efforts to bring transparency and oversight. Over the last few weeks, the DOGE effort has begun to uncover not only how massive the waste, fraud, and abuse is, but also the extent at which DC politicians and too many obstinate bureaucrats have coordinated to create what is essentially the largest money laundering scheme in history. And while Americans have been working to make ends meet, they have been using taxpayer dollars to fund unnecessary, egregious, and even evil things here at home and around the world. Thankfully, in DOGE, we have a president bringing the leadership needed and a focused effort, along with the talent, technology, tools, and transparency to this waste, fraud, and abuse. And to those who would stand opposed to this effort, I would just point out, while it's understandable to find waste, fraud, and abuse that has grown and metastasized in this government even over decades, certainly accelerated over the last few years, to continue to protect it is corruption. I want to thank the chair for beginning this war on waste on this side of Pennsylvania Avenue and bringing together this committee. This effort is so important as we work to relieve the Americans, people of this burden of waste, fraud, and abuse. Mr. Talco, you mentioned in your written statement and talked about it in your statement at the beginning that this waste, fraud, and abuse is a national security threat. And certainly one of the challenges facing us that is a national security threat is our fiscal situation. And so we have got to find ways to find savings to the American people in order to bring confidence to the bond markets, to put our country on a fiscal footing, and to reverse the curse, so to speak, that we are placing on our children and our grandchildren. You mentioned a couple threats, though. You mentioned internal threats. You said that these cases involve government employees, individuals entrusted with administering benefits who, instead of using their positions to approve fraudulent claims, override security controls, or even sell sensitive claimant information for profit. Now, this is not every federal employee for sure, but within the context of people who are trying to give their best effort, we have an internal threat. But you also mentioned transnational fraud rings, terrorist organizations, nation states, North Korea, nuclear weapons programs funded by our tax dollars, China, Nigeria, Iran, Romania, Russia, not our friends necessarily that are being funded by taxpayer dollars. Could you give us some examples of how this is happening?
God, yeah. So when you think about what happened during the pandemic, $1 trillion was stolen 70% of that money went overseas. And I can give you some examples. In a Western state, they had more people applying for unemployment insurance benefits than they had individuals over 18. The people that were stealing the money from Romania were using it to facilitate other fraud schemes that include fentanyl, that include doing things to impact our democracy. On the insider threat, right, the first thing you have to say, and my dad was a public servant, is 99% of people that work in the public sector are honest, hardworking individuals. But there are some, and what you need is data and technology to root that out. There were examples during the pandemic. There were some examples even of last week where people got into the Medicaid system in a Western state and stole $50 million in less than 4 months. So you have to have these controls in place, right? These aren't individuals stealing, Mr. Cloud. These are organized criminal groups, both domestic and transnational.
That, as you mentioned, taxpayers are being forced to fund the demise of our own country. Mr. Whitson, I wanted to ask you, because there's a lot of talk about reconciliation right now. You mentioned Medicaid and what could be done to bring a pretty substantial amount of savings, and this is without affecting those who truly need Medicaid and for what the purpose of the program was extended for. Now,
The gentleman's time has expired.
hopefully,
Does the witness want to answer the question?
No,
Just
only to
quickly.
say that, yes, there's a tremendous amount of savings that can be found from the streamlining rule, but also work requirements in the program is another big area that can be done in reconciliation. And that's could save a significant amount as well, $241 billion in federal spending over 10 years.
thank you.
Thank you.
Thank you, Madam Chair.
You're welcome. I now recognize the gentleman from California, Mr. Garcia.
Well, thank you. Thank you to all of our witnesses for being here. And I want to just start off by making something clear. I think we're all here to fight against the lies, the corruptions, and the attacks on our social safety net. Now, we should in no way be cooperating with House Republicans who want to shut down the Department of Education and destroy Medicare and Medicaid. And we should not stand by as the richest man on the planet gives himself and his companies huge tax cuts while the American people get absolutely nothing. Now, I find it ironic, of course, that our chairwoman, Congresswoman Green, is in charge of running this committee. Now, in the last Congress, Chairwoman Green literally showed a dick pic in our Oversight congressional hearing. So I thought I'd bring one as well. Now, this, of course, we know is President Elon Musk. He's also the world's richest man. He was the biggest political donor in the last election. He has billions of dollars in conflicts of interest. And we know that he is leading a power grab, also abided by and encouraged by Donald Trump and, of course, the chairwoman, Congresswoman Green. But I also want to run through what DOGE actually is going to do. It's a demolition plan that's going to run through our government. DOGE is trying to abolish the Department of Education. That means opportunities denied to kids. It means you're ripping away opportunities for children with disabilities who are dependent on this money. You're also halting medical research, which is also critical, which we have to also stop. The idea that we're going to eliminate or destroy the Department of National Institutes of Health, NIH, is crazy. Let's talk about the Department of Labor. We're talking about protections for working people across this country, where people can actually complain about abuses their companies are making against them and their coworkers. Workers are now going to be in danger. Let's also talk about the Consumer Financial Protection Bureau, another huge issue for us. Think about the scammers and fraudsters that will be empowered across this country because Elon Musk wants, essentially, these companies have more power over consumers and over people across this country. Look at the Centers for Disease and the Centers for Medicare and Medicaid Services. That is actually what's being discussed partly today. Healthcare, we're talking about being denied to millions of poor people, working class people across this country. And now, of course, they're on to their largest target, the U.S. Social Security Administration. We're talking about the destruction of the actual social safety net in this country. We know that 1 in 5 Americans collect Social Security, seniors, disabled people. This entire plan is about hurting the American social safety net and destroying our institutions. And it's important that we actually call out what is happening at this subcommittee. This is not about working with the richest man on the planet. This is actually about empowering. This committee wants to empower the richest person in the world to hurt people so they can take all of this money that they so-called want to save and then give it to themselves, their companies, and their billionaire friends. That is the attack that is happening in this committee and across this country, and it's important that we call it out. We also know, of course, that Elon Musk is sending his unqualified DOGE staff to carry out this agenda across all these agencies. And in some cases, actually teenage staffers. No accountability, no experience, and problematic records. They're trying to rob you, and they're probably a minor. Thank you, and I yield back.
The gentleman yields, and I now recognize the gentleman from South Carolina, Mr. Timmons, for 5 minutes.
Thank you, Madam Chair. I find it sad that my colleagues across the aisle can't take this seriously. We have $36 trillion in debt. We run an annual almost $2 trillion deficit. When I got elected 6 years ago, we had $21 trillion in debt. So in 6 years, we've added over $15 trillion to the debt. And guess what? President Trump ran on fixing this problem. President Trump told the American people he would right the ship financially. And he said during the campaign that Elon Musk was going to be the person to lead this charge. The man that has turned business after business around. He's the richest man on the planet because he succeeds at his endeavors. And that's why President Trump has appointed him the head of this effort. This is a very serious problem. And it's incredibly hypocritical that my colleagues across the aisle are complaining about this because Joe Biden signed his name and wanted the American people to believe that he had the ability to forgive $250 billion with a signature. Guess what? Supreme Court ruled he did not. That's our system of checks and balances. The president, Biden, he clearly was experiencing cognitive decline. He didn't even have the ability to be charged with a crime as determined by his own Department of Justice. But he signs his name and he thinks it gives $250 billion away, redistributes taxpayer dollars. It's just crazy that we can't come together to address the greatest national security threat facing this country, our debt. Now to the task at hand, Medicaid fraud. Mr. Talcove, if we implement enhanced identity verification and enhanced income verification, what will happen? How much money will we save?
You'll save hundreds of billions of dollars. Identity verification, elimination of self-certification, and monitoring beneficiaries will prevent these transnational criminal groups from accessing those systems at scale so legitimate people who need the benefits can get them in a timely fashion.
So we're going to get actual benefits to people, to American citizens that are in need faster, because if you do it electronically through web-based, like they did in Missouri, where the pilot program saved almost 20% of Medicaid dollars. So all we have to do is adopt what has already been proven in Missouri, and we'll save 20%. To the people out there listening, we spend almost $900 billion every year on Medicaid. And if 20% of that is saved, that's almost $200 billion. We got a $1.8 trillion annual deficit. We just knocked off $200 billion. Let's keep this train going. The fact that the Democrats are filing lawsuit after lawsuit to impede the efforts of President Trump to right our fiscal ship is unforgivable. It's unforgivable. Mr. Talcove, you talked about pandemic fraud. I have a bill that would cause the IRS to share data with the Small Business Administration and the FBI and the Department of Justice that would show that you were ineligible for PPP loans and you got them. So I think that would save probably $100 billion. Do you think that we should go back and take money away from people that fraudulently got COVID money?
Yeah. During the pandemic, the PPP program was a virtual buffet for fraudsters. And it was because of that 1974 Privacy Act, where data sharing and matching is virtually impossible. Congress needs to change that.
But we can do it retroactively. We can do it retroactively. We can find the people that stole this money, hold them accountable, probably get some of the money back. So I already have that bill filed. That bill, I think, would probably get $100 billion. So now we got enhanced identity verification, enhanced income verification that has been proven in Missouri. It does work. So I'm working on that bill. We're going to drop it soon. That's $200 billion. There's a competition in Congress. I think we should have a competition on this committee. I got $300 billion in savings proposed. We got to all pull our weight because we have such a massive problem right now. But I would just ask my colleagues across the aisle to get out of the way if you don't want to help. If you don't want to help right the fiscal ship in this country, get out of the way. Stop filing lawsuit after lawsuit. We do not have the financial ability to continue down this path. And we're going to save this country with or without you. You can kick and scream all the way, or you can get out of the way. I prefer the former. Thank you, Madam Chair.
The gentleman yields. I now recognize the gentleman from Texas, Mr. Kassar.
This subcommittee is supposedly about looking into waste, fraud, and abuse. So I'd like to start talking about independent inspector generals who are supposed to be looking into waste, fraud, and abuse. Mr. Talcove, do you know how many inspector generals at agencies that were investigating Elon Musk's companies have been fired by the Trump-Musk administration?
No.
It is 5. Ms. Royal, the inspector general at the Department of Labor had 17 open investigations into Tesla and SpaceX. Do you know what the Trump-Musk administration did to that inspector general?
No.
They fired him. And I think y'all know. Mr. Whitson, the inspector general of the Department of Transportation was investigating Tesla. Do you know what the Trump-Musk administration did to that inspector general?
No.
They were fired. The Department of Defense's inspector general was looking into SpaceX. Mr. Hedler, do you know what the Trump-Musk administration did to that inspector general?
I believe he was fired.
Thank you. I think everybody on the panel knows what the answer to these questions were. The U.S. Department of Agriculture Inspector General was investigating Musk's Neuralink. Mr. Talcove, now I'll ask you again under oath, do you know what Mr. Trump did to that inspector general that was looking into one of Musk's companies?
No.
He was fired. The inspector general at the EPA was repeatedly taking on Tesla. Mr. Hedler, since it seems that you're answering the questions that everyone knows the answer to, do you know what the Trump-Musk administration did to that inspector general?
I believe he was also fired.
Also fired. At least 5 inspector generals that were looking into Elon Musk's companies were fired by the Trump-Musk administration. These inspector generals who are independent, protected by law, they are the people that find the waste, fraud, and abuse and found many of the cases of waste, fraud, and abuse that have been brought up today, fired because they were looking into Elon Musk. At the NLRB, the National Labor Relations Board, which is supposed to protect workers from getting their unions busted by folks like Elon Musk, made functionally broken by the so-called Department of Government Efficiency that really is the Department of Government Efficiency for Elon Musk, not for you. They are trying to shut down the Department of Education, the Department of Labor. You know what Elon Musk doesn't seem to be looking into? His own contracts. Again, I'll ask you, Mr. Talcove, do you know how much money a day Mr. Musk will receive from the federal government for his contracts?
No.
The answer is $8 million a day. Just last year, Elon Musk was promised $3 billion from close to 100 contracts with the federal government. Ms. Royal, do you know how much the average person in this country who survives on Social Security, one of our seniors who's worked their entire life, about how much they have to survive on a day?
I do not.
$65 a day. We're not looking into Elon Musk's $8 million a day. This subcommittee, chaired by Marjorie Taylor Greene and the House Republicans, is looking into your grandmother's $65 a day. Let me be clear. I think we would all support taxpayer savings, look into money we might needlessly send to billionaires and big corporations, find taxpayer savings, and send it back to your hardworking family. But instead, what House Republicans and the Trump-Musk administration want to do is they want to look into your kids' lunch money, your kids' teacher's salary, into your grandparents' Social Security. They want to take that money and give it out in billionaire tax cuts. And they're talking about that in committee tomorrow, in budget committee tomorrow. They just released their plan. So let me be clear. When Republicans talk about government efficiency in this Congress, they're not looking into billionaires who don't pay their taxes. They're not looking into billionaires who get rich off of government contracts. They're not looking into Elon Musk firing watchdogs who are supposed to keep him accountable. They're looking at cutting your public schools. They're going straight for your Social Security. They're coming straight for cancer research. They're coming straight for the Department of Education. They're not looking at big tech. They're not looking at big pharma because those people fund their campaigns. If this committee were serious about rooting out waste from our federal government, then today's whole hearing would be about how Musk and Donald Trump are firing the independent watchdogs who've done this work for decades. Instead, my Republican colleagues' actual goal on this committee is to distract from Trump and from Musk's corrupt war on accountability. This will not be a subcommittee dedicated to making government efficient for everyday people. It's about helping Elon Musk and Donald Trump be as efficient as possible and robbing our government and handing out our government services to the rich. So this seems that this subcommittee is just
The gentleman's
like
time
the
has
agency it's named
expired.
after,
The gentleman's
sham.
time has expired.
a total sham.
The American people are $36 trillion in debt. It certainly seems reasonable that someone has been fired. I now recognize the gentleman from Tennessee.
You're going to put us
Mr.
further in debt
Burchett.
with your billionaire
You're
tax
not
cuts.
recognized. Mr. Burchett, you're recognized for 5 minutes.
Thank you, Chair Lady. The gravy train for a lot of these folks, it's been on biscuit wheels and it's about to run off the dadgum tracks, and it's about time. Could you imagine standing up here and defending waste, fraud, and abuse? But I think that's what we're seeing. When people squeal and don't ask questions, I think it shows the American public what the heck's going on. And that little gravy train is getting ready to run out. The spigot is getting ready to be turned off. Mr. Talcove, that's correct how you say your name, brother?
Yes, sir.
All right. How can the federal government improve identity verification for these entitlement programs?
Yeah, it's doing what the private sector does every single day, whether you use your bank, you go to Amazon, using those tools and moving away from some of the dated compliance standards that the federal government uses. NIST IAL 863, 2017, before there was anything called deepfakes and generative AI tools.
Also, I was informed that PayPal has never been, they've never been able to crack into that and steal people's vital information. Are they using those systems that you would be favorable towards that government seems to be shying away from?
Yes, sir.
And describe that, how that works.
They're systems that are based on encryption. They use technology and they use data to validate you are who you say you are. The people that are stealing right now, I believe a lot of them are actually ghosts from China, Russia, Nigeria, and Romania.
I read a report today that North Korea was involved in this, in some of that as well.
They are.
And those people are our enemies. Again, they'll hate us for free. We don't have to give them taxpayer money. And are there loopholes that can be closed to avoid these improper payments? And I wish you'd describe those to me.
Right. The biggest, most important thing, particularly in the benefit program space, is the use of self-certification. As Mr. Timmons noted, the state of Missouri is using a solution called Steady IQ to validate wages and wealth. You cannot allow individuals to provide the information based upon what they think. It has to be based on what you know, and that will stop the ghosts from using people's identities to steal money from U.S. taxpayers.
How much money do you calculate is wasted due to waste, fraud, and abuse in the entitlement programs each year?
Yeah, my number right now between federal, state, and local government is you can save $1 trillion a year by simply putting in front-end identity verification, eliminating self-certification, and monitoring the back end of the programs that are providing the benefits. Those three things.
You said you could eliminate that, but there are others you feel like some more low-hanging fruit?
I would start with those three things because they're simple. That'll take that 20% fraud rate that you're seeing in the public sector down below 5%.
Chair Lady, I would suggest that we adopt Mr. Timmons' legislation and get that out of the committee as fast as possible. What actions also could Congress take to fix these problems quickly?
Yeah, I think the first thing is updating and redoing the 1974 Privacy Act. That is virtually impossible to do data matching. It's very difficult to have data shared. And when you look back at the pandemic, data sharing and data matching would have stopped probably 50% of the $1 trillion that was stolen from taxpayers.
Any of y'all like to add anything to that?
Congressman, I would just add that rather than accepting self-attestation, that states should have to be required to actually verify people's identities. And here's the key part: before they get enrolled, they shouldn't get enrolled and then eventually come down later on down the road.
It's amazing to me. I have a doctor's appointment back in Knoxville, and the verification process is very extensive. It's more so than the federal government requires for any of this. What type of computer systems are these agencies using, and do they need updating?
They're using very dated technology, but they're also burdened. I look at the USDA, 6.2 million words in a 10,000-page document that shows how to implement the rules of the program. Nobody can figure that out. So one of the things that I think has to happen is the simplification of these processes and systems, and then just use the technology that we use every day in the private sector.
Okay. Thank y'all so much for being
The
here.
gentleman's time has expired.
Thank you, Chair Lady.
I now recognize the gentlewoman from Texas, Ms. Crockett, for 5 minutes.
Thank you, Madam Chair. And Mr. Talcove, I'm just going to go ahead and pick up where you left off really quickly. Just to be clear, the upgrades that you're talking about as it relates to our data processes, these aren't things that would be free, are they? They would cost some kind of money. Not looking for a number, but they will cost, correct?
Some are free and some would cost money.
Okay. All right. So I just want to leave it there because we've had a number of these hearings. So I do want to be clear, before the Trump administration came in, this committee did exist in the form of the Oversight Committee, and our task is to root out waste, fraud, and abuse. In that vein, we had a number of hearings, at least last term. I can't speak for any other term as I'm only in my sophomore term. And we dealt with improper payments. And interestingly enough, our chairwoman, who is so passionate about this today, she missed every single one of those improper payment hearings. But just to be clear, I was there. So I don't want anyone to believe that Democrats just come to work and don't plan to do work. In fact, I'm trying to figure out exactly what it is that the Republicans believe our job is, because right now they have relinquished their constitutional duties over to an unelected bureaucrat, someone who no one went out to vote for. And absolutely, he is occupying the Oval Office, as we saw yesterday. And that is a first for me, to see someone occupying the Oval Office who's never actually been elected to the Oval Office and actually answering more questions than the person that allegedly got elected. But for whatever reason, this is the first time we're having a DOGE subcommittee hearing, and that guy's not here. Instead, we have y'all. So I do want to thank you for coming. But I will say this, it's also interesting to me that in the first few days of DOGE existing, we know that they are trying to get rid of the Department of Education, USAID, Consumer Financial Protection Bureau. They're laying off FAA workers. They are going after the FDA, the CDC, the HHS, the FBI agents, and they're talking about getting rid of FEMA. And they brought y'all in. And I am going to say that I actually was shocked that there was only one person that seemed like he was an overt Trumper as you laid out your opening remarks, because I anticipated that at least one of y'all would say, yes, what Elon is doing is exactly what we would prescribe. But instead, I will applaud you because you actually were focused. You talked about what the American people are looking for us to do. We've actually consistently on this side of the aisle promoted this idea of making investments into technology so that we can do things such as, say, look at the Department of Defense. The Department of Defense that takes up approximately 50% of our discretionary income. or our discretionary spending, approximately 50% goes to Department of Defense. Department of Defense has not been able to pass an audit in the last 6 audits, and we're not talking about pennies. I understand that we want everything to be perfect, and if we could get all waste, fraud, and abuse out, that would be fantastic. But let me talk about the big numbers. The big numbers are on that side. When we look at, say, our entire workforce, our federal workforce, as we're trying to somehow fire all of them, they don't even make up a total of 5%. It's even less than that when we look at our budget. But let's talk about defense. That just happens to be the same side of the ledger that Mr. Musk gets the vast majority of his money from. In fact, at the same time that they were unlawfully, and we will stay in court, because on this side, we believe in law and order. We believe in, I mean, a number of us are actually lawyers, but nevertheless, we understand the Constitution. We believe in that as well. And so there's things such as, impoundment, right? Because as Mr. Whitson said, he said, we need to return the power of the purse to Congress. It never left. According to the Constitution, that's where it's at. Now, I know that people are confused right now because for whatever reason, we had a guy that went in, and you talk about people invading our data. Listen, people said that they were upset about TikTok, but I'm upset about the guy that runs Twitter, who for sure is doing nefarious things, because I don't understand, if you are trying to conduct audits and figure out where the waste, fraud, and abuse is, I don't know why you would go to some tech guy. In fact, it was only techies that were sitting there at inauguration. We didn't have auditors. I would welcome auditors to come in and do forensic audits. In fact, he sat there in the Oval Office yesterday and he admitted that he was lying, and he was using his propaganda machine to do it when he said that we sent millions of dollars to Gaza for condoms. That was a lie. So let me tell you something.
The gentlelady's time has expired.
It's time for
the
us
gentlelady's
to do our
time
job
has expired.
and rein in this rogue actor known
The gentlelady's
as Elon
time
Musk.
has expired. I now recognize the gentleman from Missouri, Mr. Burleson.
Thank you, Madam Chair. I just want to speak frankly at first to the American people. We're nearing $37 trillion in national debt. What does that mean? That means that each and every U.S. taxpayer owes over $323,000. Okay, what does that mean? That means when the EPIC, which is the Economic Policy Innovation Center, says we have 18 trillion left. That's it, 18 trillion left to take out, and we're spending $2 trillion in debt every year. Folks, we're at the precipice of a debt, we're like a debt cycle. We are literally at a point in which the dollar will be worth nothing. What does that mean? And we know Social Security goes bankrupt in 8 years, right? Medicare goes bankrupt in 10 years. And then 15 years from now, the dollar is completely devalued and worth nothing. So what does that mean? That means your pension, the money in your bank, your savings is nothing. It's worthless. So what are we doing? We're trying to save this country. We're trying to save your pensions. We're trying to save your bank accounts. We're trying to save this country for the next generation. And it would be nice if we had help. I think that I would hate to be in the Democratic Party right now because you're in a really bad bind. You're having to defend all of this crazy spending, all of this crazy waste. So how do you do it? You do ad hominem attacks. You attack the messenger. Oh, Elon Musk, right? He's rich. He must be evil, right? That's the attacks. Really, you can't do any better than that, right? Let's talk on the policy. On the policy, help us. We're trying to save this country. This is what, and Elon Musk, who's making no money doing this, is trying to save this country. Why? Because he has invested in the United States of America more than anybody, right? So I think that we should embrace it. In fact, not a single company, governor of any state would ever turn down Elon Musk and his team of DOGE from coming in and providing free services to right the course and financially in any state or organization. It's ridiculous that we would demonize someone that loves this country so much. Mr. Whitman, the formation of agencies via the executive action is not new, right? The formation of DOGE is not new. Can are you familiar with any other previous presidencies where they've formed organizations like DOGE via executive action?
Yeah, so actually the agency that DOGE is occupying is one that was created in a previous administration. So it is something that happens routinely. But I don't know if that answers your question.
Yeah, there's been the Office of Budget Management was created, Environmental Protection Agency was created, the U.S. Digital Service, which is now DOGE, was created all by executive order, right?
And actually one other I'd add is USAID was originally created through an executive order by President Kennedy and then later formalized.
And then, Madam Chair, I have a video I would like to end with that just let's review if we could cue that to remind, and I want to remind my Democratic friends at a point in which you once had the majority of the American people on your side. This is what your party believed in.
This report tells us how to cut waste, cut red tape, streamline the bureaucracy, change procurement rules, change the personnel rules, and create a government that works better and costs less.
I've read it, and where it says the president should, the president will.
Among the 800 recommendations, eliminating 12% of the federal workforce, merging some government agencies like the FBI, the DEA, and the Bureau of Alcohol, Tobacco, and Firearms, closing hundreds of government offices outside Washington.
From the day I took office, one of the commitments that I made to the American people was that we would do a better job here in Washington in rooting out wasteful spending. We thought that it was entirely appropriate for our governments and our agencies to try to root out waste, large and small, in a systematic way. It means cutting some programs that I think are worthy, but we may not be able to afford right now. A lot of the action is in Congress and legislative, but in the meantime, we don't need to wait for Congress in order to do something about wasteful spending that's out there. We haven't seen as much action out of Congress as we'd like, and that's why we launched on our own initiative the campaign to cut waste. And we're going to keep on finding every possible way that we can do that, even if Congress is not acting. There you go.
I think it speaks for itself. My time has expired.
The gentleman's time has expired. Thank you. I now yield to the gentlewoman from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you. Our Republican colleagues and the Trump administration continue to demonize our friends and neighbors who work for the federal government and swear an oath to protect the Constitution and serve the public. Thousands of civilian federal employees have given their lives in the line of duty for their country. The administration seems intent on dismantling much of the federal government in violation of the Constitution, statutes, and regulations. And our Republican colleagues are letting them do it. They want to gut the nonpartisan civil service and to convert a significant portion of the remaining civil service into political appointees. Depriving the federal government of employees' expertise and experience will harm the services that the government provides to all Americans. Mr. Hetler-Garlett, the administration is attempting to cause a mass exodus from our federal workforce. Will this increase or decrease waste, fraud, and abuse?
Thank you, Delegate Norton. I think it's pretty clear that chaos is not the friend of efficiency. If you undermine the very functionality of the government, you are not going to make it more efficient. You're going to make it worse. And it's going to cost even more money to recoup or to fix things that go wrong in the interim. So again, I mentioned earlier that if you care about waste, fraud, and abuse, firing Inspector General doesn't add up. I think if you care about government being more efficient, intentionally creating chaos is the opposite of that.
Well, Mr. Hetler-Garlett, do federal employees operate without oversight or rules and regulations?
No, absolutely not. They are governed by plenty of rules and regulations. And when there are independent inspector general at the agency they're supposed to be at, they also have a cop on the beat making sure that they do so.
I want to highlight some stories demonstrating exactly the kinds of federal workers the administration is trying to force out. How about Chris Mark at the Department of Labor, whose pioneering work on mine safety has reduced minor safety deaths from roof collapses to almost zero today? Or Jared Koopman at the Internal Revenue Service, who pioneered new methods for tracking criminal cybersecurity currency transactions that led to the rescue of 23 children from rape and assault, as well as the seizure of hundreds of millions of child abuse videos and 370 pedophile arrests. This work also prevented funding from going to terrorist groups. Or Ronald E. Walters, who manages the 155 national cemeteries around the country and tends to the resting places of almost 4 million veterans. These are just a few of the federal workers who serve Americans every day. The workers are wildland firefighters, border guards, doctors, nurses, food inspectors, air traffic controllers, and law enforcement that do their civic duty, often despite the fact that they could make such more in the private sector. Thank you, and I yield back.
The gentlelady yields. I now yield to the gentleman from Georgia, Mr. Jack.
Well, thank you very much. Thank you very much, Madam Chair. And I want to also thank you for convening this hearing. I think it's incredibly important. And I want to thank our witnesses for appearing before us today. Like another member of this committee, I too was once an employee of the Executive Office of the President. I worked in President Trump's White House from the very first to very last day of his first term, and I saw firsthand how entrenched and resistant the federal bureaucracy was to his agenda. So it's no surprise that today a few of my Democrat colleagues have continued that trend by using their time to bash Elon Musk instead of discussing ways to work together to advance a bipartisan cornerstone of President Trump's agenda, the mission to finally eliminate waste, fraud, and abuse. And I just took a rudimentary count of the Dems' testimony, or rather comments today, and I've got 27 mentions of Elon Musk and 3 mentions of waste. And I don't know if that's, in fact, the right count. Encourage anybody to fact check me, but I think it illuminates and illustrates one of the problems that we're facing, which is a lack of bipartisan effort to address these critical things that, waste, fraud, and abuse is something that should be bipartisan. The chair noted that in her opening remarks. Now, Madam Chair, you know how much I enjoy studying public opinion. So with your approval, I'd like to enter into the record the CBS News poll from this past weekend, conducted February 5th to 7th, 2025. And I'd also like to illuminate 2 findings. First, 70% of Americans, Democrats and Republicans included, believe President Trump is already doing the job that he was elected to, which is interesting because I have an article here from CNN from September 2024 that notes Trump says Elon Musk has agreed to lead proposed government efficiency commission as ex-president unveils new economic plans. So he is doing exactly what he said he would do by empowering his administration to root out waste, fraud, and abuse. And that's exactly what we're trying to do here today. I'd also like to note one interesting statistic from that. 62% of Americans want Democrats in Congress to work with us to advance the priorities that President Trump was elected to govern on. So I think those are 2 stats that I hope everyone pays attention to. But to ask questions of our witnesses, I'd first like to start with Mr. Talcove. One of the things that I found very interesting from your opening testimony is you talked, and I think you engaged with Mr. Burchett on the 1974 Privacy Act. And I had some interesting folks visit my office yesterday who noted that 1/3 of all prior authorizations are still done manually by phone, fax, or direct post mail. First off, I would love your comments on that, and I'd also like for you to expound upon some of the solutions that we can deliver to this Congress in modernizing that 1974 Privacy Act.
Yeah, these aren't people problems. These are technology problems. You can't process the number of individuals that are accessing our systems person by person. It just takes too much time. So by updating the 1974 Privacy Act and allowing for digital matching you would have very quickly realized that a large portion of the PPP loan funds were going to the wrong person. You would have been quickly able to match, and I think the number was 20% were on the do not pay list. You can't expect people to do what a machine, and especially AI, can do today.
Fair enough. Thank you very much for that. And if I can also ask Mr. Whitson, I think we share a common interest, which is to move departments and agencies outside of Washington, D.C. It's something that I campaigned on, something that I helped President Trump effectuate in his first administration. And I have to imagine that if we have departments and agencies outside of D.C., if we've got a workforce that's more reflective of the balance that America is, we at the same time too could potentially root out some of this waste, fraud, and abuse by enabling other Americans, other citizens of our country to help advance some of these issues. So would love your commentary on that before my time expires.
No, I think you're exactly right, Congressman Jack. And so I think, you'd save a lot of taxpayer money. So building a headquarters in downtown DC versus Huntsville, Alabama, you're going to be able to save a lot of money. Number two is you're actually going to make life better for the employees as well. So that's a point that's also missed a lot, but commuting into DC versus being able to go somewhere else where it's a better cost of living and things like that might be better for the folks. And then lastly, these areas where you set up a headquarters are going to be populated by people that live in the area to fill the rank and file of staff positions. And so if you plant these federal agency headquarters in the heart of any area that's overwhelmingly one party or the other, then you're going to naturally get that sway versus something that's more representative of the people as a whole.
Well, thank you very much, our witnesses. Mindful of my time, I want to finish before my time expires. I yield back to our chairwoman, Marjorie Taylor Greene.
Thank you.
And Chairwoman, I would like to ask for unanimous consent to enter something into the record.
So what is it?
It is a report from the Congressional Research Service, nonpartisan CRS, that lays out the rules and the law for firing inspectors general, which of course look into waste, fraud, and abuse. And
Without
that rule-
objection.
Thank you. And that rule requires for the law to be followed, for Congress to be notified with 30 days and a reason for firing inspectors general to give Congress a chance to overrule that. And that's the law. So thank you for entering that into the record.
Madam Chair.
Without objection, the materials Mr. Jack cited are also submitted for the record. I now recognize.
Apologies. And while we're on it, I'd also like to ask for unanimous consent to submit for the record 2 items. One is a statement from the AFL-CIO, Department of People who work for a living with views on working people to make the government work. And the second is a statement from the Center for Responsibility and Ethics in Washington on ways to combat waste, fraud, and abuse in the federal government.
Without objection, so ordered. I now recognize the gentlelady from New Mexico and ranking member Ms. Stansbury for 5 minutes.
All right. Well, thank you, Madam Chairwoman. And thank you once again to all of our witnesses for being here to testify. Thank you to my colleagues. We are going to have so much fun in this committee, this Congress. I actually appreciate the video that was shown just a few moments ago, because when I worked at the Office of Management and Budget, I actually worked on the waste EO that was referenced that President Obama signed. But there is one fundamental difference between the presidents and vice presidents that were shown on that video and what's happening today. And that is that they followed the law. So my colleagues across the aisle who are asking us to get out of the way and stop trying to block things in the courts, let me tell you, we do not work for an unelected billionaire like apparently this guy does. We work for the American people. And so if an unelected, unvetted individual private citizen is hacking our government systems, breaking the law, firing federal employees, dismantling statutorily created agencies, withholding funds, we are going to fight you in the courts. And I'm actually really sad that my dear friend, Mr. Burchett, left, because I want to talk about that gravy train on biscuit wheels that he just talked about, because that gravy train is not the federal workforce. It's the billionaires that are trying to hack that system right now, and which unfortunately my colleagues right now are working on a reconciliation deal to cut Medicaid, to cut Medicare, and use that money to give to tax breaks to their billionaire buddies. That is the gravy train that is actually going on here. But because this is the Oversight Committee, let's do a little bit of oversight. For the last several weeks, I've been talking to Treasury and OMB officials to try to get to the bottom of why Elon Musk and his team are trying to hack the Treasury payment system, because this is a completely nonpartisan system that literally just pays the bills of the federal government. So why are they so eager to hack this system? And I have to say that over the last several weeks, we have literally received thousands of calls in every single congressional office. In fact, we know that our friends across the aisle are also receiving these calls because this system pays the bills of the US government. It pays our soldiers. It pays for the work that we do overseas. It pays your Social Security benefits. It pays your tax refunds. So why is Elon Musk and his hackers trying to access that system? And why did a senior civil servant who had overseen this system for over 30 years get asked to stand down after a 25-year-old intern working for Elon Musk tried to get access to the code for that system? Now, thankfully, they were shut down in the court system, but Musk has installed, with the president's blessing, one of his Silicon Valley buddies, who I want to point out, in which the media has not paid a lot of attention to, is the CEO of a private IT company, including Citrix, that has millions of dollars in IT contracts with the federal government. And not only is he still operating as the installed DOGE person at Treasury, he's actively still the CEO of this private company. How is that even legal? Is it legal? I don't think it's legal, because the federal court is trying to shut this down. We also know that that 25-year-old software engineer, in violation of the court order, was actually given access to modify the code. So what is going on here? And why is this such a threat to the American people? Why are thousands of people calling us? It's because of the size and the significance of these payments, because it is an invasion of the privacy and security of the American people, because it could threaten our ability as a country if there was a default in the debt ceiling, and because it contains highly classified information that our foreign adversaries are trying to cyber attack us regularly for. So why is a private citizen being given access to this system? We know they're trying to shut down payments. They're trying to shut down agencies. What's next? Are they going to shut down your Social Security payments? We don't know, because they have no oversight, and Elon Musk will not come in front of this committee. And in fact, the Treasury folks are saying this is the biggest insider threat they've ever seen in the history of the agency. So we are sounding the alarm. And no matter how many executive orders that Donald Trump signs or how many tweets that the VP sends, you cannot rewrite the Constitution, and we are going to hold you to account. I yield back.
The gentlelady yields, and I now recognize, oh, yes.
I have 3 documents I want to submit for the record. The
What are
first document is the Constitution, Article 2. I would like to submit that for the record. That clearly spells out the president's authority. I would also like to submit for the record 5 U.S. Code 3161, the employment compensation of employees, which clearly spells out his authority to create DOGE. And then I want to submit for the record the executive order that Trump issued on January 20th of 2025, establishing DOGE officially.
Without objection, so ordered. I now recognize the gentleman from Texas, Mr. Gill, for 5 minutes.
Thank you, Madam Chair, and thank you for hosting this committee. If we've learned anything so far, it's that Republicans want to cut waste, fraud, and abuse from our federal government and save taxpayer dollars, and Democrats want to grandstand and play politics. We can see right now, even of the 6 Democrats on this committee, only 1 can even be bothered to stay for the duration of this hearing. All we've heard about for most of this hearing from the other side of the aisle is Elon Musk, Elon Musk, Elon Musk, unelected bureaucrat. And I'd like to ask if Democrats really care about unelected bureaucrats making decisions over our lives, where were they whenever their god Anthony Fauci was forcing vaccine and mask mandates on the American people for 4 years during the during the COVID crisis? Where were they whenever unelected Alejandro Mayorkas was facilitating the invasion of our country by illegal aliens who were murdering and raping and pillaging our people? Where were they whenever the Secretary of Education, unelected, Cardona, targeted states and schools and people who were disagreed with his view of the radical left's transgender ideology? Where were they whenever Gary Gensler, former chairman of the SEC, also unelected, was lawlessly thwarting the development of financial markets, particularly in the crypto space, by lawlessly pursuing regulation via enforcement? They were nowhere to be seen because they don't care, because all of those things benefited their side of the aisle at the expense of ours. And perhaps that's also why they don't seem to be very interested in rooting out improper payments from our federal government. If you wonder why so many people are cynical about American politics, this is it. This is exactly why. The reality is that Elon Musk serves as an employee of the president, and we were given a massive mandate to carry out what he's been doing. His job is to carry out the will of the American people as expressed through the executive. That's exactly how the Constitution is supposed to work. The Constitution did not create an unelected, unaccountable fourth branch of government in the administrative state. The American people know this. My colleague Brian Jack discussed some of the opinion polls recently. We are doing, and President Trump is doing, exactly what he was elected to do. And that's why he's polling at a 53% approval rating, higher than he was at any point during his first administration. Even Elon Musk and his DOGE efforts now are polling at a 49% approval rating, which, just to point out, is 16 points higher than President Biden was polling at whenever he finished his term in office. The Democrat Party has for decades systematically grown and weaponized the administrative state against the American people, and the American people have had enough of it. Right now, we're talking about $2.7 trillion in improper payments since 2003. We're uncovering what could be the biggest money laundering scandal in American history. And the other side of the aisle could care less. They have no concern about where this money went, to what entities it went, to what governments, to what people or groups. Nothing. All they want to talk about is Elon Musk incessantly. So it does make me wonder, if they don't care about where it's going, do they have an idea? Because what we've uncovered so far is that so much of the waste, fraud, and abuse of our federal government is actually funding their side of the aisle. It's funding media outlets that are running cover for Democrats routinely. The NPR, PBS, the BBC, Politico. It's going to fund left-wing NGOs that are facilitating the invasion of our country. It's going to fund left-wing transgender activism and sex changes all over the globe. This is money that's being used, taken from the American people and used against. I'm very excited to be on this committee. I'm excited to expose what's being going on. Thank you, Madam Chair. And with that, I yield.
The gentleman yields. In closing, I want to thank our witnesses again for their testimonies today. I now yield to the ranking member for closing remarks.
Thank you, Madam Chairwoman. Well, I never thought so many conspiracy theories and wild accusations could be wound into one 5-minute speech, but I appreciate my friends across the aisle. First of all, let's talk about this massive mandate that supposedly brought Donald Trump into office. Donald Trump did not run on putting an unelected billionaire in charge of dismantling the federal government. He ran on lowering prices for Americans. And I think it's interesting that while we're sitting here this morning, the top of the New York Times is reporting that inflation has risen unexpectedly as food and energy prices have soared. What's going on, guys? I thought you were going to tackle inflation and food and energy prices. Isn't that what the executive orders were supposed to do? Oh, wait. Or is dismantling diversity, equity, and inclusion in our federal agencies and putting an ideological agenda and trying to fire the federal workforce your actual agenda? Have you been too busy trying to actually address the fiscal health of this country? Because the numbers are telling us that you have. So let's be real about what's going on here. I also want to point out that literally, while we've been sitting here for the last almost 2 hours getting lectured on fiscal responsibility, literally the Republicans just released their plan to raise the debt limit while we were sitting here. And they want to raise it by $4 trillion. Okay, guys, like literally, I'm just like without words. Inflation is going up. You want to raise the debt ceiling by $4 trillion. You want to gut Medicare. You want to gut Medicaid. You're talking about going after Social Security after promising that you wouldn't. I mean, really, what the heck is going on here? We're not trying to take down Elon Musk as a businessman. This dude is literally breaking the law inside of the federal government. And for a party that is supposed to be the party of law and order, in quotes, I really do not see you holding him accountable and doing your most basic constitutional responsibility in the separation of powers. So I want to end where I started. We are the Oversight Committee. We are the people's house for the United States of America. We represent the American people. And so, Mr. Elon Musk, if you would like to appear in front of the Oversight Committee, you have been duly invited. Please come tell us what you're doing. Come testify in front of the American people. And please come hold yourself to account. With that, I yield back.
The gentlelady yields. I now recognize myself for closing remarks. President Trump was elected with a mandate to rein in unaccountable bureaucracy in Washington and to wage war on waste. I know that because I campaigned alongside him, and so did my colleagues. This hearing was the first battle of that war. And in the coming days, the subcommittee will release a report with legislative solutions to the problems we have identified here today. We aren't going to wait all the way until the end of this Congress. We're going to get to work immediately. The bureaucrats who have run Washington for decades are beyond the point of forgiveness. Their sheer incompetence and pure spite for the hardworking American people have resulted in total failure. The federal government has made over $2.7 trillion in improper payments since 2003. Including $236 billion in 2023 alone. Those are trillions of dollars that honest Americans have paid in taxes at gunpoint over the years. As we approach April 15th, Americans are once again preparing to do their taxes and fork over their unfair share of money it takes to run this country. And I have to tell you, the American people have not been getting their money's worth for a long time. Most improper payments in recent years were issued through 5 programs: Medicare, Medicaid, the Earned Income Tax Credit, Pandemic Unemployment Insurance, and the Paycheck Protection Program. But a total of 16 federal programs had improper payment rates of 10% or more in 2023. That includes SNAP, the federal food stamp program, which paid out $10 billion taxpayer dollars improperly. To get their arms around this problem, Elon Musk and the DOGE team went straight to the source. They went to the Treasury Department's Fiscal Service, which makes about 90% of the trillions in federal payments issued annually. The audit of these payment systems was long overdue. Treasury Secretary Scott Bessent gave DOGE employees working for the government read-only access to these systems so they could conduct that initial audit. That audit is already paying dividends. Musk learned that the databases federal agencies are supposed to check to prevent payments to fraudsters, crime rings, and dead people are not being kept up to date. Going forward, we are going to get more mileage out of these do not pay databases. That means fewer improper payments and less fraud and waste of taxpayer dollars. Despite this fraud that's already been revealed, a federal judge in New York issued a ruling last Friday that ran totally contrary to the will of the people. The judge blocked not only DOGE, but the Treasury Secretary himself from accessing his own agency's payment systems. That's absurd. Only career Treasury Department unelected bureaucrats can access the system, the judge ruled. This turns the Constitution on its head. We will hold this judge and others who try to stop the will of the people and their elected leaders accountable. As is written in the Federalist Papers, the judiciary has no influence over either the sword or the purse, no direction either of the strength or the wealth of the society. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm for the efficacy of its judgments. But the whole DC swamp is freaking out that the unelected officials from DOGE were allowed access to these systems. That makes no sense. Federal judges were not elected. The Treasury bureaucrats were not elected, and they have failed to fix the problem that is enabling American taxpayers to be robbed. So why not bring in skilled outside experts like private companies and private citizens who are successful in the real world to do everyday work that we need to get done here, like audits? Of course, federal payment systems are only one link in the improper payment chain. We need to look at other links in the chain. We need better front-end identify verification to screen out fraudsters, and we need to close eligibility loopholes. That means not letting applicants self-attest to their own eligibility. And it means ending categorical eligibility, which lets someone who fraudulently qualifies for one federal benefit automatically get other federal benefits. Finally, we need to better coordinate fraud prevention efforts between federal governments and the states. These are all issues that we will be taking a hard look at in this committee and coming up with solutions to, including legislation and referrals to committees of jurisdiction that will deliver for the American people. With that and without objection, all members have 5 legislative days within which to submit materials and additional written questions for the witnesses, which will be forwarded to the witnesses. If there is no further business without objection, the subcommittee stands adjourned.